Sottoatto Why the, because yesterday I have not taken any matter for the urgent motion. Why all the matter has been taken urgent? Who has given the instruction? No. See, yesterday how many matters were there in the list of the urgent motion? About 50, not more than that. I have taken these 14 matters. Correct. So what remains? 50 to 35. So if the 35, so how this matter gone? Add होने से नीचे क्यों जाएगा? ऊपर क्यों आएगा? That is the problem. एंड इतना इंक्रीज क्यों होता है अर्जेंट मोशन? हम तो कल कोई भी अर्जेंट मोशन में रखे नहीं है. इंक्रीज क्यों होता है? I henceforth I will come at 4:30, sit with you and will settle the list. You want that? I will sit with you in that table and settle the list. मैं देखता हूँ मेरे 40 से अर्जेंट मोशन कम ही नहीं हो रहा, जबकि मैं हर दिन 20-30 मैटर में अर्जेंट मोशन लेता हूँ. क्यों इतना मैटर आता है? आप तो मेरे को बताते नहीं है. मेरे को बताते हैं कितना मैसन ऑलरेडी है करके. आज पूरा लिस्ट मेरे ऑफिस में लेके आएंगे. अब नहीं होता है काम, मेरे को बता दीजिए. उल्टा सीधा काम मेरे साथ नहीं चलेगा. देन आप यू हैव टू फेस द कॉन्सिक्वेंस. और जो कॉन्सिक्वेंस होगा देन यू विल बी इन ट्रबल. Once I find anything and once I initiated any proceeding, then it will be difficult till the end. मैं बोलता नहीं हूँ, आप लोग अर्जेंट मोशन में अपने आप से लगा देते हैं. Those factors they will also allow urgent mentioning, but they are not in the list. I will recall on 2 occasions before the litigation, I had mentioned the matter. When I come back to find out what is the list number, it is not there in the list at all. Then, and I am sure the papers where they have written in new motion. That's why initially 2 days I faced problem. Then I dictated the date. And because it was an urgent, allowed mentioning as urgent mentioning. डेट जब मैंने डेट लिखता हूँ मेंशनिंग में आप नोट करते हैं डेट, तो क्यों नहीं आता है? व्हाई इट इज नॉट कमिंग इन द लिस्ट? आज आप दोनों जने आरजी के साथ मेरे ऑफिस में आएंगे 4:30 बजे. कम विद आरजी.
My matter, some precisions tomorrow, my lord.
Which matter?
Item 43 of today's list, my lord. I understand, my lord, cannot take the matter of today. Some precedence tomorrow, my lord.
Item number
43.
Item number 43 को लीगो कल रखिए. ये रिकॉर्ड ऑन ऑर्डर, otherwise they will not do. Item number 43. As per the request made by the learned counsel for the petitioner, let the matter be listed tomorrow under the heading urgent motion at serial number 1. Yes.
Urgent motion, my lord. The petitioner name listed in the 2002 and 2018 petitioner name listed in the 2002 and 2018 voter list, but in the 2025 voter list, his name did not appear because similar epic card number, another person of another assembly constituency is appearing. That is why they did not allow. 15th January is the last date for form fill up. Kindly, I have given notice to all and start the copy.
When you file the writ application,
my lord, they did not allow me to fill up the form.
When you file the writ application,
filed on 24th of December.
So
Lord, I have given notice that matter will be moved before this honorable court on 2nd. But matter appeared in the January monthly list as item number 475, and today item number is 493. Lordship, kindly 15 January is the last date.
15 January is the last date
for form fill up. Lordship, kindly, I have given notice to the chief electoral officer and others.
13 जनवरी में रखो. अंकल नोट लिख के हमको दो. list the matter, urgent motion on 13 January. Keep here.
Lordship, I will give notice again to all the respondents.
Keep here.
Get full to your Lordship.
Yes.
My lord, item number 156, my lord, I have on several occasions I have mentioned this matter and your lordship was kind enough to accommodate me on each and every occasion. But the matter is
What
going.
is the urgency?
My urgency is this, my lord, I cannot get loan because of the non-registration of my title deed. I have made payment, my lord, in 2005. I want to take loan. Bank has processed everything, but for the title deed, I cannot have the loan, my lord.
Where is
This
that? Where is the title deed?
My lord,
Where is your title deed?
title deed has not been registered by the authority itself.
Oh.
I have made entire payment on 2005. Repeatedly, I am going.
2005, you have made the payment. Now 2025, you are telling there is an urgency.
Well, everything has been done. They are not doing, and your lordship was pleased to accommodate me on all the occasions. But the matter is going down, my lord, again.
Done.
My lord, I have mentioned the
You
matter.
appoint a suitable officer here. I will do all the matters. This is the way I can tell in the open court.
I am very
My
sorry.
officers are not competent. The court cannot take all the things in the burden of the court itself.
That's right.
I am accommodating all the advocates, but my
Yes,
staffs are doing something mischiefs, or I don't know what they are doing. Either I have to resign from the post. I am incompetent to tackle with
No,
you.
my lord. It's not that, my lord. It's not. Your lordship is my kind enough to accommodate us, my
So
lord.
what can be done
That's true, my lord.
with these staffs?
We are paralytic also, my lord. My lord, every day client is saying, my lord.
If I will restart the proceeding, then
That's true, my lord.
all the persons will go out from the service.
That's true, my lord. And on every occasion, your lordship was kind enough to accommodate me, my lord.
That is the problem. I am accommodating, but after I seeing the list, I find that no list has been, which I have ordered, there is no list, and there is no matter listed in the list. And the matter which has been listed, that has not been moved before the court. How this matter is coming in the list, I don't know.
My lord, kindly, my lord, accommodate us, my lord.
अब प्रॉब्लम में आ जाएंगे, हम बता दिए हैं आपको ये सब लिस्ट कैसे आया, अपने मर्जी से करते हो, साहब तो देखते नहीं है। हाँ? हो नहीं सकते। Which matter?
My lord, 156, my lord.
156.
Of today's list, my lord.
तो रखो 21 तारीख को 21st
21st, my lord. Deeply obliged, my lord.
ले लो, लिख के हमको दो,
Deeply obliged.
मुझे दीजिए।
To be coffee.
Listed as urgent notice on 21st.
May I permit to mention a matter for hearing, madam?
Hearing?
Yes, madam.
Affidavit completed?
No, madam.
Then how the hearing can be done? Who is for the other side?
Other side government,
What is the year of the suit? Year of the writ application?
25.
So there is a direction of affidavit.
They are suffering, madam. My lord,
Is there is a direction of affidavit?
Yes, madam.
When the direction was passed?
Direction was passed on September
Huh?
September 2005.
September 2025.
25.
इसको to be mentioned में रखो.
My lord, may I have you?
To be mentioned on 8th January. दो यहाँ.
My lord, may I have your lordship's kind leave to mention this matter, my lord? My lord, your lordship remember.
8th January to be mentioned. Yes.
My lord, your lordship remember your lordship was very kind enough to hear this matter thrice by fixing the matter at 2 p.m. My lord, the matter relates to reservation relating to 100-point roster of a person with disabilities.
Correct,
Learned
correct.
Advocate General, my lord, took time. My lord, urgency was, that is why your lordship fixed it, that the recruitment process. My lord, now the interview 11-12 interview last phase is going on, and from second week of January 9-10. My lord, your lordship, on the last day, since it was just before the vacation and the advocate prayed for time, your lordship posted it under the heading and motion and request directed me. You mention and the matter will appear, my lord, at any time after the reopening. My lord, with notice, my lord, I am mentioning this is item number, my lord, 86 of today's list, my lord. Any day subject to your lordship's convenience.
When the interview is going to be held?
My lord, interview is going on. Phase-wise, subject-wise, interview is going on. Your lordship can accommodate any day. If we succeed, my lord, we will be.
15 January, urgent
Your
motion.
Lordship, may permit me to mention one matter, Your Lordship.
15th January, urgent motion.
My lord,
Yes.
Your Lordship, may permit me to mention one matter, item number 265, Your Lordship. I am a successful L1 bidder in the auction process, Your Lordship. Afterwards, without tendering any notice or any show cause notice, my tender was cancelled. Matter, I given to a notice in month of April. I given a demand notice and notice also, and filed the matter in July. But this is nothing hard, Your Lordship, even lying in a new motion, Your Lordship. Lying in a new motion, Your Lordship. Matter is still not hard, Your Lordship. Not hard yet.
Not heard it or not listed?
Not listed, Your Lordship. Item number 265, Your Lordship.
Yes. So what do you want now?
Your Lordship, matter will be infectious, Your Lordship, because the new
When
tender
the tender will be open?
tender will be open in usually in month of December, but the authority didn't give any notice, Your Lordship.
So whether your tender is cancelled,
Get
rejected?
rejected, Your Lordship, without giving any opportunity, Your Lordship. In
Without
a
giving an opportunity.
opportunity of hearing, Your Lordship, in a
There
tender.
is a law for giving an opportunity
The
for
NIT, Your
cancelling
Lordship,
the
in
tender?
NIT, Your Lordship, there is a specific.
No. Yes.
May I be permitted to mention this matter?
No.
This matter, High Court directed that all the chit fund companies' property should be attached by SEBI, and it has to be, auction, and the money will go to the depositors. Now, I am one of the successful bidders. I have purchased the land. Now, what is happening? The SEBI is writing to the state government, to the DM, that you give arrangement so that the property possession can be given to me. Now, state government is doing nothing and taking this chance. Unscrupulous persons, they are capturing the property. Now, I'm not saying the matter has to be taken up.
So what you have prayed for?
Upgradation, I'm saying.
For what? What?
For giving me the possession, because I have deposited 4
Go to the authority.
But authority has written to the DM that you help the person to get the possession, but the DM is doing nothing, my lord. And
When you made the application to the DM?
if we have made this is a continuous matter, my lord.
When you made the application to a DM, sir?
We have made in the month of March, and my lord, this SEBI has written letter. Again and again they are writing that you help, because in the act, my lord, there is provision that the local authorities will help the successful bidders to, my lord, get the possession, my lord. But the, my lord, DM is doing nothing, because my lord, we can commencing on 24th, my lord, any time.
Orderটা নিচে আছে
28 January.
I'm grateful, my lord.
28 January. As urgent motion. Yes. Yes.
Sir,
Mr.
could I
AG.
mention, Milord, item number 26? Where there was an interim order, Milord, which expires today,
26.
26.
Yes.
Milord, kindly not take me amiss, Milord, since matters are fixed at 12 noon, 2 o'clock.
It will not be taken up today.
Well, if it is not taken up, Milord, kindly, Milord, extend the interim order for some time.
Send any junior, I will take matter. If
Well,
it is not called, I will take the matter for action.
Milord, should we come at, Milord, 1:15, Milord, in that?
Yes, it is not called till 1:15.
Well,
Any junior, not your presence is not required.
well,
You can.
well, Mr. Jena will
Yes,
come.
yes, no problem.
May I have it? Interim order, will the interim order pass by, my lord?
When? Tomorrow?
Yes.
Kal rakho.
I mentioned that.
To be mentioned for extension of interim order.
Along with contempt application.
To be mentioned for extension of interim order tomorrow.
I'm deeply obliged.
Same problem, several times, last week,
It is still not listed.
That's
कोर्ची
same matter.
दादा अपना देखो कल उसको मैंने वो भी आया था ASGI भी आया था इन लोग भी मैंने बोला उसको कल रखो क्यों क्या हो क्या रहा है 3 दिन उसने मेंशन किया कल मैंने स्पेसिफिकली सब्सिक्वेंटली ASGI भी आके मेंशन किए हैं मैंने उनको एश्योर बोला है कि हाँ आपका जूनियर आके मेंशन किया है कहाँ गया जाता आप लोग का मेंशनिंग लिस्ट कहाँ जाता पान दुकान में दे देते हैं पान खाने के लिए कल मैंने स्पेसिफिक, वो कहाँ गया लिस्ट? कल उनने जो लिस्ट दिया वो कहाँ गया? तो रखो यहाँ दो, कल टू बी मेंशन में रखिए, यहाँ रखिए।
Yes. May I have your lordship's kindly to mention the husband of the petitioner died due to tiger attack, my lord.
Tiger attack, where?
As per
Where?
my lord, Gosaba in the district of South 24 Parganas, my lord. The husband of the petitioner applied for compensation as per government order. My lord, compensation.
Against which department?
Yes, forest department.
Against forest department, yes.
Yes, my lord. The compensation.
When she died?
Died
When he
at
died?
2025, my lord.
So what has happened? No reply.
No compensation has been as per government order.
What is the urgency?
My lord, poor wife, my lord, is facing financial.
How many children?
2 children, my lord.
What they are doing?
Food, nothing, my lord. They are catching fish and crabs, my lord. My lord, 4 matters are there.
29 January.
My lord, I'm grateful, my lord.
29 January urgent motion. These are the notice.
My lord, my lord.
My lord, may I be
Grateful,
permitted to mention one hearing matter? Respondent authorities have already filed their report, and we have filed their our exceptions. And this honorable court directed the matter to be appearing under the heading hearing. This matter relates to the Ayush doctor. They are not getting their salary has not been increasing since 2016, although their duty hour has been increased. In this writ petition, we have claiming for equal work for equal pay. My lord, hearing matter 2023.
You are claiming the equal power
Equal-
with the allopathic doctor?
No, my lord. With the Ayush doctor, no, my lord, these petitioners are engaged through the Panchayat department, and their other counterpart who are engaged through the.
But you will get the date for hearing in February. I am fixing especially.
My lord.
But
February.
inform the others.
My lord, I have already informed.
Nobody is present.
No, man, I have already informed.
Record an order. And let the matter appear. कब है? February में कौन सा डेट खाली है? Let the matter appear on 25th of February 2026 at 2 p.m. as specific.
My lord, grateful.
One matter, the Department of Post, by the enjoying the suit property, and the said suit property has been vacated and shifted to the other place. They have been the lock and key to my premises. I have made a representation.
So what the court will do? Go to the civil court, file in suit and file an injunction application, get an interim order.
Chief Postmaster General directed to open the key. They have been holding the key. No payment of arrear of rent has been made. Already, my lord.
So what the writ court will do, sir?
Only direction upon the Chief Postmaster or Director of Postal Services to open the key and to hand over the position.
If there is a dispute, who will decide?
If
there is a dispute with regard,
is my favor.
Maybe go and file a civil suit, sir.
Not the question of that. The remedy is here.
The 226 have been converted into the civil suit.
This is discretionary relief as your lordship can get the direction upon the authority.
29th.
May I mention,
29 January. Adjourn motion. Urgent.
Your lordship has been placed to restore this matter on 28th of November. That it has not appeared. I served the notice to all the parties below.
What is the urgency, sir?
Urgency is retail benefit. Retail benefit.
Retail benefit.
Well, may I permit to mention that?
29. Urgent motion.
29.
29. Okay, to mention that one again.
More than 30 lakh still give me lot. This man is suffering for lungs.
Money suit.
No, it is an Article 12 authority, which is the authority to disburse the payment. He is sitting tight over the matter more than 30 lakh.
I am feeling why I was not that side.
So any day we lost.
For the money suit and this civil suit before the High Court in the writ jurisdiction.
So any day lots of confidence got
30 January.
Restoration application matter.
Restoration, give. Restoration, tomorrow, day after tomorrow, under the heading application, restoration.
May I permit to mention
4, my lord.
Yes.
One of the kind matter that the husband has abandoned the wife in Apollo hospitals for 2 years. More than 1 crore is due. We have to stage.
So ले लो उन्हें.
It should have just 2 mentioned.
Why?
Because HL assured that they are going to transfer to a corporate
हाँ.
kind the last one. Or emergency officer. Kind is the last one. I have given notice. Kind is the last one. The last one is the last one. More than 2 years, the husband has abandoned the wife. In the hospital for 2 years now.
What do you want here?
We had requested. There was a meeting. The agent requested I will take steps that the patient is transferred to a government facility.
Still the patient is in Apollo.
Still Apollo.
Who is paying the amount?
Nobody.
So who is taking care of it?
We are doing it because the court has requested that we should not. But the patient is now out of danger.
You are in Apollo Hospital. You are Apollo Hospital.
I have Apollo Hospital. I am the British man. Any day has to be mentioned. He's a one of a kind man. The husband is also a temporary man. He's outside the domain of.
Tell your hospital to go do some.
We have done more than 1 crore. We are still treating her. She is now out of danger.
Okay.
They met with an accident.
28 January.
Madam, may I permitted to mention?
Urgent motion 28 January. Right to him. 28 January urgent motion. Let it come.
28 January. Complete.
17 kar. 16 kar. 16 January.
Madam, may I permit?
Yes.
May I permit to mention 4 hearing matters, pension matter, the issue has already been decided by a coordinate bench. Only it can be disposed of by.
Affidavits completed.
Yes, my lord.
Affidavits completed.
We have filed the affidavit. The issue has already been decided. 3% additional increment. The coordinate bench decided the issue, my lord. Under the heading to be mentioned, it can be disposed of.
To be mentioned, how it can be disposed.
Well, same order will be passed, my lord, by your lordship, my lord. The coordinate bench has already been decided the issue, my lord.
Who is for the other side?
Well, I have noticed
Yeah.
for similar matter, my lord.
14 तारीख को to be mentioned में रखो. But inform the other side. If the other side will come on that day, come with the order.
I shall inform.
Come with the order. We'll see to that.
My lord, may I?
Much obliged.
My lord, this matter was mentioned earlier in the month of December, and your lordship was pleased to keep it under the heading of urgent motion.
What is the urgency?
My lord, the piece of parcel of land was acquired from us, and the compensation is still pending for almost 12.
There is no urgency. It
My
will
lord,
come.
poor people, my lord, they are cultivated.
And it will come in the February.
Lordship, may I be permitted to mention?
3rd February. Urgent motion.
Lordship, may I be permitted to mentioning upon notice, your Lordship, for inclusion as motion. Oblige, your Lordship.
Lordship, may I?
My lord, may I be permitted to mention item number 104, my lord. The matter, after hearing, your lordship was pleased to fix the matter on 18 November, but 18 November, the matter could not be called. Thereafter, I have mentioned the matter, my lord, and your lordship was pleased to direct so that the matter it appear on 22nd of December, but on 22nd of December, the matter did not appear, my lord.
What is the matter?
My lord, my lord, this is against RTI appeal, my lord. My lord,
RTI appeal.
my
What is
lord,
the urgency?
petitioner has been heard, my lord.
Ah.
And respondent has to be heard now, my lord. Kindly allow the mentioning.
29th. karo.
My lord, may I be permitted to mention one matter, my lord? My lord, your lordship was pleased to hear this matter, and by your lordship's order dated 2nd December 2025, this matter was supposed to appear. It was fixed for filing of report by the CWC, and the CWC was directed to file the report on 8th of December 2025. It was fixed for that date. My lord, if you kindly recall, the petitioners was separated from the newborn child, and during
Yes, the newborn already been given on adoption by the other to the.
yes, without the permission of the parents of the child, and they were wrongfully taken into adoption according to the Juvenile Justice Act. My lord, the parents.
What?
My lord, the matter was running in the list in the top, but then day by day it is coming down. Yesterday it was 177, today is 185 in today's list. My lord, kindly fixes a date, and my lord, this is the urgency, and they want to meet the child as soon as possible. They are not getting the
30
opportunity.
January को urgent motion.
Lordship, may I be permitted to mention one matter?
My lord-
Lordship, in this matter, the petitioner was convicted under the Foreigners Act, whereby he has completed his conviction. Now he has
Many
been
years?
2 years of
Years completed.
completed
No,
in
no. After the conviction, how many years he is in custody?
2 months, my lord. My lord, kindly, my lord was
But
kind.
Supreme Court has fixed a cut-off date of 3 years. How
My
to
lord,
get the
my lord was kind enough to grant us leave, and it's
Correct. What can be done? But the Supreme Court stated if the convicted is more than 3 years is in custody after the period of conviction, then the court can release on bail. But in the state authorities are not.
he's illegally detained now.
Correct. That
His
is pending
conviction
before the
period
Supreme
is.
Court. That is pending before the Supreme Court. The state government has not made any arrangement for the.
My lord, on the last occasion, my lord has asked us for the notification. My lord, we have served your lordship the notification. We have informed. My lord, only after then, my lord was pleased enough to grant us the leave to file and move it urgently, my lord. My lord, any day, my lord, any day, my lord. My lord, if
There is a matter, I think, after tomorrow, let us see, then you mention the matter.
My lord,
much obliged, my lord, much obliged.
my lord, may I be permitted to mention, my lord?
Matter for extension of interim order, your lordship.
When the interim order is going to expire?
Order, your lordship. 8 on 8th.
7 तारीख को to be mentioned for extension of interim.
My lord, may I be permitted to mention?
So, tomorrow to be mentioned for extension of interim order.
My lord, may I be permitted to mention, my lord?
Extension of interim.
Lordship, may I permitted to mention for withdrawal, Lordship?
For withdrawal.
Yes, Lordship.
May I have my lord's?
My lord, I am.
Tomorrow under the heading application for withdrawal.
Obliged, your Lordship.
And what illegal with certificate by the private respondent on the basis of whereof my lord we want to see the election and secure victory. Now, my lord, just in a directed for a re-inquiry. Now, my lord, re-inquiry has been held. Order has been passed by the SGO, stating that the private respondent, my lord, does not belong to the OBC category. But, my lord, deliberately, the order has not been passed for my lord, cancellation of the certificate. My lord, section 9 of the SC Identification Act, my lord, kindly remember.
So what you want?
My lord, please matter for upgradation, my lord.
For what?
My lord,
What is the urgency?
my lord, private respondent, who is the my lord Pradhan, who has my lord fraudulently secured victory on the basis of a fraud certificate, is still not continuing my lord, signing on papers, my lord, taking the my lord policy.
Go to the police authority.
My lord,
To mention item number 143, my lord, that matter was under the heading urgent motion, my lord, on 25th.
Yes, what is the urgency?
My lord, the petitioner is a L1 candidate in the tender matter, my lord, and the tender was dropped as because, my lord, there are certain discrepancies was found, alleged discrepancies was found in the bid of the petitioner, which has been the subject matter of the challenge, my lord. On 25th November, the respondent state was directed to file a report, and the report was filed on, my lord, 16/12/25. And my lord, I was given liberty to file an affidavit of exception. On the date, my lord, the adjournment was sought for on the same ground, my lord, and the matter was dropped from the urgent motion, my lord. These are the, my lord,
Who has taken the time on that day?
my lord, my junior have.
Then you have taken the time when the matter was listed. Yes.
Restoration kindly.
Once the matter was listed, you not come and now I will not. Yes.
Restoration application. My lord, kindly have.
My lord,
My lord.
my lord,
Restoration day after tomorrow under the heading application.
May I be permitted to mention, my lord?
may I be permitted to mention, my lord?
Yes.
May I be permitted to mention, my lord, that I have challenged the impugned order in this petition passed by the district rehabilitation officer by rejecting the claim of the refugees to give the freehold title deeds who came from East Pakistan. My lord, on any day, my lord, for inclusion in the
Urgency on that.
my lord, for inclusion in the list.
Doesn't give that. It will be included.
My lord, may I be,
Next. All matter.
my lord, may I be permitted to mention, my lord?
Lordship, only one.
The list, my lord.
Lordship,
My lord,
one
part my lord. My lord.
Lordship, most respectfully,
My
Lordship.
lord, my lord, inclusion in the list, my lord.
This is regarding the
The
IVF
respondents have
matter.
already initiated the execution proceedings, my lord, before the learned. Kindly, my lord.
My lord, inclusion.
My lord, two remission matters, I have previously
You take
before your lordship.
all matter you take. Take.
The inclusion.
My lord, I am
All mentioning list you take. You take all mentioning list.
My lord, upgradation, my lord.
upgradation, my lord, upgradation.
Take all mentioning list.
These are the. Mentioning for inclusion.
It's a matter of remission.
It is for upgradation. It is in the list.
It's for upgrade.
Upgradation, my lord. The matter is listed as item number 433, my lord.
Which matter?
My lord, I have given slip, my lord.
Item number 50. Record an order.
My lord, I have given slip, my lord.
Learned counsel for the petition submit.
For consideration or upgradation.
This is a matter connected with the electricity connection. Accordingly, the matter is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
My lord, item number 29.
Yes, call the list. Call the list.
Appear for the petitioner, my lord, led by Mr. Shubhish Chandra, learned senior advocate, my lord. This was mentioned before your lordship, my lord, yesterday. Considering the urgency involved, my lord, if your lordship peruses the last order passed on 24th of December 2025, this matter relates to, my lord, admission to a school which was initially a co-ed school. Subsequently, it was converted to only a boys' school. Now, my lord, the petition has been filed praying by the guardians, my lord, so that the girl students can also be admitted. Now, the urgency, my lord, will find from page 3 of the last order, paragraphs.
File the report. District inspector file the report.
My lord,
We have not received any copy, my lord.
the report, I filed the report, my lord. I was directed to indicate the pupil-teacher ratio. My lord, will find that at paragraph 11.
So the copy.
Well,
So the copy.
Yeah, matter copy is very.
At present academic session, total enrollment of Gaurav Samit 663 and 21 numbers of teachers are working there as on itna, including one contractual and 2 para teachers. So what is the ratio?
my lord, 32:1, my lord.
32:1. Yes. So what is your grievance, madam?
Lord, may I go through?
Go through.
We have to go through this, my lord. My lord, only thing was the interim order is still 9th.
When is the where is just 9?
My lord will find page paragraph 4 of this order.
And counsel for the respondent has respondent number 3 has filed report after serving the copy to learned counsel for the petitioner. Let the same be kept with the record. Counsel for the petitioner prays for time to go through the report and also prayed for extension of the interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 21st of January 2026 or until further order whichever is earlier. Let the matter appear on 21st of January under the heading.
My lord, because the admission of students is concerned, my lord, the session will start. If your lordship kindly fixes the matter, I'll order tomorrow or day after tomorrow, because my lord, the session will get disturbed.
When the session is started. Session is started.
My lord will find.
The board is the respondent as well as the school, my lord.
My lord will find from paragraph 4, my lord, of this order, my lord. Present academic session is to end and the fresh will commencing from 3rd of January.
That Bhattacharya was probably appearing for the school, my lord. They would be able to.
Yes, what is?
I am the appearing for here this girls school, my lord. In this case, my lord, because there is an order passed by this court, my lord, that not to admit any girls students in boys school. At the same time, identical case was filed, my lord, and that is pending before this court, my lord. It is same application, my lord, same issue.
Who filed? Who has filed?
But this Debashish Adhikari, my lord,
No, that matter is immaterial, just become infractuous. In any event, my lord, if your lordship takes up the matter tomorrow or day after tomorrow.
9th January, under the heading urgent motion, interim order is extended till 19th of January 2026 or until further order.
Fixing the matter on
9.
My lord kindly fixes a time, my lord.
Urgent motion.
Lord, may I get a report of the DI?
You are the party?
Yes, I am respondent 11.
Yes. Next.
My lord, led by Mr. Shanal, my lord. My lord, senior advocate.
Give the name.
My
Matter is appearing for the bank to revert with instructions, Lordship.
Taken instructions, my officer is also here, my lord. We are not agreeable to this, more so because, my lord, if my lord will see page 96 once, the order of the authority when the release was made, my lord, it's very clearly written that the property be sold, paragraph 11, my lord. I am inclined to allow the prayer of the bank subject to the condition that upon satisfaction of bank's outstanding claims in respect of attached properties,
Nahi mila. Nahi mila.
Oh, sorry.
96.
96, my lord.
Yes.
At the bottom, paragraph 11, I am inclined to allow the prayer of the bank subject to the condition that upon satisfaction of the bank's outstanding claims, surplus amount, if any, realized from such auction shall be deposited with the appropriate authority for final adjudication of this case. So even, my lord, if I get some money, my goods are paid off, I have to return it to the ED authorities. So, my lord, today I cannot go in for any OTS. That is, my lord, has not been permitted by the higher authorities. If my lord wants, my lord, I have a SMS, my lord, which I could not print. I can show it also.
Okay.
And if my lord wants to hear Mr. Sen, my lord, then it has to be at 2 p.m. because his father is not well. He has not been able to come in the morning. But my lord, the bank is not agreeable to this.
Yeah. My lord, may I just only react to this? This one short list of dates I prepared. I'll not place it, my lord. Your lordship will go through it. Your lordship sees two dates here only, please, my lord.
No.
Kindly see 12 June 20. First date is 27 November 2019. There was no condition for release of the property. Your lordship sees the first entry there. There was no condition for release of the first OTS. There was no condition for release of the property. Then, my lord, kindly sees the third entry there, which is the second OTS. There was a condition for release of the property. And by this time, my lord, the attachment had already come. 12 June 24, your lordship sees, wherein there was a condition for partial release of security as bank was conscious of the fact that the funds required for settlement would be arranged by the promoter personal guarantor. I'm not even the borrower, my lord, I'm the personal guarantor by raising funds from investors against the properties. Borrower PVPL had no business and was defending IBC proceedings. Then your lordship sees 29 July 2024. Immediately after I accept the OTS proposal, the bank filed the application for release of property citing the OTS between the parties and in consequence. Then, my lord, your lordship kindly sees the next. I sought an extension on 12 September 24 as, my lord, the properties had still not been released by the PMLA code and the application was pending. Then, my lord, kindly see 9th December 2024, the bank withdrew the Section 8 application filed before the PMLA court with liberty to file afresh, and then again extended the time after 3 months. So, my lord, 1st March 25, they extend the time when, my lord, the OTS has lapsed long prior thereto. Then your lordship kindly sees, then they seek this balance amount. I say that I'm willing to make the balance amount, provided, my lord, these properties are still not released, so I'm not able to make the balance amount, but I'll pay interest. Your lordship sees 14 July 2025.
Yes.
Letter by the petitioner in response to R1's letter accepting the interest payment but expressing inability to accept any modification of the terms of OTS, namely deposit of further sum of 4 crores as investors would not advance additional funds in the absence of banks securing release of the attachment. After this letter is received, immediately 1 month later, they again file an application, my lord. Application by respondent number 1 for seeking withdrawal of attachment of the mortgage properties by the Enforcement Directorate. And after filing this, my lord, after 15 days of that, they cancel the OTS. Then, my lord, 28th November 2025, the court directs release of the attachment. I'm not aware of this order. I come to learn of this order only from the sale notice published by the bank, my lord, which I have disclosed in the supplementary affidavit. And instantly I file the writ petition.
Only one thing I'll say, I don't want to keep on replying to what he said. But, my lord, not a single payment made within the period that was prescribed by the bank. And he says, I withdrew. That was a technical thing, my lord. I had to withdraw the application filed before the PMLA court at that point of time. I took steps diligently. I have filed the application. And, my lord, he says on 14th of July, I had agreed to pay the MCLR plus the balance interest. My lord, there were two conditions in the OTS then.
two conditions imposed. One is he has to pay the balance 5%, which he has not done. So he cannot claim this OTS as a matter of right.
Okay.
Pray for
Hearing
that.
concluded, CAB.
My lord, may I, my lord, because of the pendency of the writ. Now, my lord, what my instructions, what I understand is the bank does not give consent to this, my lord, then I might have to improve my offer. Because I'm caught between the devil and the deep sea. When this litigation pending, they will not accept any improved offer which I make also. If your lordship is inclined to grant me any protection today, my lord, then because otherwise, my lord, the sale is happening tomorrow, I'll have to run to the bank, improve my offer, do what?
Tomorrow is the date.
Tomorrow is the date, my lord. That
Our draft is ready. Yeah, my lord, we are not accepting anything, my lord, because that's the instruction of the higher authority. I'm carrying the WhatsApp also, my lord.
My lord, ultimately your lordship will make an order that which will be binding on the parties, my lord. But if your lordship on the prima facie case, if your lordship thinks, my lord, I deserve any protection, I'll
Get
deposit.
the order today itself in the evening.
My lord, because tomorrow is the sale, my lord. My clients are waiting here. They'll run to the bank, my lord. Only that much, my lord.
Your client has not paid the amount twice.
It's only because of the attachment.
You have requested. Your client has requested for twice, but he has not paid the.
Well, because
the bank will do, and whether the court can impose the OTS.
no, my lord. It's only we are accepting the extension letter. Only default.
Court cannot. That's why I given if it is settled, it is okay because I don't know. That is the problem. The
law is that the court cannot. That is the order.
The court cannot.
No, lordship, if my learned friend is arguing on the Supreme Court judgment, two things there, my lord. A, there was the extension was refused by the bank, but there was no condition for release of property. Here we are willing. That is the only case. That is the only difference, my lord.
Correct. That's correct. They have not released. That is okay.
That is the only difficult.
Both the side there is.
Both of us, my lord, there have been some latches on part of both. My lord, so that is why, my lord, when somebody is willing to, my lord.
But how the court can go beyond that?
My lord, there is an order of another high court, my lord. I can just show your lordship, my lord. But there's no order of our court. There's an order of the Punjab and Haryana High Court on this.
Correct. But the Supreme Court also said that the court cannot.
My lord, cannot compel an OTS, my lord. Cannot compel an OTS. But here the OTS is there. We are just working it out. It's like a specific performance. Well, it's a specific performance action, basically, my lord. When there's breach on part of both parties.
No, my lord, there's been no breach on our part. Second step rejected because the particular clause was not adhered to by them. They failed to perform on that.
My lord, we can deposit this money subject to final outcome. Your lordship can grant us some protection, my lord, at this. Well, may I withdraw it then? They withdraw it, my lord, save your lordship. There are better things to do, more important thing. But we'll have to run to the bank, my lord, to sweeten the offer. And my lord, your lordship appreciates my predicament. I'm sorry to have taken so much time.
I appreciate, but the court
I know.
binding is also there. Nowadays, the court bindings are also there in the bank matters. Otherwise, the court.
My lord, kindly permit me to withdraw. With liberty to approach if there is any subsequent, my lord.
Counsel for the petitioner prays for withdrawal of the present writ application. Accordingly, WPA number 29164 of 2025 is dismissed as withdrawn.
My lord, with liberty to approach if there's
the dismissal of the writ application will not prevent the petitioner to approach the bank for settlement. And if the petitioner will approach the bank will approach the bank will take appropriate steps in accordance with it.
Or my lord, and also kindly permit me to agitate my grievance again if there is any subsequent.
Yes, appropriate before the bank, and bank will take appropriate in accordance.
My lord, before the bank or any other forum also with if there's any subsequent.
My lord is already filed.
No, my lord, if there's any subsequent development.
Will not prevent the petitioner to approach the bank or any other appropriate authority for his grievances.
My lord, I'm led by Mr. Shaftu sir.
All points are kept open, my lord. There's no decision on that. Grateful. Well, all points are kept open, my lord, since and no affidavit.
Then my lord will also
No affidavit has been filed.
Then that it was argued for 2 days because I know what the point would be taken in.
That's I don't want to go through all this. On dismiss that bit also.
Very well. Grateful.
Because then, my lord, I cannot carry a video recording that he argued for 2 days.
Now video recording is there after 100 years also, at least of this court. Grateful. Grateful, my lord. Deeply. Grateful.
This is, my lord, pursuant to order of this court, my lord, kindly comes to page 14. But there is an order passed by a coordinate bench. Paragraph 2 would be important. Leave is granted to the advocate and record for the petitioner. The advocate and record for the petitioner in that matter is the writ petitioner before your lordship. to submit the deficit court fees by 4th December 2025. Lordship is there, page 14. I deposit that, my lord, the writ petitioner. 50,000 rupees kindly comes to next page, page 16.
Yes.
And page 18, this is, my lord, from the government website,
Yes.
government receipt portal system, page 18, it says your transaction and the at the last, my lord, yes, failed in the case of your bank. In case your bank account debited, refund will be made in due course.
Correct.
Now, my lord, this 50,000 rupees kindly comes to the previous, my lord, page. I have annexed the mini statement. 50,000 rupees was debited from my account. Kindly see the previous page, page 17.
Page 17.
Yes, the first entry.
50,000.
50,000. Now they say it will be refunded. Now, my lord, I approach the Canada Bank for the refund. Canada Bank says at page 22 that your dispute registered is such and such, processed, status is chargeback rejected. So I'll not get the money.
Yes.
That is the cause before your lordship, my lord.
Who is for the Canada Bank?
I am for the bank.
Ah.
Lordship, I am submitting before Lordship. We are lacking any instruction as of now.
I am passing an order to you will get the all instruction.
Make this matter.
I am passing a mandatory direction. Automatically, the bank will come with the instruction. Then that is the only way
Lordship, we will
to work by the authorities.
My lordship, make this matter on Thursday. We will.
I never mind to pass a mandatory order upon the authority. If the authority is not coming to the advocates have been engaged.
My lordship, they are trying to track the grievance of the petitioner.
Sir, you receive the amount and the petitioner want back. It is not that the petitioner has invested the amount to some other thing. He wanted to revert back the said amount.
Lordship, I bow down, but we are lacking any instruction as of now. Lordship, may kindly keep.
When you have been engaged by the bank?
Lordship, yesterday, sir.
So when tell me your date and time, I will fix on the same date. Come with the instruction and tell your bank that if the bank will not come, then certainly order will be passed.
They should come with a draft. They are, my lord, in matters where, my lord, they seek, my lord.
Thursday or any other
Thursday, sure.
Or any other day as per your lordship.
Any other day is tomorrow.
As per the prayer made by the for the respondent, the case is adjourned. Let the matter appear on 9th January under the same heading. Affidavit of service filed by the petitioner be kept in the record.
People obliged.
Next.
Application item number 4.
My lord, I am for the petitioner.
Yes.
My lord, my lord, may I say one thing, my lord? My senior is, my lord, unwell, my lord, because of fever, my lord.
What is the application for?
Application, my lord, is a, my lord, for setting, for an ex parte order of a probate, my lord.
No, applicant for restoration. My last occasion, I took a point that if your lordship considered the prayer, earlier occasion also, when the matter appeared before Justice Rai said that you can challenge the order of the civil court in writ proceedings. I am permitting you to challenge before the appropriate forum. When the order was passed, next 2 days he chose not to appear, matter was dismissed for default. Then he filed a restoration application. Then I took a plea before your lordship on the last occasion that this writ petition is not maintainable. Lordship can grant.
It's a maintainable, my lord. My lord,
what is the writ petition?
My lord, writ petition is, my lord.
What is the prayer in the writ petition, sir?
My lord, the prayer is setting aside, my lord, the.
Huh?
My lord, prayer is, my lord, for setting aside the order of the.
Setting aside the order of?
Order of, my lord, 19th November.
Probate proceedings.
Of the probate proceedings. My lord, on the main.
19th November. Where is the order of 19th November in the writ petition?
Page 60.
Page
60.
60. So you challenge this order?
Yes, my lord. My lord, regarding
how?
My lord, regarding maintainability, my lord, senior will, my lord.
How you can challenge it?
My lord, there are some, my lord, judgments, my lord, which favor.
Granting letters of administration, you challenge the writ petition.
My lord, regarding the maintainability, my lord, kindly, my lord.
You have a Indian Succession Act.
Milord, right now,
You
Milord,
have
I
an
can.
Indian Succession Act.
No, Milord, I'm not getting Milord the instruction. Milord, the instruction.
What instruction if a frivolous application is filed here?
Milord, kindly, Milord, not today, Milord.
No.
Milord, only Milord.
Why the court will burden with the all this application?
And my lord, the district judge and everyone has made the party. I'm appealing for the district judge.
How the district judges have made a
Milord,
party?
there are some Milord errors, Milord.
Unless you go to the
Milord,
appeal.
change brief, Milord. Change brief, Milord. Kindly.
Got an order.
No, Milord.
The petitioner has filed the present application being CAN 1 of 2025, praying for. Where is CAN?
Okay. My lord, kindly, Milord, what days accommodation?
Praying for recalling of the. Where is the CAN?
Can Milord?
Recalling of the order dated 10th of November 2025, wherein this court has dismissed the writ application for default for non-appearance of the parties. Police. The petition was taken up for hearing on 22nd of December 2025, on the prayer of the petitioner, the case was adjourned. Today, when the matter is called, learned counsel for the petitioner prays for adjournment on the ground that the senior is unwell. Learned counsel for the learned counsel appearing for the district judge.
But I am appealing for the respondent number 2 and 3. The court of the district judge Asansol and the court of the civil judge junior division.
Counsel appearing for the respondent number 2, that is the district delegate to the district judge Asansol Paschim Bardhaman and the court of district judge Asansol Paschim Bardhaman raised an objection and submit that the writ petition itself is not maintainable under Article 226 of the Constitution of India, as the petitioner has challenged the order granting letters of administration. Consider the submission made by the counsel for the parties. This court finds that the petitioner has challenged the order passed by the district delegate dated 19/11/2024, wherein the London district delegate has granted the letters of administration in respect of the will.
My lord, my prayer is also the court has no jurisdiction, my lord, also, my lord.
Full stop. Considering the above, this court finds that the writ petition itself is not maintainable before this honorable court. Accordingly, the CAN is dismissed.
My lord, kindly grant the leave, my lord, to file, my lord, the appropriate remedy, my lord.
Full stop. However, it is made clear that this order of dismissal of this application will not prevent the petitioner to take appropriate step before the appropriate court in accordance with.
My lord, regarding the time limit, my lord, the file, my lord, the limitation, my lord.
That you will get.
Section 14.
Next.
Only thing, after that, he filed an application before the district delegate for recalling of the order. But that has been turned down. But he has challenged both the orders.
Yes. Next.
Right. There is a writ petition and 2 CAN applications appearing along with it.
Yes.
Now, your lordship, of the last petition was this order at the instance of my learned friend, lordship.
Order dated 19/11.
Believe me not, my learned friends.
Yes.
There is no affidavit forthcoming. I don't think, Millard, they want to use any affidavit. So exactly.
That is not correct. We want to use, but my lord, the thing is this, lordship, kindly, my lord, consider this, my lord, the petition and other things, we kindly consider. But let us, my lord, we shall, if your lordship kindly grant me, my lord.
How soon you'll file?
3 weeks time, maximum.
3 weeks? That is soon.
Very good, my lord. Then, my lord, the 2 weeks. 2 weeks. And my lord, interim order already is there, but it would expire or going to expire on 9 January. Let it be extended till 31st of January, and after 2 weeks, let them file their reply and lordship kindly fix it.
Millard, may I say this, Millard? In the interregnum, Millard, we have taken out another application in the second petition, where Millard, We have asked for, my lord, appointment of an independent expert. My lord, these are disputes regarding certain machines which we had supplied. They have come up with a report saying that the experts have said that the readings in the said machines, my lord, are not correct. Now, my lord, that has come at the instance of the respondent. So, my lord, we presume that, I'm not saying yes or no, but we presume that it has been under instruction.
Want the independent.
I have filed an application.
But that application in the second matter.
In the second
In
matter.
other matter.
The same matter, same matter.
No.
It's not CAN 1 or CAN 2, it's in another writ.
But in WP 15978.
I brought a list of certain experts, my lord, in the field. Anyone, my lord, the court feels.
What is the machinery?
My lord, it's for measuring the blood glucose.
The
Hemoglobin.
I think copy has not yet been sub. Copy diyecho kake? Kake dile?
What is the CAN number?
My lord, this is CAN number 1 in WPA 26421.
Oh, 26421.
2642 is not listed.
26421, I am not happy. I do not
It's
know.
not
which
listed.
appearing.
My lord, all I was saying is that since
Whether the same matter
that
or not, I do
report,
not know.
that report which will come, my lord, would have some bearing on the hearing of this application, my lord. Let that application, my lord, appear any day convenient to your lordship, so that, my lord, in the meantime, we are taking 2 weeks' time. In the meantime, the
So
expert.
in that application, whether affidavit directions are there?
I do not know.
I don't think.
Somebody
my lord,
else is
there is
appearing possibly. I do not know, my lord.
My lord, that can be, if an expert
what
is to be
extent those are-
appointed from a list of 5 people,
Madam, may I tell,
my learned friend can also choose any one of them.
Madam, may I tell? When this matter is taken up and that matter is not in your lordship's list, so my lord, I cannot, my lord, say anything. I am not in that matter. I do not know anything. So lordship, kindly, my lord, so far this matter is concerned, I can say, lordship, kindly give me 2 weeks' time. I shall file my
Very well.
affidavit.
Give him 2 weeks' time and let this matter also appear, my lord.
Along with this matter?
Not along with this, my lord, because that needs to be, order needs to be passed.
Okay.
Because
So
the
let it
outcome-
come tomorrow or day after tomorrow.
Or anyway.
And counsel counsel appearing for the state press for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks from date. Reply, if any, there to be filed by
1 week thereafter or 2 weeks thereafter.
within 2 weeks thereafter. List the matter. 2 weeks to
4 weeks.
डेट अच्छा है कि 12 बजे का कोई डेट है देखो फिक्स का फिक्समेंट 12 बजे का कब है फरवरी फर्स्ट वीक में है 5 फरवरी 5th February or 12 noon as a specially fixed matter. The interim order is extended till 9th of February 2026 or until further order, whichever is earlier.
If this direction can be passed, my lord.
इसको ना एक काम करो डे आफ्टर टुमारो इसको अर्जेंट मोशन में लेके आओ
So that, my lord, this interim period can be used, my lord,
day
for
after tomorrow urgent motion.
ওটা নাম্বারটা কত আছে?
ওই তো ওটা নম্বরটা হচ্ছে বলে দিচ্ছি আমারও নম্বর কি আর মুখস্থ থাকে স্যার
এটার নাম্বারটা
2642
2642 হ্যাঁ 25 হবে।
হ্যাঁ
क्या हुआ
ঠিক আছে
हो गया तो
ओब्लाइक
ये तो देखे ना मैंने
गेट
जब जो मेंशनिंग लिस्ट दिया है ना उसको यहाँ रखो यस नेक्स्ट 5
Instead of 9, can it be taken? Take up my 10 first. Both are similar, madam.
10 का फाइल तो
Well, Mr. Shopun Banerjee is appearing. Mr. Shopun Banerjee is appearing in item number 9.
10 take coach.
10-13 yes
Lord, before my learned friend starts,
Yes, I know.
Lord,
He has a preliminary point as soon as.
for want of determination, my lord may not take up this matter.
what is the matter
This is a service matter. Kindly come to page 16.
page 16 prayer
No, pleadings.
pleading
Para 28.
para 28 Police recruitment.
And he is saying it is a service-related selection are ordinarily amenable to the jurisdiction of West Bengal Administrative Tribunal Act under Section 20.
Issue related to EWS. Your Lordship.
I am coming. And your Lordship's determination
Why the West Bengal Administrative Tribunal is not there?
No. But that's the reason.
Yes, for that, my lord,
Your Lordship is taking up on one matter where I'm
my landfield is also moving before Justice Shogoto Bhattacharya, and another matter is also hearing going on as to whether it will go to the division bench or single judge can hear in absence of judicial member of the
It will go to the division bench.
No, lad.
that is
I am back to it, lad, Supreme Court judgment.
no, no, I'm special bench judgment. I am also prepared. Fully prepared.
And first, but it's just with whether this court is having jurisdiction.
No.
Determination.
Absolutely.
Lad, EWS. Your Lordship is taking up matters, my lord. Lad, here, lad, the question is,
EWS, but the recruitment process. How
lad,
this court-
all EWS issue, my lord, in fact, EWS certificate is issues for recruitment. Entire purpose of EWS is for recruitment, lad. Lad, I have, lad, no dispute so far, lad, recruitment, lad, terms and condition is concerned, lad.
Yes. Yes, anything, but what the judgment you are having?
I have got a judgment of the special bench. For want of determination, my lord, what would be the fate of the orders that is passed by the learned judges? My lord, a reference is at paragraph 1 itself. Whether an order passed by the bench of this court, not having conferred with determination by virtue of the roster fixed by the Honorable Chief Justice, is vitiated by inherent lack of jurisdiction so as to render the order passed a nullity
in the
eye of law or void ab initio. My lord, the honorable judges, my lord, it is my duty. That is why I am saying.
Correct. That's why the lawyers have been called as the court
officers.
For this, no judgment is required.
No, judgment is required because you are saying because it is without jurisdiction and nullity. Any order that may be passed.
Always. Nobody in this courtroom will be denying this.
Paragraph 10 onward, my lord, paragraph 10, my lord, Sumama agro was followed. Then ultimately result is, my lord, all judgments have been referred to. Then ultimately the question has been answered in the affirmative. Any matter pertaining to and in connection with the, my lord, service under section 15 of the Administrative Tribunals Act, it goes to the tribunal. I have no choice of court.
Yes.
Forum chopping, my lord, is not. My lord, he is also moving before Justice Bhattacharya.
No, that is absolutely service matter.
This is also service matter.
Yes.
That matter relates to promotion, and this is something else.
This is also you go to the
Lad, I tell you, Lordship, lad, I had an occasion 2006, lad, to move a matter before Justice Dipankar Datta, lad. The prayer was for repairment of embankment and for police protection. Whenever we repair the embankment, somebody comes and break it. The court says that I don't have jurisdiction of land How come I take off land? Either you have to move before the land court or before the residuary court. So ultimately, it was decided that this has to be assigned. So far, the other determination part is concerned. Ultimately, the matter was taken up by Justice Tattum. But these are certain issues which needs to be clarified. Now, here, at the verge of recruitment process, conclusion of recruitment process, the authority is seeking EWS certificate, and particularly when in the midst of the recruitment process, a fresh notification including the my subcaste into the OBC list. My subcaste was not in the OBC list. It was included during the selection process, not before advertisement, after advertisement. Now, I had my DW certificate. I produced the DW certificate at the time of my application, in terms of the requirement of the advertisement. Now, the authority is saying that you need to produce fresh EWS certificate, but in view of this notification, I cannot get it. But that's the difficulty and the reason for which I am before this court. Has nothing to do with the advertisement.
But kindly come to the prayer A.
Uh,
Demanding the
Milad-
responsibility West Bengal Police Recruitment Board to consider. So how
Yes,
this
Milad-
at this stage regarding EWS certificate? So
if I go to that court will say I don't have determination so far that notification by which your name has been included in the OBC list. That is with the residuary bench. That's why I take an example of my experience before Justice Otto. Now, this is a whole difficulty. I have no quarrel with the advertisement. I have participated in terms of the advertisement producing my EW certificate. The difficulty is, if you kindly takes up page 75.
there is one judgment. I could not remember. The joint cause of action, the determination, Justice Basak's order is there. If joint cause of action, as like this, if the joint cause of action, some part here, some part in the other court.
Any of the court can take up. Even I take up, consider that judgment, and even though she has determination.
Because your B prayer is okay.
Yes, but my difficulty is page 75. Page 75, this was issued in the midst of the selection process. Can you see the dates? And this subcast is at page 77, clause 90. Page 77, clause 90. Shadgop is my page 77 at the bottom, clause 90. Sadgop.
Yes.
This is my community, Now, kindly takes up once, but what was existing prior to this, page 29. That's why I say I have no quarrel with them. 29 at the bottom, clause 5. Candidates belong to economically weaker section must produce income and accent. As per specified format.
Kindly see section 15. All matters.
Correct. I am not on that. That's what I'm telling. With regard to the recruitment, this court cannot. This court is not having. But kindly come to the prayer B of the writ petition. Where is this notice? Prayer B, which you want to cause? Certificate, EW certificate. Where is this prayer B certificate?
Yes, sir. Prayer B.
Prayer B, which you want to cause, the notice dated so and so, so and so.
Yes, ma'am.
Where is that?
Declaring that economic section. Yes, ma'am.
Which annexer?
P9 at page 8.
Page?
Page 90, annexure P8.
So this is a police recruitment.
This is but I am seeking declaration that you don't put me in these terms that this notification at page 75, which include my subcaste
Correct.
into OBC list.
Correct.
I don't want this reservation. That's why I have made prayer B. This prayer cannot be given by the any other bench except this bench.
Why?
Because page 75 includes my name and kindly see the notification. ওই নোটিফিকেশনটা দাও ওবিসি এই ইডব্লিউএস এর নোটিফিকেশনটা দাও মানে kindly see this notification. What is my difficulty? Because of this incorporation, now kindly take some
This is not under challenge.
clause 3. Yes, it is under challenge. This is that is in fact by prayer.
Exemption from reservation.
Yes.
Yes.
I mean rather clause 2. The person belong to EWS who are not covered under the scheme of SC, ST and OBC shall get reserved 10%.
Correct.
In the midst of the selection process, this notification of OBC was issued. Now they are saying
Which notification was issued?
at page
75.
75
75 issued by whom?
by the backward class department. That's why I have made the prayer B.
So you have been made as a backward class category B.
Yes.
Who has issued this? Where is the total notification?
Total notification is
Where is the total notification? When it was issued?
at the top. It was mentioned.
List of 140 sub includes the more backward classes category A and category B as per the notification of from May 2025. So where is your certificate? Where
My
is your certificate?
EWS certificate. Yes. My EWS certificate is at page
74.
At page 67. Producing this certificate, I have applied.
But in the meantime, that category changed. That category.
And nobody can compel me to be treated as OBC. I don't want this constitution. That is absolutely against the Article 15 of the Constitution. I didn't even apply for OBC certificate. I don't want to apply for.
Who is for the authorities?
State can respond to this.
You are appearing for whom?
State.
State. For the state.
He can respond. Only difficulty is today I have been qualified. So far the first round is concerned. The notification has now been issued that if I want to participate in the physical efficiency test, then I have to upload a present certificate, and then only I can download the admit card for this. That's why I seek for interim order at this stage. Let them file their affidavit and decide this question.
No, with regard to prayer A, this court cannot at this stage. With regard to the prayer B and other prayer,
let them not insist me to obtain OBC or change my category. Oh, if there is a record, no difficulty.
Yes.
Presently, he should not produce the certificate.
Correct.
But at the time of interview, he has.
So whether there is a written test?
Yes, I am qualified.
No. All of them has not qualified.
You have qualified?
Yes, I am.
So Bosachi Ghosh and Saurabh has not been qualified.
In the written stage, in the written examination, who
Yes,
has qualified?
Qualified.
How many petitions are there?
And it is, my lord, I have got.
Among the 6, according to them, 2 have not been qualified. Rest have been. Right?
Yes. Even marks have been given.
Sabyasachi not shortlisted.
Bosachi and Saurabh.
Sabyasachi and Saurabh not shortlisted. Others have been shortlisted.
Yes.
32, Sabyasachi and Saurav not shortlisted.
And their mark sheets have been given.
So when the interview is being conducted, when the interview will be conducted,
Give me a second. Date has not yet been fixed.
अरे हमको notice दिए थे कोई
Interview date has not been fixed.
मतलब they have emailed me.
ফিজিক্যাল মেজারমেন্ট টেস্ট এর জন্য
Okay.
এই 18 তারিখ কারোর হচ্ছে 16 তারিখ কারোর 18 তারিখ
Physical measurement test they have started. Now that I don't think that.
Okay, let they continue. Only the interview they have to submit this.
Can you record that they will not insist in the physical measurement test? Court record করছে তো
10 is being taken now. This is with regard to constables.
Constables. This is a post of constable only.
Yes.
So when the interview physical test?
Physical test কবে আছে?
From 8th.
So you do one thing. Let them may allow these 2 persons may allowed to be.
No, they cannot. They have not success. They are not successful.
Those who have successful.
Who has been shortlisted?
Yes.
They may allowed to continue in the physical test.
Look, they cannot appear in the physical test.
Why?
One has to cross that barrier first.
What barrier?
যারা পাস করেছে তাদের কথা বলছি
হ্যাঁ যারা পাস করেছে তারা
Okay, that's why let them participate in the physical test,
excepting these two.
Yes, obviously.
Yes,
these two participate at the time. In the meantime, what is the instruction with regard to this OBC, this notification?
Notification is not under challenge before this court.
No, I have said I have made declaratory prayer.
Can you see the prayer B? That's what I'm telling.
No, B is with the notification issued by whom?
This is by the backward class department.
That's who is appearing for the backward class department. You are appearing.
But I could not take any instruction.
That's why what I supposed to let's the shortlisted candidate may be allowed to participate in the physical examination and interview. It has to be placed. How soon you will give the report with regard to the with regard to this decision taken by you with regard to the
production of the certificate at the time of interview? That my lord, after affidavit, your lordship will decide.
But this has to be decided. How long you can keep pending for the interview? So that's why this is to be decided
shortly.
That has to be decided.
So how soon you file report with regard to this? Because earlier he was in the EWS category.
Yes.
Earlier they are in the EWS category. Now you have been changed the notification, brought the OBC under the category B. Category B.
They can change any time.
So that's why that's why I am not telling you illegally. So you have to submit under which provisions of law and what criteria you have fixed for changing the category from the EA.
Changing of the category is in the notification itself.
Where is the notification? That's why I'm asking where is that?
Let them take my full-fledged instruction.
No. Kindly come to my lord page 90 itself.
90. Yes.
My lord, clause 1, certificate.
No, this is the recruitment board. Backward class, kindly come to the page 75.
75.
This is decision taken by you. Who has taken this decision? Where is this notification? The petition have been brought under the.
This is by backward class.
So how this decision has been taken?
No, this decision was under the challenge up to Supreme Court. Now stay is there.
The decision.
How this court will do now?
No, stay up.
I tell you.
তুই তো নিজেও জানিস এটা. Order passed by this honorable court staying the operation of this order has been stayed by the Supreme Court.
Correct.
Now, if your lordship kindly comes to page 90, enough opportunities there for the ESW candidates and the OBC category candidates whose category either removed or added or interchanged in the current existing list of category of the government of West Bengal have to procure their certificate from the competent authority. Let them procure.
That's why. So that's why I'm telling. They have been shortlisted. They have, as per your notification, page 75. They have been brought from the
No,
year
75 is the list of category A and B.
Correct. Kindly come to the page 74. Not 74, 60, 67.
67, yes.
It was the EWS.
Yes, yes.
EWS. Now it has been changed to the category B.
B. Kindly come to listen. That is why I am reading. Page 90. That is why I am reading.
Page 90 is the recruitment notice of the police department.
Yes.
Correct. Police department telling whatever the certificate they have to produce.
No, not whatever. If it is interchanged.
Correct. That's why interchange.
They let them produce. Their backward class is issuing now certificate.
That's why I'm telling. Though they are telling that you have issued, you have bring them as a category B.
Yes.
Category B. Yes. They are asking now. They wanted to EWS.
Yes. They want to retain the EWS.
EWS.
That has to be decided.
That's why I'm telling for the last half an hour.
No, I could not read your lot. Maybe because of the cold weather or either of these.
So they wanted they should be retained in the EWS. They have been wrongly brought under the category B of the OBC.
They don't like to change.
They don't like to. They didn't want to be OBC. They want to be in the EWS. So only you. That's why you have to submit the report. See, okay, category B, category A. It is the discretion of the administrative decision you can take. But the EWS, some other category. Why they have been brought under this? Right. Because of this category EW. What is the category for giving the EWS income? So if these persons are not having the income, so whether they will go to the B or come to the EWS. What are the criteria?
Kindly come to page 74, 75.
Yes. 75 I'm there. That is the only challenge here.
Not to be so fast. Well,
in recidivism is required.
So
you're not habituated to the cold weather. I am habituated for that. So in the Andaman there is so cold.
Andaman is Andaman, Bombay, seashore.
But I am habituated for that. Cold also.
For a long time your lordship was there. Now they have been changed. Changed because of that.
That's why only the question is that you come with the report. In the meantime, I am passing an order. The shortlisted candidate may be allowed to participate in the physical examination test. And in the meantime, you file the report. Under what circumstances this EW has been converted into the category B, OBC category B.
But I was saying something else.
Yes.
I was saying even if your lordship sees the challenge to prayer B. Last part, if your lordship sees, I am reading it.
Yes, yes.
Was set aside, notice dated such and such, bearing such and such, in so far as it mandates procurement of fresh and revalidation EW certificate issued after.
Where from you are reading?
Page 23, prayer B.
Prayer B. Issue a writ on nature of such calling the record, causing setting aside the notice dated 17/11/2025. 17/11/2025. That is the page 90.
Page 90.
Page 90.
That also covers section 15.
Yes, Mr.
Prayer C. I have seen that. I was calling my juniors.
Very frankly.
Prayer C covers everything.
Go in appeal. I may not advise you. Because the judge is judge, whoever decides. But then,
judge is to be corrected by the appellate authority only.
Prayer C covers everything. Prayer C and prayer D. C and D covers everything.
It is not the judge. Every time the judge is right. That's why the appellate authority.
That's why we are here to assist the court in right direction.
That's why I am always ready to learn from you.
It comes.
Prayer C and D covers everything.
My reading is it comes within section 15.
Correct.
C, D, E.
No, but
All are covering.
Issue written and declaring the notification 325. Where is that notification? See?
C.
C notification. Where is the C notification? Yet declaring the notification dated so and so 9th July.
That is I have produced.
This
Just now I have handed over.
Can I have a
9th
copy?
July.
By which
arbitrary.
benefits has been excluded. Clause 2 I have referred.
আমার টোটটা কপিটা দে না।
So, but prayer A and B is with regard to the recruitment issued by the police authority, how this court can enter into.
But for the timing, yes, no. Because the first prayer needs to be considered whether anybody can be forced to receive caste-based reservation. If it is decided against me, then nothing remains. So, if that notification 19 sustained, nothing remains in my writ petition.
Correct.
That has to be decided by this court only.
So that is a C.
That is press C. C and D. D also mlat.
But you are not include this.
Now that I can produce by way of supplementary mlat. It's not happily drafted. That's I have seen that.
Finally, come to the page 75.
75. Yes.
Backward we as per the government notification that 27 May 2020. Where is that notification? This is not in connection.
This is the list of categories.
No. List of 140 girls included under the more backward classes A or backward B as per the notification of 27th May 2025.
Yes.
Where is that?
But this notification is not available, but the list is available.
So you are telling prayer C is this one, but this the notification under which you have been brought under the category B is under the notification of 27 May.
That is also I need to
So hurry. You prepared the notification because without any document.
But this possibly this notification is not. Let them ask to produce this. Or I'll
You find the writ petition and production of document by the other side. What?
But this should be in the website. But I'll be checking that.
Because this is not. So how it can be? You challenge the
police recruitment. 19. One second, man. The 19 order is. I have handed over. Can you see clause 2? Yes. 1 second. Yes. The clause 2 exclude me from taking benefit of EWS.
Correct.
That's my point.
That's correct. I appreciate EWS is total segregated from the ST and OBC. No problem at all. Now with 25 notification you have brought under the category B. There are 2 categories. You have been brought under category B. So you are not challenging the May 25 order. Notification.
May 25 order, possibly I cannot challenge in directly. Why I tell you, Lordship, this is under 1993 Act. This notification was issued.
Correct.
Now, 1993 Act, Section 9 and 11, subject to Lordship's consideration, the authority inquire into the issues, and they decides which are the backward classes.
No, then again the question will come. If you are a backward classes, and what is the difference in the backward
EWS?
EWS?
Yes, the difference is backward classes.
How you identify the EWS?
Right. I tell you, there's a fine difference. The difference is in EWS category only economically backward.
Correct.
And so far OBC is concerned, they're educationally, socially as well as economically.
Correct.
So those person who are economically backward class, those who are socially and educationally backward class, as well as economically backward class, all of them are EWS, but all EWS are not OBC.
Correct.
Now, therefore, if I don't want, why I opposing OBC? I opposing OBC for the reason that I don't want caste-based reservation. If Article 15 prohibits caste to your identity, then I may always choose not to take advantage of that reservation, but to avail the reservation
under the backward.
That's my point. I have argued this before the Lordship in other matter also.
Correct. No, but only the problem is that
Well, this needs to be argued at length, my lad. There are judgments in the line. But I believe that this will went up to the Supreme Court also. If they
the grievance of the petitioner in the presented application that the petitioner has applied for the post of constable in the state of West Bengal, post of constable in the state of West Bengal.
West Bengal, my lad.
State of West Bengal. Full stop. Full. The
My lord, today I should not interrupt, friend. My lord, why this certificate is required? WS certificate is valid for 1 year.
correct.
That is why it is.
Correct. Well, state of West
আমি
full stop.
তোমার ইয়ে পড়িয়েছি EWC
As per the recruitment notice dated 17/11/2025 for EWS candidates and OBC category candidates whose category either removed or added or interchanged in the current of the existing list of the categories of the government of West Bengal, have to produce their certificates from the competent authorities issued on or after 14th of June 2025. Counsel for the petitioner submit that the petitioner was under the EWS category, but subsequently, by a notification dated 27th of May 2025, the petitioner has brought under the category of OBC, under OBC within bracket backward category B. Category B, for which the petitioner could not get an EWS certificate. Now the petitioner intend to get the benefit of EWS category in the said recruitment process, but the authorities have not issued the EWS certificate. Police. Learned counsel appearing for the state raised a preliminary objection with regard to the determination on with regard to the jurisdiction of this court and submit that this court is not having the determination to decide the instant writ application as the subject matter is of the recruitment process and this court cannot decide the matter. Police. Learned counsel for the petitioner submit that though the petitioner, the genesis of the writ petition is the recruitment process, but the petitioner is the prayer of the petitioner in the present writ application for issuance of the EWS certificate, which this is the only court having jurisdiction to decide whether the petition is entitled to get the EWS certificate or not. Considering the submission, this court find that the petitioner is only harping upon the certificate for issuance of the EWS certificate by the authorities, and thus this court find that this court having the determination to decide the said issue. Then counsel for the state has submitted that the written test has been completed for the post of constable and the petitioners have appeared in the written test. Out of the 8 petitioners, 6 petitioners have been qualified and have been shortlisted for the further recruitment. This is not recorded preliminary. क्या बोला? Has petitioners 6 have been shortlisted for PMET and PET. Full stop. This court find that though the petitioner out of the 8 candidates, 6 have been shortlisted for PMT and PET. Accordingly, the authorities are directed to allow the shortlisted candidates to participate in the physical examination test. And PMT, what is the PMT? Preliminary? PMT, what is the PMT? PMT and PET. Full stop.
Both.
Physical measurement test and physical
efficiency test.
Thus, subject to outcome of the result of this court and this writ petition. In the meantime, the state is also directed to file the report whether the petitioners can be allowed to can be taken as EWS can be taken as EWS category instead of category OBC category B. Let the report be filed.
I am your lordship and
Blood admit card for this test blood maybe issued blood physical.
I told that allowed to come. Let
Right.
the matter subject to outcome of the result of this court. This writ petition by 2 weeks. By 2 weeks after serving the copy to the learned counsel for the petitioner. आज कितना तारीख है 7 है 6 तारीख है 2 weeks. Let the matter appear on 28th of January under the same head.
one other thing, my lord, I tell you. Why it is taken as it is a service matter and amenable to the tribunal as pleaded in my lord, para 28. Then also Article 323A and B comes into play. Then also whether single judge or division bench.
That's why I have not taken into consideration the recruitment process. You have not heard the dictation.
And item number 9 is
when I appeared from the bar, because in Andaman their cat was not the regular in session. So we used to move before the court. So this question was moved. This question was moved. Then it was a division bench.
It was a division bench, it was being heard.
It was a division, but I don't.
there are judgments of 2025 and 2003 which says no single judge of this court.
That's why I don't know further what has happened in the principal bench.
Another matter is
But 9 is maybe similar order being passed.
my lord, and another matter is being heard. Advocate General is addressing the court. His submission is even if it is taken up not by the single judge but by the.
Okay.
I'm sorry, my lord.
Next. Thank you.
But in 9 let
11 item number
9.
9 already passed an order.
But item number 9 but physical efficiencies is already over and we are allowed. But subsequent stage let they should not take any possible without leave of the court with the cancellation of my conditions.
Now I passed an order in 9.
10.
Yes.
In 9 similar issue is involved. Here that physical efficiencies is over.
Okay.
Post of sub inspector. Now that they should not cancel my
Mr. Shopun Banerjee is there.
Tomorrow take up.
9 tomorrow, not today.
My lord, or if your lordship takes it after half an hour.
I don't think so. Come tomorrow. Yes. Call. Number 6. 8.
Not about the state correspondent, not I have brought the press report. So lordship so desires I can.
I beg to appear on behalf of the petitioner.
Yes.
Not very plain
Fine.
report.
Yes.
In terms of my lord's last order, the state had taken a point that the appeal is pending before the learned district court, my lord, at Purulia. That is the point that they had taken. It had fallen from the honorable court that a special officer will be appointed who will be present there, and in the event there is any law and order situation, he will be immediately informing the district magistrate and the concerned SP. On the last date, I have taken instructions, my lord. The appeal was fixed on 20th of December 25. It could not be taken up by the district court, my lord, because there was possibly some resolution.
Pen down the objection.
No, at present the petitioner already started construction of the bond.
Yes. That is again another, my lord, submission that I will be making.
Second page of my report.
Owing to, my lord.
And there is no problem, Lord.
Owing to pendency of the case, my lord, and my lord, the observations, my lord, as has fallen, my lord, from the honorable court. I may kindly take it up after 2 weeks, my lord. But almost 80% is complete, my lord. Till now, my lord.
Not what I objected to regarding the appointment of special officer, because earlier in the.
And it takes it up after 2 weeks.
This court, as per my concern, I want all the matters should be resolved.
Yes.
So my report
Instead
may
of
kindly be kept on record.
Lingering the matters should be resolved. Either of the way. lingering, no purpose.
Well,
to
is it
dis-
necessary to keep the matter pending for?
Well, kindly
another
takes it
2
up after 2 weeks.
Okay, I am fixing after the, I am accepting your report, keeping the report,
Yes.
fixing in the second week of February.
Grateful.
And
13th February is the next date. So cause notice has been already issued to the principal defendant. So your lordship give it after the
কোথায়?
date.
So I am fixing on 10th of February.
Your lordship
10th of February.
10th of February.
No, 13th February is the date, next date. Your lordship,
No purpose. See, now if the construction will be over, the petition would be done.
Naturally. 10th.
The state authority has filed the report after 17th February for the petitioner.
13th
Let
February is the
same-
next date. It would have been better not if your lordship
Let the same be.
could have fixed it after
Okay,
13th.
let the matter appear on 16th February.
16th February.
At the same meeting.
Grateful.
Grateful to Lord.
Grateful. But I'm sorry, Milord. Suddenly gate of Gate
Your lordship has already heard Milord item 10. Item 9 is a little bit different because there is not the question of participation. Here Milord already participated and they are not. But only they, my landlord is praying they're not to cancel. But I want, subject to your lordship's kind sanction, whatever steps, but that will abide by the result. That will abide by the result.
That will not, sir.
Now, whether interview conducted?
Yes, yes. Everything is over.
That is why it is.
Let them not cancel my candidature without leave of the court. That's all. For non-production of this certificate.
No, but with regard to you are appearing for the state also.
State.
How soon you will file the report with whether it can be converted into OBC to OBC category B to EWS? How soon you will file the report? By that time, I will say no, not to take any
Adverse.
action. You tell me that you take the instruction from the DM.
কোয়ালিফাই করেছে ইন্টারভিউ করে বাকি আছে যে কোনো সময় ইডব্লিউ সার্টিফিকেট
We have actually a police department. We have to come.
Not that's what I'm telling you. Who is appearing for the DM and
I have since but I am appearing for the state blood the DM.
Correct. Not police. I am not against the police.
No. But I cannot go by this.
So you do one thing. I am keeping tomorrow. You take proper instruction. How soon you can file the
by tomorrow, but I can. Your lordship can pass the order.
Interview is yet to be held. স্যার ইন্টারভিউটা এখনো হয়নি ইন্টারভিউটা হয়নি
বলতে হবে কোর্টের অর্ডার পাঠাতে হবে মোটামুটি fortnight time your lordship kindly give.
Fortnight time.
Fortnight time.
So till the disposal not to reject the candidate,
Yes.
let it be in the list. Then until the disposal, what is the
Or will not your lordship can without prejudice, your lordship subject to result of the writ petition, your lordship can pass the order. Because if it after the consideration at all, if your lordship holds that yes, action of the respondent is bad in law or illegal, then your lordship is power to cancel or set aside. That is why interim
not to cancel. That's all.
Cancel.
The petitioners are the aspiring candidate for the post of sub-inspector of police in the West Bengal Police. The petitioners have participated in the recruitment process. The only grievance of the petitioners before this in the presented application that initially
from the police, this report also can take.
The only grievance of the petitioners before this court that initially the petitioners were having the EWS certificate, but subsequently the category of the petitioners have been changed from EWS to category OBC. Within bracket category B. Category B. Now the petitioners intend to remain in the category of EWS. Full stop. He submits that due to change of category from the EWS to OBC category B, the respondents authorities are not going to consider the candidature of the petition under the EWS category. Full stop. Learned Counsel appearing for the state submit that the recruitment process is completed, but final result has not been
Well, interview is
Interview
is not complete.
all the except the interview process, all the formalities have been completed. All the formalities have been completed. In view of the above, full stop, full stop. This court find that this writ petition is to be disposed of only after obtaining the report from the. Who will give the report?
Okay, report to the
You are not made a party. You are not made a party to the.
Then he has to make party.
Not made a party.
The petition to come.
For his principal secretary. Unless an until
Principal
report
secretary.
unless an until report is filed by the respondent number 4, that is the principal secretary, backward classes, welfare department, government of
Two is,
West Bengal.
but we can delegate the powers of to file the report. Principal secretary.
No, that is a recruitment board. But
No,
if, backward classes, because the category is
No,
set by the
respondent
welfare.
number 4, your lordship. Respondent number 4, your lordship is directive. But respondent number.
No, I am not directed unless and until you file the report. File the report before this court to show. क्या बोला? Only after obtain report from the respondent number 4 with regard to the issue whether the category of the petitioners can be treated as EWS instead of category of OBC, category of OBC within bracket category B. Let the report be filed by 2 weeks.
3 weeks time, your lordship.
By 3 weeks. By 3 weeks after serving the copy to London Council for the petitioner. Oh, matter when it was fixed? Huh? The matter appear on 28th of January 2026.
But only for the purpose of this is on my behalf. I am praying by seeking that your lordship may a copy of the order be sent down to the respondent number 4, so that everything will be done.
Full stop. In the meantime, action taken by the respondent authority shall be abide by the result of this court.
Yes. No.
Cancel my candidature.
Result of this court. Full stop. The department is directed to communicate this order to the respondent number 4 for compliance.
And let the copy of the report be.
Copy of the report filed by the state be kept with the record. Next. Item number 11. Yes.
Of the Kerala High Court,
Yes, Mr. Bandapati.
Our reasons, we have already handed over. Now, we may have objections on fact, but I cannot lose sight of the fact that it has been allowed by 2 single benches of our court. And in November 25, this the Union of India was a Divyani. But the Kerala High Court Division Bench has also upheld this. There was another order of Meghalaya High Court where interim order was passed. And thereafter, since the ovum and the sperm was not fertile enough, it was made infructuous and dismissed. But similar orders have been passed. On law, I cannot take an objection. But on facts, I think the objections have already been handed over. In one of the orders of instruction, yes, that last page has our objections. But factually, those are the objections. But in one of the coordinate benches have taken into consideration these same objections and has allowed the IVF.
Correct. You have given the objection.
Instruction, it's a copy of an instruction with the heading statement of facts. Last occasion it was submitted by me.
You have a copy?
I'll Omito Sin order ta kya hai if your lordship is having the order, probably, but if your lordship is having the order of the,
Probably this is my lord.
May I, my lord? Right. Right. It is. Action. Then back to এটা ইউনিয়ন অফ ইন্ডিয়া অ্যাক্টের আন্ডারে যেটা আছে সেই হ্যাঁ পুনর্লিখিত কোথায় হবে in the coordinate benches order of Shamoli Shaha,
Yes.
These same objections have been taken into consideration also.
Yes.
In paragraph 7. Shamoli Shaha ke din diyechili?
Yes.
So there has been handed, your lordship will find in paragraph 7, the same objections have been taken into consideration and thereafter allowed the IBF to continue.
Okay, I will dispose of this.
Fine. So in terms of Shamoli Shah as well as Divyani, the Kerala High Court Division Bench.
Kerala High Court Division Bench order is there.
Paragraph 30 is relevant in that. 30 and
You this Kerala Division Bench order.
This is the interim order, paragraph.
No, the final order. Final order.
This is the final order.
Final order.
The interim order of stay, and this is paragraph 31. And that is handed over because Shamoli Shah was considered the interim order. Paragraph 30 and 31.
no. ফাইনালটা দেখলেই হবে But in the final order passed by the Kerala Division Bench,
Yes.
your lordships may kindly take note of paragraph 4, which are the objections of the Union of India,
Yes.
and the decision is in paragraph 30.
Correct. The petitioner has filed the present application, praying for a direction upon the respondents to provide the petitioner with the necessary permission. Yes, yes.
Thank you.
Permission and services to avail the assisted productive technology through IVF
Assisted
procedure
reproductive
in terms of the provisions of Assisted Productive Regulation Act 2020-21. The petitioners are the coupled petition number 1 is aged about 57 years and the petition number 2 is aged about 52 years. The marriage between the petitioner and petitioner number 2 was solemnized on 22nd of April 1996.
It's overage, right? দুজনেই তো overage
only take me back on
The wedlock between the petitioners, a girl child, namely Supriti Vaidya, was born on 25th of August 1998. But unfortunately, on 5th of June 2025, the girl child passed away. Now the petitioners intend after the death of the child, and as per the advice of the elderly members of the family, the petitioners have contacted. Where you are contacted?
Yes, kindly come to initially kindly come to page 90.
Contacted the office of the respondent number 4.
Kindly come to page 90.
4. Who is the consultant doctor of the petitioners? Page number 19.
Yes. Kindly see, Milord, at the bottom, Milord, all the age limit does not permit for IVF.
And on examination of the petitioners, the consultant doctor namely Dr. G.B. Datta, has opined that age limit does not, inverted comma, age limit does not permit for IVF. IVF. Full stop.
But another thing, kindly come to page 60, and actually P5. This is another Millard medical certificate. Kindly see Millard page 61.
Subsequently, the petitioner has contacted another doctor, namely Dr. Devdeep Das, on September 2025, on 8 September 2025.
Kindly see page 61.
And on examination of the petitioners, the doctors have opined that the patient is clinical fit as per all reports and examination. No
apparent
cardiac abnormality. Opinion regarding IVF should be taken from urologist.
No, my lord, gynecologist.
Gynecologist within bracket Dr. G.B. Datta, as age is importance for IVF. Inappropriate. Achha.
For
Age is
IVF.
Inappropriate for IVF. Huh? Cool. Then you went to the this G.B. Datta? No.
Yes, then G.B. Datta is the previous one.
Yes. Then what has happened? Then
we went and Millard, nothing was done. Then
no, where is the age proof of the wife?
yes, kindly see Millard.
Where is the age proof of the wife?
Yes. Kindly see Millard, page 15. This is the certificate of marriage.
15.
Yes. (16) and 17 are the Aadhaar cards of both the parties.
As per the document,
date of birth is 9th October 1970.
Disclosed by the petitioner. The age of the petitioner number 2, wife is the petitioner number 2.
Yes.
Age of the petitioner number 2 is 52 years. Age of the 52 years. The counsel for the petitioner submitted that as per 21, give the act. As per section 21G of the Assisted Productivity Technology Regulation Act 2021, the clinics shall apply the assisted reproductive technology services to women above the age of 21 years and below the age of 55 years. To a man above the age of 21 years and below the age of 55 years. Counsel for the petition submitted, though the husband, that is the petition number 1, is above the age of 55 years, but the petition number 2, the wife, is below the age of 55 years, and as such, she can be allowed to go for the IVF procedure. Counsel for the petitioner has relied upon the judgment in the case of Shamoli Shah and another versus State of West Bengal and others, passed in WPA number 23776 of 2024, dated 22nd November 2024, wherein the coordinate bench of this court, taking into consideration of the age of the wife has allowed the petitioner to get the benefit of assisted productive technology as one of the parties qualified on the upper age limit stipulated in section 21G, irrespective of the fact that the other spouse does not. The net concept for the petitioner has further relied upon the judgment in the case of Sudarshan Mandal and another versus State of West Bengal, passed in WPA number 9232 of 2024, dated 26th of April 2024, wherein another coordinate bench of this court granted liberty to the petitioners to approach the respondent number 4, an assisted productive technology clinic, for obtaining the service authorized of the said clinic for the purpose of employing assisted productive technology service in order to conceive child. Full stop. The petitioner has further relied upon the judgment in the case of Sanchita Ghosh and another versus Union of India and others, reported passed in WPA number 12154 of 2023, dated 8th April 2024, wherein the coordinate bench of this court by interpreting section 21 within bracket G, has allowed has held that the petitioners will be entitled to have the benefit of assisted productive technology services and can approach an appropriate clinic for having such services, in view of the facts that one of the two spouses, that is the petition number 1, qualifies on the upper age limit as stipulated in section 21 in the bracket G, irrespective of the fact that the other spouse does not so qualify. The petitioner has further relied upon the judgment in the case of Union of India versus Devyani S, passed by the Honorable Division Bench of the Kerala High Court in WA number 209 of 2025, dated what is the date of the Kerala High Court judgment? 6/11/2025, wherein the Honorable Division Bench of the Kerala High Court relied upon the judgment passed by the coordinate bench of this court, have agreed with the findings of the learned judge and classification of the married woman and a single woman differently when they have approached the ART clinic, either as one amongst the commissioning couple or as a single woman, would put married woman at an unfair disadvantage when compared to the single woman. Consider the submission made by the counsel for the petitioner for the judgment passed by the coordinate bench of this court as well as the division bench of the Kerala High Court, and the document relied by the petitioners in the present case. This court find that though the petitioner number 1, being the husband, is a 57 is the upper age limit, but the petition number 2, that is the wife, is within the age limit as prescribed under 21G of the Assisted Productive Technology Regulation 2001. Thus, 21G. Which one? Now that I am as the wife is the age of 51 years, considering the above, this court find that the petitioner number 2 is entitled to avail the facilities of ARTS. Accordingly, the respondent, who is the respondent? Respondent number?
Respondent number 4.
Accordingly, respondent number 4. Respondent number 4 is directed to provide such facilities to the petitioner within a period of 4 weeks.
Process shall start. Yes.
4 weeks. Respond to avail to eligible the ATS, and the respondent number 4 is directed to provide such facilities to the petitioner within a period of 4 weeks from the date of receipt of this order. Anything further?
No. I'll get put to the lordship.
The writ petition is disposed.
I'll get.
We have filed our instruction like kindly record.
Instructions filed by the state be kept with the record.
Grateful, my lord.
ऊपर आते हैं, हाँ? Next.
Item number 12.
Yes.
For the private.
Huh? Is from Patna High Court. Yes, what is the matter?
May I please, your lordships? I will assist your lordship online.
Yes, no problem.
In item number 12, lordships.
Yes.
Lordship, it's a trademark matter in which the respondent number 3 had filed an application for registration of his trademark, my lord.
But how the trademark matter will be here? There in the High Court, there is already a trademark.
Yes, my lord. I am against the order dated.
Objections, my lord. Firstly, my lord, this will go before the IPD division, and secondly, my lord, there is a specific statutory provision under section 91, my lord.
That I will go subsequently. Let this. Yes, the IP. You go to the IP division, sir.
Lordship, just one issue. One issue which we want to point out is that we are against the order dated 4th of January 22, where our the registrar trademarks, he has actually passed an order where our opposition has been abandoned on one simple ground, which has been argued by respondent number 3 before the deputy registrar, that we did not furnish the proof of service of evidence of opposition, my lord. If 4/1/2022 order can be seen once, my lord, our only simple case was.
Yes.
My lord, our only case was that we had engaged our previous attorney, the agent, my lord, who had been processing our application for opposition. He in his office, my lord, there took place an occurrence of fire in the year 2017.
Whatever it may be, sir, whatever it may be, but in the High Court at Calcutta, there is a IP division has been constituted, and all the IP matter has to go to the IP division. If you want, I will give the leave to. I am releasing only, and you mention before the appropriate bench, and it will be listed
Lordship,
before the appropriate bench.
very humbly, Lordship, the IP division matters, Lordship, is under the Acts, Lordship, and the petition is a writ petition, Lordship, for another residuary group, Lordship.
Residuary group, but I cannot take the residuary group part, which is not in any of the
individual.
Residuary group, it will go before the IPD.
Lordship, IPD, there is no writ petitions. There's
Just 10 days before also I have sent the matter.
Yes, madam.
Lordship, then very well, Lordship. Lordship will and I'll pray for a sign.
I am allowing you. I am delisting the matter from this court, and you mentioned before the court.
I'm so sorry, my lord. I had no idea of the roster there. I'm from Patna, though. Therefore, my lord, I'm so sorry.
No problem.
My lord. Let me place it, my lord.
This court find that the matter is connected with the intellectual property dispute matter. Accordingly, this court is not having the determination to hear the writ application. Accordingly, WPA 2142 of 2023 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Grateful.
Deeply obliged.
Next.
I'm appearing for the petition. In this matter, a single person is doing.
Yes. What has happened?
Your lordship directed me to inquire whether Canning 2 as well as Shimontala police station falls under the jurisdiction of Baruipur police district or not. Under Baruipur police district.
Both.
Yes.
Canning also.
Good. I marked.
Javantala police station. No, Canning police station is different. Javantala police station different.
Two police stations are different, but under one SP.
One SP.
One SP. Superintendent of police
of the same.
Of the same. Who has been made a party here?
Where is PW? This dependent respondent 3. Respondent number 3.
Respondent number 3.
Okay.
Superintendent of Police, Baripur Police District.
The grievance of the petitioner in the present application is that the petitioner is the aspiring candidate for the post of data entry operator.
Data entry operator at PSK Canning 2.
Yeah, data entry operator as
At PSK.
PSK.
PSK. Bangla Sohayok Kendra.
PSK. Canning, that's
2. Canning 2 block.
Block. Full stop. Counsel for the petitioner submit that the petitioner came to know one person, the private respondent, he is a party here.
Yes.
The
Respondent
private
number 6.
respondent, namely, private respondent being respondent number 6, namely, Khokan, Khokan, Khokan Paidia, Piyada, Paida, is appointed as data entry operator in Canning 2 video having this is a voter's identity card.
Yes, epic number.
Having epic number Z capital U capital B capital 1928260.
19262.
Yes, 1926260.
Yes.
1926260. Okay, not 8. Huh? And the same person is been appointed as
Osman Piada.
No, as what? Same data entry?
As civic volunteers.
As civic volunteers.
Under Jibantala Police Station.
As inverted comma Usman 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 Paidia under the
Jibantala Police Station.
Jibantala Police Station.
Voter identity.
The Jibantala Police Station having the voters identity epic number
ZUB 1417179.
17. Police. The contention of the petitioner is that Khokan Paidia having epic number ZUB 1926260 and Usman Padia having epic number ZUB 121422179 is the same person.
Is the same person.
Same person.
One point is required here to mention. Up to 2024 voter list, his name appeared. Recently in 2025 voter list, his name is not appearing, that name. Up to 22.
He further submits that Land Council appearing for the petition further submits that up to 2022, the name of Padia, Khokan Padia,
Osman
Piada is appearing in the voter list, and subsequently his name is not appearing in the voter list of the said area. He submits that one person in the name of in two names is working in two places. That is as data entry operator in Canning 2 video and civil volunteers in
Jibantala
Police Station. Due to which the petitioner has been deprived for getting the said post of data entry operator in Canning 2. Considering the submission made by the counsel for the petitioner, this court find that the writ petition can be disposed of only obtaining report from the superintendent of police Baraipur Police District to ascertain whether the respondent number 6, namely Khokan Padia, is the same person being the name of Usman Padia, who is working as a data entry operator in Canning 2 video office, as well as the civic volunteers in the Jibantala Police Station. The superintendent of police Baraipur Police District is directed to inquire into the matter and to submit the report before this court on on 28th of January 2025. Let the matter 2026. Let the matter appear on 28th of January 2026 for submission of the report by the Superintendent of Police, Barapur District.
Point is, the attendance register.
Let it come. Full stop. The office is directed to communicate this order to the Superintendent of Police for compliance. Next.
May I please, Your Lordship? I am for the private respondent number 8 and 9.
Yes, what is your grievance, sir?
My Lord, in this matter, I have challenged the license granted by the CMOs to a private nursing home run by the respondent number 7 and 8 in the present 8 and 9. Sorry, I'm stand corrected. My Lord, 8 and 9 in the present petition. Now, my Lord,
who are you?
My Lord, I am a person residing just adjacent to the nursing home.
Adjacent to the nursing home.
Adjacent to the nursing home. And because of the operation nursing home, my Lord, my rights of free air and all the things are being violated. And my Lord, my contention is that the nursing home is being illegally run. Why? Because, my Lord, for granting a license to a grade 1B nursing home, the primary requirement of the CMO should be to consider the building requirements of the nursing home, whether the nursing home is having a valid sanction plan or whether the building is in order, whether all the documents are in order. Now, my Lord, my contention was that the building was not in order, and the sanction plan which has been obtained from the concerned Pradhan of the Gram Panchayat, it was not it was not obtained in a right manner. Now, my Lord, on that ground, I had already filed a writ petition. Now, my Lord, during the pendency of the writ petition, I informed the CMOH that you should not grant license to the nursing home because, my Lord, that at that point of time the nursing home was to be the CMOH was about to grant license. You should not grant license to the nursing home because, see, the building is not being built in a proper manner. Now, my Lord, that representation was not considered. After that, my Lord, I filed a representation before the CMOH. That was considered. CMOH says, on the basis of a survey report of Raidigi Gram Panchayat, says that the nursing home is all right. There is no building irregularities of the nursing home. Now, my Lord, subsequently, my former petition before the Panchayat bench had been disposed of, and, my Lord, with this order, my Lord. My Lord, may kindly see, my Lord, this is after filing of this petition. My Lord, may kindly comes to directly paragraph numbers 9 and 10, which is the observation of the court, my Lord. Well, I will not take a lot of the submission, my Lord, the observation of the court, which is binding upon the parties.
So what has happened after this?
Now, my Lord, after this, my Lord, the SDO is considering the matter. Now, my Lord,
was caused. Inspection
no inspection has been caused, my Lord. The SDO is considering the matter. Now, my Lord, now the binding observation, which I may read out from paragraph numbers 9 and 10, it is not in dispute. My Lord, the coordinate bench says, my Lord, the honorable coordinate bench says that it is not in dispute that the plan has been sanctioned by the local Gram Panchayat in favor of respondent number 7 and 8. Be that as it may, Annexure 15 to the affidavit in opposition shows that only 7 decimals of land recorded in the name of one Shiv Prasad Patro has been converted from Shali to Vastu. However, there are no such documents showing conversion of land from Shali to Vastu measuring 5 decimals of land recorded in the name of Shiv Shankar Patro. The state in the present petition through the BDO Mathurapur 2 development block has filed report which shows deviation in construction from the sanction plan. Well, this report is annexed with this petition also, my Lord. In such circumstances, the issues raised by the petitioners need to be dealt with by the authority concerned. So, my Lord, this observation is staring at their face, my Lord. Now, my Lord, kindly comes to the representation that has been disposed of by the CMOH, my Lord. My Lord, my report.
That's why kindly come to the paragraph 10.
My Lord, the
Paragraph
SDO was
10 of
directed
yours.
to consider, my Lord.
Paragraph 10. Paragraph 10, this court has given four cause the inspection. Inspection is carried out or not?
Inspection has not been carried out by now. Not been carried out. But my
It shall be heard a notice. Whether notice was given to you, a hearing of the
No,
notice?
no, nothing.
No notice was given. Material transferred during the inspection. So question of 3 does not arise. Entire access will be completed within a period of 3 months. What is the date of the order?
Well, the date of the order
October.
is 28th October, my Lord.
Yes, October, November, December, January. So still it is premature.
No, my Lord. what I say, my lord, in
What
view of,
what you have prayed for in the present?
my lord, I have prayed for cancellation of license, my lord, but
correct, but it's a premature 3 months. When the 3 months will be
my lord,
completed?
my lord, may I say this, my lord? Well, the CMOH has considered the survey report of Raidgi Gram Panchayat.
Whatever it may be, sir.
Well,
One court has passed an order giving 4 directions: cause inspection, hearing.
But my lord, paragraph number 9, Shalitu Bastu, the court has
Maybe,
said,
but the court has taken into consideration and passed the order.
my lord, may kindly comes to page number 150 for once, my lord, for my satisfaction. Page number 150, my lord.
Yes.
My lord, point number 1.
Yes.
The document for conversion of character of land from Shali to Bastu, which has been duly issued by BLLR or Muthurapur, dated on such and so, has been provided.
Correct.
My lord, this has been negated by the read court, my lord. This has been negated by the read court, paragraph number 9.
Correct.
Now, my lord, what I seek an interim protection, my lord, let the SDO carry it out. I seek, my lord, the license may, they are running the nursing home business, the license may not be renewed further because of the observation of the learned, because, my lord, that observation is staring at their face that they have not appealed from that observation. So, my lord, the license may not be renewed in their favor.
But
the SDO
again the questions come in the earlier round of writ petition. This court has taken into consideration and passed certain direction.
But the CMOH part has not been considered.
Yes.
The activities of the CMOH, I could not have challenged before that court, my lord.
Correct, whatever it may be, but now the 4 directions have been given and 3 months has been given. This is October 2025. To October 2025. So the 3 months has not yet been completed. 28th of January it will be completed. So you have filed the premature writ petition.
No, my lord, what I say, my lord, because the building
one by one you filing a writ petition, whether the all the things can be taken. Why you not taken that plea and the earlier writ application?
Against CMOH, I cannot take a plea against in the Panchayat bench, my lord.
Then,
so, my lord, that is the reason why, my lord, I have approached before your lordship, my lord. Because the CMOH should not, because, my lord, the CMOH has considered all the documents, all the documents have been negated by the
I can only pass this order, complying the direction passed by this court within a stipulated period. That's all, nothing. Or you want what you want. I cannot pass any further order. There's already the direction by this court.
My lord, not upon the CMOH, my lord.
Once the matter is session before the authority.
The only direction that I want then before your lordship.
What?
My lord, my representation, the CMOH is disposed of. My lord,
Where is the representation?
My lord, my representation is appearing at page number 112. That is a legal notice, my lord, disposing it of 115 has been.
Then again you.
My lord, let that be set aside and let CMOH consider in light of this order, my lord. Because all the documents has been negated by the read court. Let that be set aside and in light of this order, CMOH may consider.
Sir, kindly come to your paragraph 3 subclause A. Paragraph 3 subclause A.
Yes, my lord, over the Shali land, my lord, in light of this order.
Come to the paragraph 113.
Paragraph 3, my lord, 113, yes, ma'am.
Yes, the nursing home building G+2 construction, Shali land, so and so, so and so. This is already the subject matter of the inspection. Correct. Now can it be the building itself be built by the living requisite so and so, so and so, that already the court has dealt with. Now come, non-obtain the relevant licenses required for the multi-speciality. You at the time of hearing, you go and you tell all the things before the authority.
But before the SDO, my lord, but CMOH will never consider. My lord, then my lord kindly sets it aside. After the SDO's report, I can go before the CMOH kindly gives me that liberty because CMOH has already considered this. CMOH also already considered this and passed page number 115 order, my lord.
What?
Page number 115, my lord, kindly comes. 115.
Yes.
But this order has already been passed by the CMOH.
What order is passed?
My lord, 1, the document for conversion of character of land from Shali to Bastu, which has been duly issued by BLLR of Muthurapur, South 24 Organs, dated on so and so, has been provided by the nursing administrator representative to the inquiry committee members. 2, the setback distances, CMOH has been satisfied, my lord. The file license, everything has been satisfied.
So this is the 5th of June 2025.
Correct. Kindly give me a liberty.
What
And
is your name?
well, I am Uttam Kumar Biswas, my lord.
What is your name?
I am Uttam Kumar Biswas.
Uttam Kumar Biswas. This is the 5th of June 2025. And the earlier writ petition was disposed of when?
My lord, 28.
So why this has not been brought before the court?
My lord, 28 October after filing of this writ petition, my lord.
How you can say, sir? The order was passed on 25th of October
28th of
2025.
October, yes, my
And
lord.
the order of the health office.
5th June 2025, my lord.
Then June 2020, before that, 4 months before.
After my lord, 5th June 2025, and this is 28th October.
October is first or June will be first?
June 25, my lord.
Okay, this
And
order
it
is
is also
not.
October 25.
June will come first or October will come
June will
first?
come first, my lord.
Then
June the order has been
when
first.
the order was passed, this order was with you. You have
This was-
suppressed this.
No, my lord, CMOH was not a party.
Why
in
you
the
not brought this on? Why you
CMOH
have
was not a
supplemented?
party in the Panchayat writ petition, my lord.
The petitioner has filed the present writ application, praying for a direction, praying for setting aside the memo issued by
CMOH was not a
issued by
party in
the
that writ petition,
OSD
my lord.
and
Kindly
Deputy Director of Health Services dated 5th of June 2025. 2025. Full stop. This court find that prior to filing of this writ application, the petitioner has filed earlier writ application being WPA 3/2022 of 2024 within bracket Uttam Kumar Biswas and another versus State of West Bengal and others. And the said writ petition was disposed of by this court by an order dated 28th of October 2025 by passing the following order. I record paragraph 10. Set out, huh? Paragraph. No, paragraph 10 and 11 both. 10 and 11. Full stop. Now the petitioner has challenged the order passed by the OSD and Deputy Director Health Services Administration dated 5th June 2020. This court find that
Well, CMOH order was already under challenge.
when this court was in session for hearing of WPA 3/22 of 2024, this order was with the petitioner. But the petitioner has suppressed the said order and not brought the notice of this court before this court when this court has disposed of the writ application being WPA number 3/2022 of 2024. Accordingly, this court find that the petitioner has not come with a clean hand, and the order which has been challenged in the present writ application was prior to the order passed by this court on 28th of October 2025. Thus, the writ petition is dismissed.
My lord, kindly sees the date when my writ petition was filed, my lord. Kindly sees this order was already under challenge before your lordship, my lord.
Yes, next.
Yes, my lord, in item number 15 and 16, I beg to appear for the petitioner, my lord.
Yes.
Kindly to file the affidavit.
My lord,
It is not within time.
just now I have received the opposition, my lord. Yeah, just now, my lord, it requires some time to file the reply, my lord.
In both.
Both, my lord. One more humble submission, my lord. I have not received any opposition from the state authorities till date, my lord. So,
You have given your copy also.
Oh, sorry.
Who is appearing for the state?
60.
There is any difference?
Same party is in the. What is the matter about?
My lord, pursuant to the complaint lodged by the private respondent, my lord, the voter ID card of the petitioner has been changed, my lord. The relative's name has been deleted, and
So you will file the affidavit in 16.
And-
Have you filed? Okay. Respondent number 6 and 7 have filed their affidavit in opposition. 4 and 5 in item number? No, there are difference. 4 and 5 in item number 15. Huh? No, item number 15, 6 and 7. And 4 and 5 in item number 16. ठीक है? have filed their affidavit in opposition after serving the copy to the Land Council for the petitioner. Council for the petitioner prays for time to file reply. Let affidavit in reply be filed by
2 weeks, my lord.
within 2 weeks. List the matter on 3rd February under the same heading.
Grateful, my lord.
Next.
Should I appear?
Yes, sir.
Directors filed a report as regards non-fulfillment of the post of chairman, judicial member, and the administrative administrator. What difficulty has arisen is that actually no petition copy was served in the Minister of Law and Justice.
I'm not
I have
petitioner,
come
Lord.
with the
State.
I have come with the report. I persuaded the DOPP yesterday and I have got the instruction. Now, explanation is that it has to be apprised to your lordship. The law has undergone a change. Initially, the recruitment process was initiated by the Honorable High Court, subject to approval of the state government, and proposals were there. Administrative Tribunal Act 85 was amended and rules were amended. And then it was assigned to the Ministry of Law and the Department of Personnel and Training, Government of India. Division bench of this Honorable Court passed a judgment, and I had the privilege to appear for the. Now, this was actually to be done by selection of the search selection committee by the Honorable High Court by constituting a committee, and the committee shall decide the issue, and they refer to the Honorable Governor, and the Honorable Governor may forward it or may recommend it. Now, that is the case that the Honorable Governor has forwarded it. Why it is not being appointed or approved by the Department of Personnel and Training? That is the sole question. Answer is that there was a constitutional court's
order
judgment pending on the Supreme Court challenging the constitutional validity of the Tribunal Reforms Act, and it was struck down on the ground that it is violative of the earlier judgment of the Supreme Court. So the guidelines which is framed now, that has to be assessed and followed by the DOPT, and that is what is exactly the instruction. It will take some time.
So now what the union is doing now?
Hello?
What the government is doing?
Yes, I am answering. This is the process. Kindly see paragraph 5. Instruction is given. Paragraph 11, Roman 5 and 6. 5.
আমি তারা মামলাই হচ্ছে না শুনলাম প্রত্যেকটা আগে তো স্টেট না থাকলে মামলাই হচ্ছে নিবি তো না
Last 2 lines.
Yes.
So kindly give us some time, and the report may be taken on record.
Learned ASGI, appearing for the Union of India, has submitted the report. Let the same be kept with the record. Full stop. As per the report, the further course of action on the proposal of the state government will be taken immediately once the decision on the directions of the Honorable Supreme Court passed in WP number 1018 of 2021 is finalized. And subsequently, the orders of appointment of chairperson / members will be issued to the state government of West Bengal after obtaining the approval from the competent council. ASGI prays for some time for taking decision by the government. Accordingly, case is adjourned. Accordingly, for the time being, the case is adjourned for 3 weeks.
For 4 weeks.
For 4 weeks. This is the matter on 10th of February 2026 under the same heading.
Doctor, may I have a copy of the report?
Which?
State can have a copy of the
I
report.
shall give.
Grateful.
Please collect it from my secretary.
Grateful, Doctor.
Next.
Item number 18 and
19 minute I appear.
18 minute I am for the petition.
19 is a separate matter. I think it has been wrongly tagged.
No.
I mean,
18 minute petitioner has approached not because the benefits of not the Assisted Reproductive Technology Act has been denied to the petitioners on the ground that husband has crossed the age of 55 years. Although wife is within 50, she is 39. But no, it was the clinic has refused on the ground that husband, since husband is more than 55, benefit cannot be given to you. We have relied on a judgment of this honorable court where it has been held that if not the wife, any one of them is within age and the services doesn't relate to the other partner, it can be given. In this case, the husband shall take the GMAT from us, the wife shall take the GMAT from a sperm bank.
The age of the wife.
Wife is 39 within age.
39. What's
Within
the age
age.
of the husband?
57. 57 years. So, we submitted, your lordship recorded our submission. They were to make the submissions. We have relied on the judgment.
Kindly peruse, the re-petition prayer.
B, they are not pressing.
Yes.
B,
they are not pressing.
Ultraviolet is not pressed. That girl. According to me, after in view of this, this petition has been an infraction. Because your lordship kindly see the prayer C. Issue a read or read of or in the nature of manner directing the respondent authorities commanding the respondents to administer treatment of the petitioners. This cannot be. But there is no statement. The judgment relied on, there was a specific statement that I can forward the judgment to your lordship. This statement is not here in the present case. And in that judgment, your lordship, my lord has relied. There is a report from the concerned authority to that effect. That report is also not before your lordship.
Yes. Have you undergone medical expert report? Have you obtained reports?
No, that was not taken.
Huh?
That was taken. She is capable. The clinic has.
Where is that report? She is capable.
The clinic has refused only on the ground that unless the court permits, we cannot proceed.
Where is that?
Lord, page 27.
Need High Court order.
Page 27.
Need High Court order.
Yes, Lord. That is the only ground, Lord. They are not. Yes. That is the only ground.
Direct concerned authority to submit a report before your lordship. That was the judgment, my lord. My learned friend is relying.
Which judgment you are relying?
No. Judgment, I relied on the last day, my lord, I submitted.
Yes, but your lordship kindly pay the judgment.
Which judgment you are relied upon?
WPA 23776 of 24, my lord. My learned friend handed over to your lordship.
This one. Now the matter has been settled by the division bench of the Kerala High Court. The findings of this court has been upheld by the division bench of the Kerala High Court. Initially, the Kerala High Court has stayed the single bench order of the Kerala High Court, which they have passed the order in terms of the findings, taking into consideration finding of this court of the Justice Sina and Justice Bhattacharya.
Subject to correction without declaring ultravirus, I think.
No, yeah, that's it. Ultravirus he is not pressing on the very first day. And with regard to this, the court has already had one of the spouses within the age limit under 21G, they can go for the
for a case of borrowing. In case of borrowing.
My
lord, the prayer C is standing in the way. That is your lordship, my lord. Unless
your lordship will take care of that. We have said that wife is within age, and she only ground of refusal is that.
Pleadings.
Page 27.
No pleadings. With the judgment relied on, there is pleadings that this can be done.
But kindly see, petition. Who is the petition number 1?
Petition number 1 is the
petition number 1 is
husband.
Kindly come to prayer 1. You are
my lord.
And how the relaxation, see, the law now which has been settled, only the spouse means only one can be taken into consideration. So kindly come to the one also is defective. Relaxation. How the relaxation can be given to the petition number 1, which is over and above the age of the 21 and as per the 21G of the Act?
Relaxation part cannot be given.
Then
my case is not 21G is not a fetter in our case. The case that we have made out is
again,
that
the fetter this 21 is not applicable in the instant case to relax the condition of
Fine.
provision of petition number 1. Again,
the request has become infectious in
we say no. Kindly say, my lord, our case is that in view of
correct, I appreciate. Petition number 1 is the husband. Husband
Husband.
is having the overage
husband is
after
a,
57 years.
but there is no involvement of the husband in the process.
But your prayer is kindly see either you withdraw it or you amend it. It cannot be. Even prayer A and prayer B you're not pressing. Prayer A and B and C is with regard to the petition number 1
Lordship,
relaxation.
kindly ignore prayer A, kindly come to prayer C, my lord.
Yes.
Mandamus directing respondent authorities to administer the treatment
Ah.
as the fetter of 21G is not applicable in the instant case.
In
Now,
some
my lord,
place to relax and to relax the conditions of the provisions of to petition number 1. How?
relaxation is only so far, my lord, that both commissioning couple, they don't have to be, my lord,
No.
that is the interpretation of 21G taken by the clinic. But our submission is that 21G, if one of the commissioning couple is within age and the treatment only relates to her, in that case,
That I am also telling because it is not settled. If one of the couple is within the age of 21G, it can be allowed. But you are asking for the relaxation of petition number 1. You are not
relief
asking for the petition number 2.
relief can be molded
The ART and
in
the
226.
IPR.
Relief can be molded by your lordship, my lord. Only petitioners has been stated, my lord, but
can
there's the omnibus pair is also there.
Relief can be molded, but you are asking for the
I have stated-
relaxation. Now the relaxation.
I'll use a supplementary affidavit stating that I'll file a supplementary.
No, I have got submission. I'm intervening.
Yes.
It is well settled that when there is a statutory bar, without declaring this statutory bar as ultra vires, whether court can give any relief, and if relief is granted, in oblivion to this statutory provision, it shall be pardon curious.
Now the court has held that it's okay if both the parties are overage than the 21G as
Yes, yes,
21G,
yes, true.
the court cannot.
Yes.
Cannot alter the age limit. That's why I'm
But if
asking.
one of the parties,
If one of the parties
Yes,
is within
then it is
the
not a
age
bar.
limit, it can be.
but in the case, this case cannot be improved by supplementary affidavit because this honorable court has delivered 2 judgments. There is no scope for filing supplementary affidavit. It has to be, what has exactly fallen from my lord, has to be filed as application for amendment.
That's
But
why
I shall make a supplementary affidavit making my submissions. Your lordship,
you have to amend. Supplementary cannot amend. You have to amend the prayer.
not prayer relief can be molded by your lordship, my lord. I have said
But when,
treatment to the
when
petitioners.
when there is a problem, when there is a statute, you cannot. You are asking for the statute relaxation by statute relaxation. Court cannot mold that.
No, I'm not asking for relaxation, but I am saying that 21G doesn't apply.
See, sir, both the prayer you ask for, the B you not pressing, I am taking it granted
C.
you not. I will record that. But with regard to A and C, you're asking the relaxation of the petition number 1. Either
Lordship-
to amend this or you withdraw with the liberty to file a fresh as
Kindly see, kindly allow me to place the prayer once, my lord. There are 2 parts of the prayer. The first part can be granted. I'm reading. Declare 21G of the ART Act as unconstitutional, or in the alternative, issue a writ in the nature of mandamus commanding the respondent authorities to allow the petitioners to avail the medical remedy. Otherwise, yes, because the commissioning couple petitioners are coming within that. I am not asking from the applicability of the procedure to both of them. I am saying
or I can pass an order. The court is suggesting.
but I have to file an amendment application.
No, the prayer, do not prayer A if it is prayer.
No, kindly allow me. Kindly see the prayer. Kindly see the prayer. I'm reading.
Prayer A if
To avail the medical remedy, otherwise available to them, holding that the provision of section 21.
I am telling you, the court is ready to give the relief, but you have to mold the. You are
Kindly permit to use a supplementary, but I am not modifying the prayer.
amendment.
Amendment, I will have to file an application with the
Supplementary also.
the amendment application has to be heard by your lordship.
Amendment
Amendment writ has to be filed. since it's a matter of artificial reproductive technology act
39
passage
years
of time
age, there is a time 39 years age wipes the age.
39 years
So there is a
treatment.
Otherwise you withdraw, I will give liberty, file a fresh within a week, no problem. That will be that will be better to you.
I'll withdraw and file afresh. I'll
And you
instead of amending I'll come out with the amended prayer.
amended plan.
No, I'll file a fresh statement with modified
Okay.
prayer.
Counsel for the
এই
petitioner
প্রেয়ারটাতে তুমি
submit
petition
that
ask
there
করবে
is
না।
some technical defect in the
না amendment করলে ঝামেলা amendment
readings
application
and
file
prayer
করতে হবে writ
on
amend
the
হবে
petition.
তার
Accordingly,
থেকে
it
fresh
for
read করে দাও।
withdrawal of the writ petition with the liberty to file a fresh. Accordingly, WPA number 21719 of 2025 is dismissed. Brought liberty to file a fresh.
The morning, Mala, Mr. Dotto mentioned this matter, Your Lordship,
Right.
for extension of interview. Item number 26, my lord. Because 2 p.m. matter fixed.
Both item, not the last matter, item 18, 19, both.
The 19 is separate, Your Lordship. It is pertaining to passport.
Why it is been
It
tagged?
has been wrongly tagged.
wrongly tagged.
Why it is tagged? Okay. Item number 26 of file.
Well, other matters will not be taken up before this.
Tomorrow. Now, item number after item number 19 onwards, let us see if the 2 p.m. matter will be not be taken, then serially it will.
19 will be taken up. 18 has been done. I mean 19.
19. Who is for the other side? Nobody.
Nobody, my lord. Even then, I have communicated this order by post also, by speed post also, my lord.
So the matter is listed as item
No,
number
no, 26.
26. But none appears on behalf of the
I've served twice. Notice and also, my lord, no, communicated this order.
petitioner. Submit that. The interim existing interim order is till today and paid for extension of interim order. Consider the submission made by the counsel for the petition. Interim order is extended till 4th of February 2026 or until further order, whichever is earlier. Let the matter remain in the list.
Your Lordship, may I be allowed to mention a matter? There is an urgency I'm mentioning on behalf of the state respondent. The matter has been heard by Your Lordship.
Which one?
Your Lordship, this matter. This is not in the list. It was supposed to be appear on 13 January. In the meantime, Your Lordship, there is no interim order. In the meantime, Your Lordship, the petitioner has blocked the project property. And now they have
Why
also
you
sent
mentioning this time? Come in the morning hours.
The company.
or I get a notice from, my lord, the registering authority. They, my lord, say that there is a, yes, regarding determination of market value, there is an issue. And they say that there is a shortfall. They try to reopen that issue after 2 years under section 47 of the, my lord, 47A of the Stamp Act. And my lord, a hearing was afforded, and they ultimately, the first authority ultimately concludes that there is a shortfall and I have to pay a certain amount of money. From there was a appellate remedy provided under the statute. I preferred an appeal, and the appellate authority has rejected my contention, and that appellate authority's order is the subject matter of challenge before this honorable court. This is, my lord, the factual, my lord, backdrop. May I start with the, my lord, document, the registered, my lord, deed kindly comes to page, my lord, 6.
How the value has been assessed?
The value has been assessed based on the value which was there, the market value which was set forth in the deed, which was certified, but they don't take care of the exemption provision.
Assignment is with regard to the landed property.
No, with regard to copyrights. Copyrights. So, my lord, there was one company.
How the value has been ascertained?
My lord, valuation, my lord, in the deed we have, my lord, set forth. My lord, kindly comes to page 31. No, the deed starts at page 16, kindly comes to page 21. Clause 3. I am saved, my lord, because I understand why lordship posed this question, but this is what, my lord, the registering authority has also certified. So there is no variance between the market value. 9 crore is what I set forth. 9 crore is what the registering authority has certified. I'll show that also. Clause 3.1, lordship kindly takes: purchase consideration for assignment of the assigned rights by the assignee to the assigner shall be paid in the following manner, exclusive of any value added tax which will be separately reimbursed by assignee to assigner. INR 9 crores has been paid simultaneously with the signing of this deed with a demand draft number so and so, dated so and so, receipt of which the assigner hereby duly acknowledges. So the market value of these copyrights, the 16 copyrights which were the subject matter of the deed of assignment, was assessed at 9 crore by the parties. Now kindly, my lord, kindly comes to page 36.
Yes.
My lord, middle of the page, lordship will see a certificate of market value.
Yes.
Certified that the market value of the property, which is the subject matter of the deed, has been assessed at 9 crores.
Correct.
Certified that the required stamp duty of the document is 54 lakhs and the stamp duty paid as impressive rupees 300. My lord, this 300 is by reason of the exemption provision in the Stamp Act. I'll show that.
So deed has been assessed 9 crore. Stamp duty is assessed 54 lakhs.
And payment
It is paid 3 lakhs
because of the exemption.
Correct.
Now, my lord, there is a certificate of admissibility of the document also, because one of my grounds, my lord, of attack would be that they are trying to reopen or review, my lord, what has been, my lord, done by the registering authority in 2015. Admissible certificate of admissibility under Rule 43 of the West Bengal Registration Rules. Admissible under Rule 21 of the West Bengal Registration Rules, duly stamped under Schedule 1A, Article 23 of the Indian Stamp Act. This is, my lord, the relevant schedule under which I am entitled to that exemption. And because of this, my lord, I was not required to pay the entire sum of 54 lakhs, but only 300 rupees was charged as stamp duty. Registration fees I paid entirety.
Yes.
Now, my lord, kindly comes. Huh?
Kindly accommodate me for the table that I'm not ready.
I'll take some time.
No, I'm not ready in the matter. So, I find the interim order is till 9th. My lord, kindly extend it and allow us to come back any day in next month.
Next month.
If lordship permits, I can, my lord, take your lordship through the, if lordship permits.
I understand that.
Because we have been very lucky. Lordship was very kind to give us this time, my lord. We know, my lord, how much pressure, my lord, we have in this court, my lord. All of us realize that.
I want to waste my lord's valuable time, my lord. He'll make my submission. I'll take time, no use of it, my lord.
Because in any event, when we start on the next day, again, I'll take time, my lord. Maybe his opportunity would not come, my lord. And we have time only till 3. If lordship permits, I can continue. I leave it to your lordship.
Allow us to come back. That will be prudent, my lord, but we must not wait.
How much time will take?
Till 3.
1 hour.
Yes.
How much time you will take?
You will have to come back and assist.
No, how much?
Not like my lord, not much, my lord.
Interim order is there.
Interim order is there.
Till 9/6.
It's a 2022 writ. I am enjoying an interim order, but I wanted, my lord, a finality to this, my lord, proceeding. That's the reason why we mentioned, my lord, last week of November, lordship said January. We were happy that at least we have a definite date and time.
You'll again have it.
And because we realize how much pressure, my lord, this court has, we realize other benches, my lord, are also similarly pressurized. my
All
lord.
benches, because of dependency of the.
Just that we don't want to lose this opportunity. But if lordship wants me to come back, I cannot really.
Okay, let it complete. I will fix another date for you, no problem.
My lord, I was at page 36, my lord. The certificate of admissibility, my lord, they rely upon Schedule 1A, Article 23 of the Indian Stamp Act. Now, pausing here for a moment, may I first show, my lord, Article 23, Schedule 1A of the Stamp Act. Copy good. My lord, I have prepared a short compilation of whatever provisions I'll rely, and I'll give a copy to my learned friend as well. 23. My lord, kindly comes to page 5. तुम वहां से बोलना. My lord, the exemption which I am referring to is at page 6 of that, my lord, compilation. My lord, this is part of Article 23. Lordship will find that at page 5, conveyance. And there is a next page, lordship will find the exemption provision, assignment of copyright by entry made under the Copyright Act 1857. Then there is a reference of section 18. This is section 18 of the Copyright Act. Now, my submission would be, my lord, that under section 18 of the Copyright Act, there is no requirement of any entry. And in any event, I'll show the document by which I had, my lord, requested the registrar of copyrights to make that entry pursuant to the registered deed of assignment. So this is the provision which was invoked by the registering authority, and I was charged only rupees 300 and not the entirety of 54 lakhs. Now, my lord, kindly comes to.
Where is the exemption?
My lord, from the act or from the document?
This act, this stamp act.
My lord, page 6, my lord, kindly comes to page 6 of the compilation, serial number A, assignment of copyright
Entry number date.
by entry made under copyright. Kindly sees the heading, my lord, exemptions. So these are the categories of exemptions. One such category is an assignment of copyright.
Okay. Exemption. Okay.
And this falls under the broader category of conveyance, because an agreement is also deemed to be a conveyance within the meaning of the Stamp Act. So this is the, my lord, exemption provision. Now, my lord, kindly comes to page 40, my lord. This is my application to the registrar of copyrights.
Yes.
Application in form 15 for, I'm reading, my lord, the reference part. Application on form 15 for registration of changes in the particulars of the registered copyright number for the artistic work Rasoi.
Rasoi
refined soybean oil in the name of Imami Agrotech Limited. Then the first para, my lord, number 1. By virtue of deed of assignment dated September 25, 2014, company name and address has been changed from Rasoi Limited, an Indian company of Rasoi Court so-and-so, to Imami Biotech Limited, West Bengal. My lord, then, my lord, in paragraph 2, lordship will find few bullet points. Kindly sees the 4th bullet point. I have given the notarized copy of the deed of assignment dated so-and-so for change of name and address to read as Imami Biotech. Then my last paragraph of that page, at page 40, kindly proceed further in the matter and finally record the name and address of the proprietors to read as Imami Agrotech Limited, an Indian company of so-and-so. So, my lord, Rasoi gets changed to Imami by virtue of the deed of assignment. Now, lordship kindly comes to page 44. This is the, my lord, form in which, my lord, I had made that application. This is the statutory form in terms of rule 70, my lord, of the copyright rules. Application for registration of changes in the particulars of the copyright entered in the register of copyrights. In accordance with Rule 71 of the Copyright Rules, I hereby apply for registration of the changes in the particulars of the copyright entered in the register of copyrights. Well, as a assignee of copyrights, this is what I can do under the provisions of the Act, read with the provisions of the rules. And I made this application with the requisite amount that I was required to pay.
Yes.
And my lord, this application is a bulky application. 44 is the first page. The statement starts from 45. Particulars of all the copyrights are mentioned. I need not trouble your lordship with all this. Now, lordship kindly comes to page 136.
Yes.
My lord, this is addressed to my accountant, chartered accountant. I am directed to refer my consultant, I'm sorry, not chartered accountant, who was doing the copyright work. I am directed to refer to your application dated 29th April. This is the one which is at page 40 on the subject cited above, and to state that on examining the application, the following discrepancies have been observed.
Yes.
My lord, there is no observation in black and white. Lordship will not find in the printed, my lord, form. There is no observation that there is a deficiency so far as stamp duty is concerned. But lordship will kindly come to the foot of that page 136. There is a handwritten note. Note: your stamp duty is not sufficient in the deed of assignment, keeping in view the payment of purchase consideration. Now, the first point I wish to argue is, my lord, whether the copyright authority has jurisdiction, or the registrar of copyrights has any jurisdiction to raise an issue with regard to stamping under the Copyright Act. Because I'll show the provision of the Copyright Act now, my lord. That is again in that compilation. Kindly comes to, my lord, section 18 first.
Now you have challenged the order of the
appellate authority, which is, my lord, under the Registration Act. But, my lord, since it appears though it's not there, stand in the my lord opposition. After this, my lord, there was a gap of, my lord, around 2 years, and they say that there was, my lord, some observation made by the accountant general. Based on those observations, the registering authority reopened the issue of valuation of that instrument, that deed of assignment, and then they determined that there is a short payment of stamp duty. It should have been 54 lakhs in total and not 300 rupees. The exemption should not have been granted. That is their case in the opposition, and therefore they have rejected my contention both by the first authority as well as the appellate authority. I'll come to the appellate authority's order, my lord, shortly thereafter, my lord. My lord, if lordship has the, my lord, Act, Copyright Act, page 10, my lord, will find, lordship will find section 18. This is the provision regarding assignment of copyrights.
Yes.
The owner of the copyright in an existing work, or the prospective owner of the copyright in a future work, may assign to any person the copyright either wholly or partially, and either generally or subject to limitations, and either for the whole term of the copyright or any part thereof, provided that in case the assignment of copyright in any future work, the assignment shall take effect only when the work comes into existence. My lord, there are number of, my lord, provisos thereafter. These are really not relevant for this purpose, so I am not, my lord, placing it formally. Then, my lord, kindly takes 18(2), where the assignee of a copyright becomes entitled to any right comprised in the copyright. The assignee, as respects the rights so assigned, and the assigner, as respects the rights not assigned, shall be treated for the purpose of this Act as the owner of the copyright. So I step into, my clients step into the shoes of the owner. Correct. And the provisions of this Act shall have effect accordingly. Then 3, in this section, the expression assignee as respects the assignment of the copyright in any future work includes legal representative. So it also includes legal representative. Now, my lord, the mode of assignment, that is provided in 19. No assignment of the copyright in any work shall be valid unless it is in writing signed by the assigner or by his duly authorized agent. So this is, my lord, the requirement. It has to be in writing. So I have a deed, and it has to be signed by the assigner. The previous owner, Rasoi, had signed the instrument. My lord, rest of it, my lord, from my lord section 19 is really not relevant unless my learned friend argues, my lord, anything on 19. I'll come back, my lord, when I am in reply. So this is not important. The only other provision, my lord, which is relevant is page 12. Lordship will kindly come to page 12. Sections 44 and 45. 44 says register of copyrights. There shall be kept at the Copyright Office a register in the prescribed form to be called the Register of Copyrights, in which may be entered the names or titles of works and names and addresses of authors, publishers, and owners of copyright. So once there is an assignment, the assigner, yes, and such other particulars as may be prescribed. Then, my lord, 45, entries in register of copyrights. The author or publisher of, or the owner of, or other person interested in the copyright in any work may make an application in the prescribed form, accompanied by the prescribed fee, to the registrar of copyrights for entering particulars of the work in the register of copyrights. This I have done, my lord. I showed that document at page 40. My lord, the proviso is really not important. Then, my lord, subsection 2 says, on receipt of an application in respect of any work under subsection 1, the registrar of copyrights may, after holding such enquiry as he deem fit, enter the particulars of the work in the register of copyrights. This has not been done in my case because the registrar of copyrights has not entered it. Yes. So these are, my lord, the only provisions which, according to me, are relevant. There is one rule, my lord, now after the act, kindly comes to page 13 of the, my lord, compilation. This is part
what
of
are the documents required for change of assignment?
What are
the rules?
I'll show, my lord, from the rules itself. Kindly comes to, my lord, the rule. This is the relevant, my lord, provision apropos lordship's query.
Yes.
Rule 70. And I have given all because there is not a single, my lord, document or not a single, my lord, letter issued to me that your assignment is not possible because you have not furnished this document. That is not their case. The only, my lord, grievance is that you were not entitled to exemption. You have got it registered at 300 rupees stamp duty paid. It should have been 54 lakhs. So there is a shortfall of 53 lakhs 70,000. 900. Figure in here. My lord, kindly comes to page 13.
Yes.
Rule 70, application for registration of copyright. Yes. Every application for registration of copyright shall be made in form 14, and every application for registration of changes in particulars of copyright entered in the register of copyright shall be made in form 15. Every such application shall be in respect of one work only and shall be accompanied by the fee specified in the second schedule in this.
I think whether it is before this court or it will be go to
Residuary, my lord.
Residuary or it will go to the IP.
No, it was entertained also, my lord, by the. Today, my lord, I don't have any other forum to challenge because I am challenging the appellate authority's order under, my lord, the Registration Act. I don't have any other forum. This is, my lord, therefore, my lord, it was entertained and the interim order was also passed in my favor. So, my lord, what Rule 70 or, my lord, the provisions 18, 19 and 45 require is, or it states is, my lord.
The first concern is that what the note they have provided, that is not in the purview of the registrar.
Right, that is one. Now, my lord, kindly comes to, after 136, my response at 138. Second paragraph. Regarding objection raised, we submit that according to the Indian Stamp Act, copyright assignment is exempted from stamp duty. So we refer to the provision. In view of the above, objection may kindly be waived and send us the order for change of name and address in the name of Imami Agrotech. Either they send me an order or they do that change in the register of copyrights by incorporating the name of the assignee, which is my client. Now, my lord, 139, lordship marks the date after 2 years, 27th of December 2017. This is important, my lord. At the top, lordship sees the form number. It's form 8 under sub-rule 1 of rule 5. Notice calling for objections relating to determination of market value under subsection 5 of section 47A of Indian Stamp Act. I pause here for a moment. This is, my lord, an exercise entirely dehots the provisions of the statute, entirely without jurisdiction. Why I say this, my lord? Because determination of market value was not in question. I had started with the deed of assignment saying that the set forth value was 9 crore, and I showed their certificate where they determined or certified the market value to be 9 crore. So there was no issue with regard to the determination of the market value. And 47A can only be invoked when there is, my lord, as an example, if I may cite, my lord, if I had, my lord, indicated in my deed that the market value or the set forth value according to me is, say, my lord, 10 lakhs. But the authority, while registering, says, no, you are undervaluing it. It should have been 9 crores. Then, my lord, 47A, my lord, provision can be invoked, and I would have been then charged with, my lord, stamp duty, not as per, my lord, 10 lakhs, but as per 9 crores. Then, my lord, 47A can be invoked. Otherwise, 47A cannot be invoked. Therefore, I say it's without jurisdiction.
But suppose, okay, rightly or wrongly, it has been registered. Stamp duty paid less or whatever it is. Subsequently, it is found the authorities not having the authority to determine, but the authorities have found that it is a less. Whether the authority cannot go.
My lord, my understanding, I knew this question would come. My lord, my understanding of the, my lord, provisions of the Stamp Act, this is not there, my lord, in the Stamp Act. There is only one provision, lordship, in, my lord, suits or arbitrations at the stage of impounding, presenting, my lord, when we, my lord, present a document as evidence. Then 33 to 35, my lord, those provisions, my lord, where, my lord, document, the judicial authority feels that it is not properly stamped or it is insufficiently stamped. Then at the time of the document being received in evidence, it is sent to the collectorate for the purpose of assessing whether it is properly charged or not, which is there in section 33 to 35 of the Stamp Act. But in 40, I am, my lord, relying upon their first notice. They invoke section 47A. My lord, before I place the notice, my lord, kindly takes the Stamp Act, my lord, 47A. What does it provide? My lord, it should be, my lord, page 2 of the compilation. This is a West Bengal amendment, my lord.
Yes.
Where the registering officer appointed, my lord, I am placing subsection 1, where the registering officer appointed under the Registration Act has, while registering any instrument, my lord, the nature of the different classes of instruments are mentioned, kindly turns the page.
5. On receipt of the reference under section 3 of authority specified under subsection.
Reasons to believe, my lord is reading, my lord.
5.
47A5. Lordship has gone to 47A5. Now, I wanted to show, my lord, 47A1 once, and then I'll come to 5, my lord.
Okay.
If lordship permits me, my lord. 47A starts with, my lord, the heading is instruments of conveyance, etc. undervalued.
Correct.
So there is no question of undervaluation in my case, because the figure was indicated in the agreement and they accepted that, certified that to be the market value. So there is no case of undervaluation. So first submission is 47A cannot be invoked. Then, my lord, I read subsection 1, where the registering officer appointed under the Registration Act has, while registering any instrument of, my lord, I am skipping the classes of instruments, kindly, my lord, comes to after sub H, has reasons to believe that the market value of the property, which is the subject matter of any such instrument, has not been truly set forth in the instrument presented for registration. My lord, kindly, my lord, allow me to pause. So if I have not set forth the market value in the instrument,
this part you have covered.
I am covered. Therefore, 47A cannot be invoked. He may, after receiving such instrument, ascertain the market value of the property, which is the subject matter of such instrument, in the manner prescribed, and compute the proper stamp duty chargeable on the market value so ascertained. And thereafter he shall, notwithstanding anything to the contrary contained in the Registration Act, insofar as it relates to registration, keep registration of such instrument in abeyance. So both the, my lord, criterias, that my client having declared the set forth value, which is the market value, and the registering authority not keeping the registration in abeyance, implies that, my lord, there was no case of undervaluation. If there is no case of undervaluation, my lord, 47A could not have been invoked by the authority. And it is not, my lord, a suo motu invocation. Lordship was relying upon 5. I will show another my lord, section of section 47A, which gives power to the registering authority to suo motu invoke.
Correct.
But they did not do that. My lord kindly takes, my lord, the...
That's why if any document, very first I said that the very first document is submitted and the authorities found that it is insufficient stamp and not market value is not.
They could have called upon me.
Immediately
Yes.
they called upon, or it will be kept abeyance unless and until you will. Not
Grateful, my lord. This is what 47A1 says. Yes, that's the law. Now, my lord kindly comes to, my lord, 47A3, and then I'll come to 5. My lord kindly permits me to place 2 also, because 3 is linked to 2. Where the market value of the property, which is the subject matter of an instrument, has been ascertained and the proper duty chargeable thereon has been computed under subsection 1, the registering officer shall, in the manner prescribed, send to the concerned person a notice calling upon him to make payment of the deficit amount of stamp duty within such time as may be prescribed. And if such person makes payment of the deficit amount of stamp duty in the prescribed manner, registering officer shall register the instrument. This is the example Lordship gave. Then 3, where the concerned person does not make payment of the stamp duty as required under subsection 2 within the time specified in the notice issued under that subsection, the registering authority shall refer the matter to such authority and in such manner as may be prescribed for determination of the market value. So 1, 2, 3 can be invoked only if there is an issue with regard to, my lord, undervaluation of or market value not being, my lord, declared properly in the agreement or not being certified by the registering authority when a document is being presented for registration. None of these cases, my lord, where, my lord, are attracted, my lord, here in my lord.
Your case is not covered under 1, 2, 3.
Then, my lord, kindly comes to 5. 5 is linked to again subsection 3. That is why, my lord, I wanted, my lord, to place 3. On receipt of a reference under subsection 3. My lord, where is that reference? In my lord, if I may put my submission in the form of a question. Where is that reference under subsection 3 to invoke subsection 5? And to invoke subsection 3, you have to say that the market value is not 9 crore. It is much more than 9 crore. You don't say that. So, my lord, the entire assumption of jurisdiction under 47A is wrong.
So, this page 36.
Page 36,
Page
yes.
36 issued by the Copyright Office is not forwarded to the registering authority.
My lord, this is issued by the registering authority, not copyright.
No, this one, page 136. 136.
No, it is not.
No, it appears that it is not. But I will show from their affidavit. They are not, my lord, they have not opened this, my lord, on the basis of this document. They have opened it on the basis of their accountant general's observation. They have disclosed it. I'll show that, my lord.
Okay.
They are not proceeding on this basis.
So they are not calling as a reference of this letter.
Yes, and that is why lordship will not find my writ petition containing any prayer against, my lord, the copyright, my lord, registrar, because otherwise I was entitled to make another writ petition or join, my lord, here only, that I would have prayed for a direction on the registrar of copyrights also. But I first want to get rid of this hurdle, because if I get rid of this hurdle, my lord, that is automatic. Because then, my lord, there will be a seal from the court that this exemption I was entitled.
Correct.
Now, my lord, kindly
So
comes.
That's why if it is not the copyright, okay, let me see what the Auditor General.
Yes, my lord, I'll show it. My lord. So let me just complete, my lord, 47A5. On receipt of a reference under subsection 3, the authority specified under that subsection shall, after giving the parties concerned in respect of the instrument referred to in subsection 1, a reasonable opportunity of being heard, and after holding an enquiry in such manner as may be prescribed, determine the market value of the property, which is the subject matter of the instrument, and the proper stamp duty payable thereon, and shall thereafter issue a notice in the manner prescribed directing the concerned person to make payment of such deficit amount of stamp duty within such time as may be prescribed. Now, side by side, lordship sees page 139, which is, my lord, invoking of 47A5. Whereas a reference has been made to me under subsection 3 of section 47A, read with subrule 1 of rule 4. My lord, the first, my lord, point of attack would be subsection 3 of 47A reference could not have been invoked without first under subsection 2 of 47A giving me notice that look here, the market value which was set forth is, my lord, less than what the actual market value is. So I did not get any such notice.
Correct. As per your submission, subsection 1, 2, and 3 are already been completed.
So 47A 5, yes, lordship, yes, lordship is absolutely correct. I need not then, my lord, take
now the only question, how the section 5
now, my lord, I will
reference is taken under section 5 of the
yes. Now let me kindly take the opposition once. My lord, one document I want to show from their opposition. Because why this was done?
That is the only crucial.
Yes, my lord, kindly comes to page 13 of the opposition. And then I will come to the two orders, my lord. First authorities order and the appellate authorities order. My lord, page 13 of the affidavit in opposition of respondents 1 to 3.
Yes.
My lord, kindly comes to page 13.
Page 13.
1-3, my lord.
Yes.
At the top, lordship will see para number 8, short realization of stamp duty on assignment of copyright. My lord, there I showed that figure should have been 54 lakhs. They charged me only 300. This is the deficit amount they say. 53, 99, 700.
Because
300 is paid. From the scrutiny of deed number so-and-so under so-and-so revealed that Messrs. Rasoi Limited assigned the right title and interest of over some copyrights in favor of Imami Biotech Limited in consideration of rupees 9 crore. The amount of stamp duty payable on assignment of copyright was assessed at 54 lakhs with a query number so-and-so. But the assigner paid stamp duty of rupees 300 only on the document. Since the assignment was not done by entry made under the Copyright Act, no exemption was allowable in this case. Kindly marks this, my lord, because this is one of their contention.
No,
assignment was not done by entry made under the Copyright Act 1957. No exemption was allowable. I will show, my lord, why they say this. My lord, kindly takes, my lord, that compilation once again and comes to, my lord, section article 23 1A. Page 6, my lord, of the compilation. Under the heading exemption A, assignment of copyright, there is an expression by entry made under the Copyright Act. Then the section is also mentioned, section 18. That is why, my lord, I placed section 18. Section 18 does not envisage any entry to be made in the register of copyrights by the registrar of copyrights, recording that there is an exemption or there is an assignment which requires an exemption. That is not, my lord, what section 18 says. I placed section 18 of the, my lord, Copyright Act.
Under the copy, yes, 14, section.
Section 18 does not, my lord, anywhere says. So and this, according to me, my lord, in the
recording of assignment will come only after the taking into consideration of the registered document.
But they say, my lord, the registering authority is now saying, or the at least their accountant general is saying, that since the copyright register has not done it by entry, therefore I have my registration, my lord, has to be on the basis of entire stamp duty, 54 lakhs. So, my lord, it's really a loop for me now. I am, my lord, faced with two authorities. My lord, one is sending me to the other.
Okay.
Now, please kar deta
hu. If this authority out have been recorded entries made, so question of this does not arise.
Absolutely. Then question of this does not arise. And that is, my lord, my letter to the registrar of copyrights, that please enter the details. That's because my deed was registered.
You registered, requested, but the request has been refused because of the stamp duty.
That is, my lord, a separate chapter. I will not invite your lordship to return any finding on that because that is not the subject matter here.
Okay. Next.
So, my lord, coming back to page 13 of the AO, yes. Audit also found that another deed of assignment of copyright was executed and registered between the same parties with a deed number 311/2015 for consideration of rupees 4 crores on which full stamp duty had been paid by the parties. But in the instant case, no such stamp duty was paid by the party excluding 300. So they are referring to another instrument between the same parties. my lord, keep that page open, my lord, page 13, and also sees page 157 of the writ petition. This is the document they are talking about. This is not, my lord, an assignment of copyright.
157.
157 of the writ petition. My lord, this is a deed of trademark assignment. I am not entitled to an exemption under the Stamp Act. And my lord, this deed number, lordship, I just now read the deed number 311 of 2015. Lordship will find that at page 195. That is the, my lord, deed of trademark assignment. At the top, lordship will find between the two, my lord, lines, endorsement for deed number volume 4 00311 of 2015.
Where from?
My lord, 195 lordship has.
Correct.
At the top, my lord, just after the seal, Government of West Bengal, there is a
311 of 2015.
Yes. So this is the deed they are talking about. This is not, my lord. So there, my lord, they are proceeding on two premises. One is that the entry is not there by the Register of Copyrights. Two, that a similar deed, which is an assignment of copyright, you have paid the entire stamp duty. Why will you be exempted here? And neither of these, my lord, pertain to undervaluation, which is, my lord, 47A, which has been invoked by the authority.
As per your, the first observation is something else, which is not in accordance
Yes.
with law. The second is, which they have treated as a copyright, that is not.
That is not a copyright, that is a trademark.
That is a trademark.
And on this basis, my lord, they open the, my lord, valuation exercise again, saying that there is an undervaluation.
So they are not telling that you are not entitled for this. They are
Not really. But, my lord, they are demanding, my lord, now the authority, if I show the appellate authority's order, my lord, now I will just show the orders, two orders. Before that, my lord, let me just complete page 13. Otherwise, my lord, my lord, there is a handwritten, my lord, note just after the, my lord, typed portion at page 13 of the AO. Averments of AG, Government of West Bengal, was that no exemption as assignment was not done under Copyright Act. How they make this? My lord, page 13 of the AO. My lord, I have, my lord, the service copy, I have this. I am saved. If it is not there, I am saved. But it is really a reiteration of what's there in black and white in, my lord, typed form. But really, my lord, these 2 points they say, one is it's not there by way of entry. Two, they say similar instrument, it was, you paid entire stamp duty. Why should you get that exemption now? These are the 2 points. Now, my lord, kindly comes to the authority's order. My lord, the first authority's order, which is at page 140 of the writ petition.
Oh, format.
And lordship will not find any reason why this order has been passed. In continuation of the notice in form so and so under rule 5.1 served on you on so and so blank, you are hereby informed that after careful consideration of the objections raised by you, examining the information report, records and finding of the registering officer, the market of value of the property, which is the subject matter of the instrument, agreement or memorandum so and so, where proper stamp duty is payable on the basis of market value or settlement or transfer of lease by way of assignment, and in respect of which statement in form 1 or form 2 or form 3 or form 4 was furnished before the registering officer, ARA 2 Kolkata, has been determined by me at 9 crore. Why is this determination necessary? Your own officer certified that to be 9 crore based on my set forth value. And I'll show that registration rules, my lord. That certificate which I showed in the, my lord, deed of assignment, that certificate is given as per a rule of the Registration, my lord, Act. I'll show that provision also, my lord. You are hereby directed to pay the sum of rupees blank. My lord, that is, my lord, I don't know, my lord, because they say market value determination is 9 crore, but if at the foot of that page they say stamp duty payable is 54 lakhs. So if there was a deviation or variance in the market value, then based on that deviated market value, I would have been charged the deficit stamp duty. That is not what they are doing. They are again coming to the same figure of 9 crore, but saying that without giving me that exemption, saying that it has to be 54 lakhs.
Their contention, they are not entitled for the exemption.
Exemption. Under what the Stamp Act provides. And reason is it's not entered in the register by the Register of Copyrights.
They are first appellate.
Now there is a, my lord, the first appellate authority's order. Lordship will find at page 151.
Now this is the.
This is the order. This is the only order, my lord. And at the cost of repetition, this cannot be done under 47A.
Still assignment is not done.
No. So I am, my lord, at limbo. That is the reason why, my lord, I was, my lord, insisting that I get a chance here today.
10 years passed.
Yes.
Good. Yes, next.
My lord, the appellate authority's order starts, my lord, at page 151. The covering letter is 150. Kindly comes to 151. Well, I'll not, my lord, place the submissions. Kindly come to 152, which is relevant, my lord. What is their stand? My lord, 152, the third paragraph. Deputy Inspector General. My lord has found.
152.
152, my lord, third paragraph.
Yes.
Deputy Inspector General of Registration, Range 3, Hooghly, in its submission stated that no exemption should be allowed in case of copyright registration in the instant case, and any exemption in that regard is not appropriate. My lord, we really don't know why. And from where does he, my lord, get this, my lord, authority or jurisdiction? It appears that the additional register of assurances had assessed the market value of the property contained in the document of assignment bearing number so and so, which is in question, to the tune of rupees 9 crores. So they are aware that this, my lord, market value determination was proper. The RO realized the necessary registration fees of so and so on the market value of 9 crores, giving remission of stamp duty to the tune of 53,99,700, which was objected by the Accountant General in its audit query, since assignment was not done by entry made under the Copyright Act. Now this, in my respectful submission, is not, my lord, permissible under 47A. And therefore this entire exercise is wholly without jurisdiction.
Yes.
Then audit further noticed that another deed of assignment of copyright was executed and registered between the same parties Vide 311 of 2015. So this is the second time the appellate authority also ignores that 311 is not for assignment of copyright, but it is for assignment of trademark. For consideration of rupees 4 crore on which full stamp duty had been paid by the parties. The fact pointed out by the respondent was also perused. Observation of ARA submitted on verification of all related documents in its compliance report to the AG. Well, this is that report at page 13 of the AO. In document number so and so has also been perused and scrutinized at the end of the appellate authority, which were as such. And my lord kindly turns the page, their finding. My lord, second last paragraph at page 153. Further audit has pointed out that another deed of assignment of copyright was executed and same. Then next para. From all the observations and on verification of all related documents submitted by both the appellant and respondent, it appears that document number 335 in question was not entitled to get benefit of exemption of stamp duty under Article 23. Now, my lord, apropos lordship's query, whether, my lord, an authority after realizing whether it can open. I am not saying it cannot, but if it has to open, it has to follow the procedure which is there under the Stamp Act. You are trying to open this issue by invoking 47A when 47A does not give you that power. 47A is only restricted to cases of undervaluation. From yes, benefit of exemption of stamp duty under Article 23, exemption list of Indian Stamp Act, as the assignment was not done by entry made under the Copyright Act. Again, section 18, which was very rightly and justifiably pointed out in audit para by AG. So government's officer, my lord, again certifying that what the Auditor General or Accountant General has said is correct. Appellant is, next page, appellant is ordered to deposit the deficit amount as stated in its order of Deputy IGR for an amount of so and so within next 2 months of receipt of the order, unless which. So my lord, when I moved the writ petition, I said that they should not take any coercive steps to recover this amount from me.
Okay.
Now, my lord, only the law, my lord, 2 judgments I wish to cite, my lord. One is, my lord, the issue of jurisdiction can be raised at any stage. This is a settled position, my lord, 2012, 4 SCC 307. Only one paragraph I cite, my lord, paragraph 22. Because I am saying 47A could not be invoked. Postal copy level. My lord, paragraph 22, Lordship kindly comes. This is reported in 2012, 4 SCC 307. My lord, para 22. There can be no dispute regarding the settled legal position that conferment of jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by a superior court. And if the court passes order decree having no jurisdiction over the matter, it would amount to a nullity, as the matter goes to the root of the cause. Such an issue can be raised at any belated stage of the proceeding, including appeal or execution. The finding of a court or tribunal becomes irrelevant and unenforceable and inexecutable once the forum is found to have no jurisdiction. Acquiescence of a party equally should not be permitted to defeat the legislative animation. The court cannot derive jurisdiction apart from the statute. So here, my lord, my submission is the authority cannot derive jurisdiction apart from what is provided under the statute. And under the statute, it is only 47A which you have invoked. That does not give you this jurisdiction. One more judgment, my lord. This is, my lord, on 47A, my lord, of the, my lord, Stamp Act, 2009, 14 SCC 716. My lord, the relevant paragraphs, my lord, if lordship kindly takes a note of the paragraphs first. 16, 18, 19, 49, 51 and 53. ये मेरा मार्क किया हुआ है कॉपी में. My lord has 16, my lord. Before the introduction of section 47A in the Stamp Act, there was no provision under the Act empowering the revenue authorities to make an enquiry regarding the valuation of the property conveyed for the purpose of determining the duty chargeable if the registering authorities were of the view that the valuation shown in the document was undervalued. Then, my lord, kindly comes to 18. Pursuant to Himalaya House, several states amended the Stamp Act. The state of UP also introduced an amendment by way of 47A, which has been quoted above. The object underlying 47A of the Stamp Act is to neutralize the effect of undervaluation of immovable property under registered instrument of sale. This is the object. Or exchange or gift or partition or settlement. From a bare perusal of subsection 1 of 47A of the Act, it is clear that if the market value of any property, which is the subject matter of an instrument on which stamp duty is chargeable, as set forth in the instrument, is less than even the minimum value determined in accordance with the rules made under the Act, the registering authority shall request the person to pay the deficit stamp duty and present the instrument again for registration. At the same time,
here they are not telling with regard to they are
not.
the exemption.
Only, my lord, exemption is which they don't have authority.
Whether they are entitled for the exemption or
yes.
Not. Once they have registered, the authority have not taken into consideration. Now the Auditor General has given the 2 point he has taken.
2 point.
Whether that 2 point is
sustainable or not. Now, my lord, on the entry point, I could not, my lord, lay my hands on a, my lord, Supreme Court or a High Court decision, but I have a Copyright Board decision, which I found, my lord, interesting, my lord, if lordship permits. It's not binding on your lordship, but if lordship permits, I just want to place one paragraph, because this clarifies the law according to me. But this is, my lord, a Manupatra edition. Because this entry issue was the subject matter in this proceeding. Kindly comes to, my lord, I have...
That is the only thing.
Yes. My lord, kindly comes to page... My lord, kindly comes to page 24. It's marked, my lord, in hand. Lordship will find page numbers there. Kindly comes to page 24.
Yes.
My lord, there will be, my lord, a sentence after around, my lord, 12 lines from the top. Starting with, he argued that the relevant provisions providing exemption prescribes for making of an entry under the Copyright Act. Lordship has found that. My lord, around 12 lines from the top at page 24.
Yes.
He argued that the relevant provisions providing exemption prescribes for making of an entry under the Copyright Act 1957. Since no entry has been made in the instant case, the documents are not entitled for exemption, and the petitioner is in violation of the provisions of the Indian Stamp Act 1899. In view of that, documents should be seized and sent to the collector of stamps for fixing penalty, etc. It is cardinal principle of interpretation that full effect is to be given to the legislative intention. Legislature, in providing exemption, has laid down a clear policy for exempting conveyances in the nature of assignments under Section 18 of the Copyright Act. Of course, narrative of the relevant provisions of the Copyright Act have not been happily placed, which error can best be placed at the doorstep of the draftsman. For understanding the statutory mandate of making of an entry of assignment or not, the last word lies in the provisions of the Copyright Act 1957. The said act nowhere prescribes for it. That is why, my lord, I said Section 18 does not prescribe for it. Rather, it lays two prescriptions for the same and nothing more. That is, for an assignment of the copyright in any work to be valid, it has to be in writing and duly signed by the assigner or by his duly authorized agent, which is Section 19. At the cost of repetition, we say that the language of the exemption clause under Article 23 can best be attributed to a bad specimen of drafting, and for that reason the words by entry should best be treated as surplusage to be ignored. It is interesting to find that the original entry as given by the then Central Legislature in 1899 reads, assignment of copyright by entry made under the Copyright Act 1847, Section 5. It continues to be so till now. The Copyright Act has been successively repealed and reenacted. Unlike West Bengal, states where this entry has not been amended, the courts, while interpreting this provision, will take recourse to Section 8 of the General Clauses Act 1897 and read Section 18 of the Copyright Act 1957 in substitution. Draftsman's error in the West Bengal amendment can well be gleaned through the extant original provision. Certain other state amendments have made a neat provision in substitution. There is another prescriptive provision in subsection 5 providing that if the period of assignment is not stated, well, this I am not concerned, so up to here. So it's really a surplusage. Yes. Therefore, my lord, on both counts, my lord, their objection should fail. And my lord, these orders of the my lord first authority and the appellate authority cannot be sustained, my lord. And if I am successful, my lord, here, if I succeed here, then my lord, I have to pursue with the my lord registrar to my lord then enter it so that I can enjoy the benefit after 10 years. My lord, those are my submissions. I'll my lord make my submissions in reply as an thank you. Grateful, my lord.
Counsel for the petitioner has concluded his argument. Counsel for the respondent due to paucity of time. Counsel for the respondent could not argue the matter. According case is adjourned. Let the matter appear. कोई देखो 12 बजे का कोई है फिक्स है 12 बजे जनवरी में है भाई देखो तो डेट 22 January.
Fresh in mind, my lord. It's easier.
That's why.
Yes.
22nd January at 12 noon as a specially fixed matter.
Very great.
No adjournment on that day. Yes. 15 बज गया चलो एक मिनट कॉल करो 3 मिनट
I don't know about payment.
for the respondent. 2 बजे क्यों 2 बजे 2 गलती हो गया गलती दो मैटर
Milord, in item number 7, I appear for the petitioner. I'm being led by Mr. Sarkar. And Milord, pleadings are completed, ready for hearing. If a lordship may fix it.
Fix for hearing.
Yes, Lord. Lordship, I'll be.
3 minutes you will complete.
No, Your Lordship, it will not be possible.
How much time will it take?
At least half an hour, Milord. Mr. Deepan Sarkar will be leading me in this matter, Milord.
They have challenged the 13-2 notice on the Surface Act. Lord, we are
out before this court.
Milord,
the Lordship has the determination under Milord hearing matters.
Yes, Your Lordship.
Because now we are suffering an interim order. That is the
SARFAESI.
under the surface.
Yes, your
Yeah.
lordship.
How this
No,
court?
my lord, your lordship has a determination under the group 9 hearing matters. These affidavits are complete. So your lordship had kept this matter as a fixed matter at 3 p.m. 2 p.m.
2 p.m. my lord.
And we are suffering an interim order. For that reason, we are pressing the
Lordship,
for vacating of that interim order.
I'll request your
Because
lordship
on
to
the
keep
last
this matter
occasion,
tomorrow at 2 p.m. my lord.
I'm
Then you would
objecting
be
to that,
able to
lord.
find
If your lordship kindly takes the last order once. So they had wanted to pay the dues. They offered for an OTS settlement. OTS settlement was given in the year 2025. Thereafter they failed to pay they deposited the first installment. They failed to pay the second installment. Thereafter, my lord, we granted another time to pay the dues by depositing the interest portion. They have also failed till 30th of December. Now, my lord, we have cancelled the OTS. Now, my lord, it is for your lordship to vacate the interim order. Here are the writ petition any day subject to my lord's approval. I will not oppose to that.
Lordship.
Vacating is the order.
My lord, kindly keep it tomorrow, my lord. I'm just Mr. Deepan Sarkar is coming, my lordship, and I'm praying for a short pass over then. If your lordship was to take this matter today, my lord, in that case, I'm seeking for a pass.
But it's the SARFAESI, how it can be for
The hearing group 9 hearing your lordship has a yes, lordship has a determination.
Accept the SARFAESI and see the determination.
Determination is
Excluding a matter relating to the SARFAESI.
But your lordship had kept this matter. Your lordship had heard it this matter.
You heard? Might be. Only one date the order was passed.
Yes, your lordship.
Earlier, because I don't think this matter can.
Lordship kindly allow Mr. Mukherjee.
That is subsequent.
Where is it?
He's coming. But this is a hearing matter.
What short consideration? Yes.
But this is a hearing matter. Your lordship has determination love to hear it.
It won't know. But excluding this,
my lord, it specifically states excluding SARFAESI matter. My lord. That is
That's
excluding
in the stage or in the
hearing.
even
the matters, all the matters, motion and hearing.
all matters and hearing.
Including the matter.
All matters, motion and hearing.
Lord, I am run out.
This first line, motion and hearing.
And then hearing of petition. Then I can see.
No, first clause is serious.
I see. Then I can see. That motion get. Now I see. Third, hearing of petition. Irrespective of classification, including application, there are no 2023 or what. That is
Need not to go other court.
Because we have the
We don't have the copy.
that you want to get.
Yes, you can. I'm just
File a writ petition for clarification.
But Lord, yes, Lord, as it.
Now, if we go by first, I am not.
No,
We go by
but
third.
3 takes out, Lord, 3 carves out an exception that way.
That's I'm telling. The 3
Yes.
override the 1.
Lord, hearing of writ petition irrespective of classification, including applications connected thereto 2023 onwards. So, Lord, I'm covered in 3, Lord, that way.
15. 12 baje khali hai. How much time it will take?
Milan half an hour.
Half an
But
hour? Sure.
Millard,
But I have an objection as to Lord extension of the
No,
interim order.
I am fixing on 15th as final hearing, especially fixed matter, because today 3
I understand that.
Millard,
but Lord, they are supposed to pay Lord to the bank.
Why you're not
I'm a
paying?
bank.
Millard,
Lord, about more than
we're
10
still
crores
being
is
new.
even payable.
We're still in talk with the bank, Millard.
There's no,
Like,
we have already
See,
cancelled it.
19 December the court has
yes, your
spoken.
lordship. On the last occasion on which date we had to pay, Millard, we couldn't pay. That is
It is
true,
only
Millard.
money
That is
talks, Lord,
that is
nothing
true,
else will
Millard.
talk. Notice the there now.
My lord, what I'm praying for before your lordship, my lord, kindly keep it on any other day. Until that date, my lord,
No,
that interim
OTS,
order may be
5 lakhs upon receipt of the OTS sanction that paid.
Your lordship will kindly take this letter. Yes. The last one was not, they are supposed to pay 81. That was not.
No, how can I share?
In previous order, it was recorded that they will pay by 31st of December. That has not been paid.
Yes.
And OTS can cancel.
Yes.
They are not entitled to any
Lordship,
further
we are
extension of
still
the
talk.
interim order.
We're still in talk with the bank, my lord. On
There's
2nd
no
of Jan,
talk.
on 2nd of January, my lord, we had a
This is what I have handed over.
communication with the.
I have handed over this letter to my lord. This my client's letter to you.
3011 what you have paid? Second installment 2 crore on honor before 3011 have you paid? No.
No, your lordship.
Then OTS is standing 3011 6.20. Accordingly, in order so and so 81 lakhs
Not even
remittance
paid.
on 3112.
Yes, your lordship.
Not paid.
It ought to have paid, but we couldn't pay
Then
it on
balance
time.
5 crore 39 lakhs by 28.2. Then
But we are trying to pay, but my lord, on time we couldn't pay, my lord. But we are still in talk with the bank, and we are hopeful.
you will pay.
My lord, kindly fix it on tomorrow, my lord. Till tomorrow, kindly give us that.
On the
The
last
matter is
occasion, it was
fixed today
extended
for
only on
hearing.
that.
Learned Counsel for the petition praised for adjournment and paid for extension
I
of
don't have the
interim order.
instruction to send.
Learned Counsel for the bank has raised objection and submits that as per the settlement, a one-time settlement, comma, the petitioner has to pay an amount of rupees 81 lakhs on or before 31/12/2025, but till date the petitioner has not paid the said amount.
My lord,
The balance amount is to be paid. Balance amount of rupees 5 crore 39 lakh is to be remitted by 28th of February 2026. This court finds that in spite of the opportunity given by the bank to the petitioner has not paid rupees 81 lakh by 31st of December 2025, and thus this court is not inclined to extend the interim order.
my lord, kindly for one day, my lord.
The matter appear on 15th of January 2025 as the special fixed matter at 12 noon.
Lordship, agree.
Next.
My lord, I've just got the instruction, my lord. We are ready to pay, my lord. Kindly for 7 days, my lord. Kindly.
You are not going to sell. You are not going to sell. That is.
Pay and come.
My lord, for extension, my lord, for 1 day, my lord, just.
Sorry.
Yes.
My lord, after so many months, my lord, I have got the opportunity because irrespective of hearing, irrespective of classification. My lord, this is KMC relative. My lord, here.
Appellate side. Appellate side.
No, original side.
Original side.
Original side.
Okay, just a minute. Just.
With your lordship's leave, if I may mention one matter.
My lord, first of all, my lord, Happy New Year to you and my lord's family. My lord, my submission would be, my lord, this is, my lord, why I am mentioning this matter. Because, my lord, absolutely, my lord, inclusion of my building, this is the dilapidated one. And it was not, my lord, worthy for habitation. So I have taken a rent and I am residing there. So, my lord, in the affidavit, they have disclosed their inclusion, that is my premises inclusion in the heritage pending list is absolutely illegal. And, my lord, I will take 10 minutes time. My lord, everything is complete. My lord, kindly fix any day because kindly
let
it appear to be mentioned. And, my lord, I have given the notice. My lord, I will take just 10 minutes.
For the other side.
Mr. Alok Ghosh. Sorry. I will inform you. Obliging.
With your lordship's leave, if I may mention, your lordship, this is the matter, your lordship, this is a suit where we are appearing for defendant number 2, your lordship. Your lordship, in this, the plaintiff filed a substitution application where your lordship heard it at length. Only defendant number 2 had to distinct the judgments. If you recall, your lordship, this is the same matter where Mr. Moinak Bose was arguing, yes, your lordship. Yes, your lordship, the
That's
partnership.
resolved.
Yes, yes, yes. So if this matter can be assigned to your lordship.
For the plaintiff whose application was for substitution. On 17th of November 2025, this submission was made before the bench taking up the matter. It was observed by the bench that they do not want to do it before the regular bench. We said that it was not marked as part. We know how hard the hard press this bench is. So we took it upon ourselves and we submitted that we want to do it before the regular bench. Now, after 17th of November, they have now come up before your lordship in 2026, January. So, after 2 years of the death of the defendant number 3, successfully derailed us.
Your lordship, if I may just
Your
submit.
lordship kindly looks at the last order. Kindly sees
Your lordship, if I may submit.
It was directed to mention forthwith.
Your lordship, there.
And I will not know how hard pressed this bench is.
Your lordship,
as much as we would love to do it before your lordship, but I know how
Your lordship, if I may, your lordship, this matter was very well heard by this bench, your lordship, and your lordship, the seniors were there who argued the matter. So, seeing all, your lordship,
How to hear the matter, but how to judge?
your lordship, just the distinction of judgments was left, your lordship. And we can file a written notes, your lordship. We will.
Some judgment is filed. You appeared on other matter.
Your lordship, we will not even argue the matter. We can file written notes, your lordship. With the judgments, we have to only distinct the judgment. But your lordship,
argue the matter.
No,
It's been 4 months which has
Your
passed. After that, this order has been passed. The last order has been passed.
if I may make a submission, your lordship, just a humble submission that we can file a written notes, your lordship. We would not want to trouble your lordship.
We would like to the learned noble judge taking up this matter. The regular bench has not released the matter. It is has only been adjourned. If your lordship kindly looks at the last order, the last order.
With a liberty to mention.
Second page,
It's not part heard.
It's not marked as part heard also. That is
Not part. However, if I may, just one last submission, then I will leave it on to your lordship. Your lordship, I definitely agree that there was no part heard word used. But if we see the line of chain of orders, which I even showed it to the coordinate bench, that the arguments were concluded.
Everything has been done in other matters. There are simultaneously 5 matters are there. Same thing has been done, recorded. Even the court has recorded, extensively heard, but the then the matter was referred by me to the Chief Justice in the regular bench.
Regular bench, yes, my lord. That is
mentioned before. But the file is not here. Mentioned before the regular bench. Mentioned because there is no file.
Try Allah because I know from 3 PM it is
obliged.
Very difficult.
No, obliged, your lordship.
Because unless there is no part head, without the assignment, this court cannot.
Obliged, your lordship.
Part head is not there.
I understand, your lordship, the part heard word is not.
Yes.
Obliged.
Call the matter.
My lord, may I please mention item number 144? I'm on behalf of the plaintiff and I'm being led by Mr. Vishrupacharya. The matter was according to the last order dated 11 December 2025, an interim order was granted till today, 6 January 2026.
You are having the copy of the order?
Yes, your lordship. Kindly extend the said interim order.
Though the matter is listed as item number 144 in the today's list, but it is not possible for this court to take up the matter for hearing. Counsel for the petitioner prays for extension of the interim order in view of the submission made by the counsel for the plaintiff, not petitioner. Interim order is extended till 3rd of February 2026 or until further order, whichever is earlier. Let the matter remain in the list. Next. Number 1. Why to be mentioned?
My lord, last order records, my lord, direction was given on this.
Administration.
to seek instruction, my lord, whether this matter can be kept pending.
Yes, no, my lord, we took possession entire property, my lord. Prior to that, my lord, filing this writ petition, my lord, kindly have a look this, my lord.
No, is my friend arguing the matter, or is he, my lord?
If my lord fixed this any day, my lord, for arguing this.
So you want to argue the matter on merit?
My lord.
So they very well, my lord, I cannot compel. I had shown your lordship the provision of the Estates and Forfeitures Act says that, my lord, if I have a caveatable interest, that is sufficient to, my lord, oppose the proceeding. So, my lord, my PLA proceeding is pending, and over there is an order for status quo to be maintained.
Withdraw and, my lord, own affidavit, my lord, they have no, my lord,
Under duress.
before your lordships, my lord, affidavits, my lord, before affidavits, my lord, kindly, my lord, acts, my lord. I saw before your lordship.
My lord, I have a leader in the matter. If your lordship is hearing the matter, let it.
I appreciate. If suppose tomorrow the PLA is allowed,
Lordship.
what would be the effect? Question is only one. If suppose tomorrow the PLA is allowed, letters of administration is allowed, what would be effect of taking possession?
Lordship.
That is the only question.
That is true.
No, that's why I asked you. But okay, you taken the possession, no problem. Let no assignment or no conveyances be made. Let
Yes.
the PLA be proceeded by
Status quo order is already, my lord, in vogue, in force.
No, my lord, what has happened, my lord? Because, my lord, writ petition, my lord, they have challenged, my lord, 2018 order.
Correct.
My lord, 2018 order, my lord, this is the, my lord, authority passed this order, and, my lord, appellate authority was there. Without appellate authority, my lord,
That's why I'm telling. That's why I'm telling. Okay, you're taken. I am not setting aside your order.
My lord.
I only pass that. Okay, whatever the action that may be kept in abeyance till the decision is taken, and this writ petition be signed till the disposal of the PLA. That's I wanted, because suppose I dismiss the writ application, and tomorrow he will get the order in the PLA. What would the sequence?
Yes.
What would be effect?
Because, my lord, their predecessor, my lord, filed 2 PLA case, and, my lord, their affidavits, my lord, own affidavits, my lord, they withdraw the PLA case. My lord.
Correct. That is the matter of the PLA. Whether the
Yes, I'm
the
grateful.
testamentary court can allow or not. This court cannot decide with regard to the testamentary whether it's entitled for.
The difficulty is this, my lord, the threshold issue.
In the writ petition, this court cannot
My
decide
lord, that is
with
that
regard to
is
the
true, my
letters of
lord.
administration.
My
This
lord.
court only say whether okay. That's why I'm telling. If today I decide this, and tomorrow and after the dismissal of the writ petition, you conveyed the property to third party, and tomorrow he will get the probate.
That's why, my lord, previous occasion, my lord, learned, my lord, single judge, my lord, intervene to learned advocate general. My lord, kindly keep it pending, my lord, 1 week or 2 weeks, my lord. I will, my lord.
Otherwise, tell the advocate general to appear before this court. I will convene this. Let or take the decision, because you are taken. I am not going into only kept in abeyance till that. See to that, because if see the future.
No, my lord, I understand, but my lord, as per my lord, government notification act itself, my lord, he has no locus to challenge this authority order without, my lord, paper and appeal. Appeal, my lord, 2018 order.
Okay, then I am fixing a date.
My lord, kindly fix.
As your lordship
fix
please.
the date, my lord, and my lord.
कब होगा? कोई डेट है?
আমি বলি।
By an order dated 16 December 2025, this court has directed the respondent to take instruction whether the impugn order can be remained kept in abeyance till the disposal of the proceeding initiated by the petitioner for grant of letters of administration. Today, when the matter is taken of a reading, Common Learned Council appearing for the estate has handed over the order dated 31st of January 2023 and submits that the authorities have already taken possession of the property in question. Considering the above, this court finds that the writ petition is to be disposed of on merit after hearing the parties. Let the matter appear on 19th February at 3 p.m.
Very well. I'm grateful.
Give me a partner.
I'm grateful.
You want to carry all this thing whenever I will go.
Extremely grateful.
Next.
Please, your lordship, my lord.
There was direction to file affidavits, my lord. I am for the private respondent.
Lord, no, my lord, that period has expired long time back. 4, 6 and 7K.
May I file the affidavits, my lord?
Who is
Affidavit in opposition directly filed by order till date respondent number 5 you are appearing for?
No, my lord, they may appear first time. The matter has been pending for 2 years.
We are appearing for?
I am for 5,
5, 9, 10, 11.
5, 9, 10, 11. May I file my affidavits, my lord?
Yes, Mr. Mukherjee, how are you? Where are you? You are not staying in this court.
Lord, he is the only person who is from day one of this government. From day one till today.
That is the biggest.
And he appears in all courts for the government, protecting.
Except 25.
জজ সাহেবের কত দুঃখ দেখো তোমার জন্য।
Except 25.
Lord, I tell you, lordship, what is the issue? Then I leave it to my lord. I leave it to your lordship's kind consideration. What is the issue? I tell you, Lord, I lost my daughter. Lord, me and my wife, we went for IVF. Lord, we went for IVF. Lord, on the third attempt, we became successful. A girl child was born. When the girl child was about 3.5 years, she was diagnosed with cancer. Now, Lord, bone marrow transplantation was the only treatment available. Lord, we were under impression how the bone marrow transplantation is done. Lord, I have inquired from my client that if the DNA matches, from them the bone marrow can be taken. So we are the parents, we went for DNA testing. Lord, there was no match found.
Naturally.
No, Lord, IVF, it is not natural. IVF, it is the, Lord, it should be more natural that it will match. Because in IVF, what happens, Lord, the sperm and the eggs are taken, it is fertilized outside and then put inside the uterus.
Correct.
So it will be my baby. We found that the DNA is not matching. The IVF center has done this. Lord, we went to them. We told them that please supply us how this has happened. They give us some cock and bull story. We told them that look, to save our child, the only system is that you have to disclose the details of the biological parents. But they did not disclose. They disclose only the details of the biological mother, not the biological father. Lord, the biological mother we contacted, she came, she gave her bone marrow, but with only one bone marrow, the transplantation was not successful. I lost my daughter. They did not disclose the name. I went to the West Bengal Clinical Establishment Commission. The Clinical Establishment Commission hold them guilty. Imposes a fine of 5 lakhs and let them go scot-free. That is under challenge before your lordships. We prayed for closure of this establishment. Lord, in IVF, what happens? Like a normal delivery, normal consumption. Now, Lord, the DNA will automatically match because it is my child. Unless they kept us in dark. And my lord, they have taken the eggs and the sperm from some outsider.
That's why I'm telling the sperm is of the same
No,
spouse or
different. Without our information. That's a crime under the statute.
No, you went on the IVF under the same with the same spouse or the outside?
No, with the same spouse. Me and my wife.
With the same spouse.
I am the father of the child.
That's what I'm telling.
Yes. I went myself.
Right.
No. Lord, had it been a case that we agreed for a donor, then that would have been the end of the case.
Correct. That's what I'm telling. That's why I told you.
No donor. Without our knowledge, they took the, Lord, this is a scam going on in Calcutta. There are IVF centers like mushrooms, several IVF centers, maybe in Calcutta, maybe more than 500. They do this. There are sperm donors, egg donors. They fool the, Lord, infertile couples. And this is the result. Lord, I would have understood when I got to know that the DNA is mismatching.
What's the age of the child?
The child is dead. See, I have lost her.
What was the age at that time?
At the age of 5 years. At the age of 5 years, I lost her. At the age of 3.5, she was diagnosed with cancer. I took her to all parts of the world. Only a bone marrow transplantation could have saved.
they gave us the name of the donor of the egg, but kindly take the impugned order once.
When the authorities came to know, there is no
Kindly see the authorities order. That is my best case.
there's no recommendation for criminal investigations.
Lord, the authorities order is my best case, page 75. It's my best case. Kindly see what the authority says. Just I'll place this order, then Lord. No, chup karo. Allow me to place this order, page 76, volume 1.
Yes, I'm there.
What is that, page 76? The complainant, Mr. Rahul Kothari, was married to Gunjan Kothari. Since they did not have any issue out of the wedlock, they approached Institute of Human Reproduction for IVF procedure. First two procedures failed, however, the third one succeeded, and the lady conceived a girl child, Isha Kothari. The entire procedure was done by Dr. Emil Goenka, who is no more. Isha was born on January 21, 2019. Soon after her birth, Isha had severe illness, and after a prolonged illness, Isha was diagnosed with BCP ALL, a form of blood cancer. Despite prolonged treatment in carcinoma, the doctors could not cure the disease, and the treating team ultimately decided to undergo HLA typing, which revealed no genetic match between Isha and the couple, indicating mix-up during the IVF transfer. Unfortunately, despite immense effort, the treating team Isha breathed her last at the age of 4 years on March 3, 2023. The couple then started the fight justice for Isha. According to them, due to mix-up of the embryo at the IVF center, the child got infected. That resulted in ultimate tragic death of the young girl at the tender age of 4 years. Serious allegations were had as we find from the records. But kindly come to the expert opinion now. Kindly come to expert opinion, page 79. Page 79. There are two doctors' opinion taken, Dr. Runa Bal and Dr. Moitri Banerjee. Kindly come to page 80. Dr. Moitri Banerjee's opinion. Our esteemed member, Dr. Moitri Banerjee, has also given her opinion that is quoted below. This seems to be a case of institutional malpractice where embryo donation was done using gametes that did not generate from the parents. Gunjan and Rahul Kothari were being treated for infertility at IHR. They had 2 unsuccessful IVF attempts in 2017. The third attempt in May 2018 was successful, and baby Isha was born. The baby tragically developed B-cell Prasuker Swanso leukemia, required bone marrow transplantation as a last recourse of medical management. Her high-resolution HLA typing did not match her parents. The couple approached IHR for clarification and crucial genetic information of the biological parents from Isha's medical management. The biological father genetic information was not revealed by the IHR. Bone marrow transplantation from biological mother was done but was unsuccessful, and the baby Isha sadly succumbed. The key question that arises are follows. There are clear national guidelines for accreditation, supervision, and regulation of art clinics in India set up by ICMR in 2005. Clause 3.2.5 states no treatment should be given without the written consent of the couple. There is no husband signature in the consent form of IHR. That's their observation. 3.2.7 states that no woman should be treated within gametes or with embryo derived from the gametes from more than one man or woman during any one treatment cycle. This has clearly been violated by IHR, as all boxes in the consent form, including anonymous sperm, anonymous oocytes, self-sperm, self-oocytes are ticked in clause 3.5.15, which states that when DNA fingerprinting technology becomes commercially viable, the art clinic may offer the couple a DNA fingerprinting of the donor without revealing his or her identity. This was refused despite urgent medical requirement. In clause 3.5.18, semen from 2 individuals must never be mixed before use under any circumstances was clearly not followed. 3.5.22 required that the consent on the consent form must be a true informed consent witnessed by a person who is in no way associated with the clinic. This is no signature of the witness of the counselor. Clause 3.1.2 states that children born through the use of donor gametes and their adopted parents shall have a right to available medical and genetic information about the genetic parents that may be relevant to a child health. This was clearly required in a particular instance, but was not revealed by IHR. In conclusion, it is obvious that certain key clauses of the national guidelines were disregarded during the treatment of the couple Rahul and Gunjan Kothari. These intentional lapses, not page 82, these intentional lapses were unlawful and may have contributed to the unfortunate death of baby Isha. That's the expert opinion. Then what is the view?
But the problem is, kindly come to a prayer A.
Prayer A, my lord.
Prayer A. Why you want to setting aside?
Because, my lord, they have only, there is no order, closure of the institute.
Closure of the institute, but you could have been money. If it's satisfied, what remains?
My lord. Prayer.
Nothing remains.
Acha. Prayer A, let me see prayer A, my lord.
See prayer A.
My lord, kindly give me a minute. Past setting aside the order dated, passed by resolution, remain namas directing cancellation. My lord, kindly see prayer B. Prayer B, I have prayed for. Lord, the observation, the cancellation is of the observation. The observation at page 82. Kindly come back to 82 once.
Totally. That's why I came to the prayer portion.
Yes. After the expert opinion, could the council come back, render this view? Kindly come to page 82 once. Our view. দাঁড়ান এত তাড়ার কি আছে
So who is appearing? You are appearing for?
There are certain restrictions but we are having certain limitations. But the license issuing authority, we are not there. And we who is the license issuing authority?
But the commission cannot recommend. Commission cannot recommend. Commission cannot recommend for the criminal investigation and
Section 33. Now, who are you appearing? For the 4, 6 and 7 থেকে yes এটা 4, 6 and 7 কে জিজ্ঞাসা করছি why do you become silent when you come before the
will not find.
Why do you become silent?
And you are appearing for?
4, 6 and 7.
কে এটা কি 4, 6 and 7 টা কে
দীপক গোয়েল
তুই কার হয়ে
5, 9, 11, 10.
এরা তো তোরই লোক
5, 9, 10, 11.
Lord, 4, 6 and 7 is a part of 5.
5, 9,
5 is the institute. No, my lord, the period has over. They cannot. Yes.
4, 6 and 7, your lordship can look to the cost side debits. For one. 4 is at Assam. 5 is at Assam. 7 is at Assam. I have no objection. They cannot produce any piece of paper showing that he has my signature. The incident is unfortunate. There is no doubt about that. I do not have any connection with that treatment.
Get the order.
I do not know anything about this. But the first time I am looking into this.
So you are appearing for the 4, 5, 6 and 7.
6 and 7.
5 not.
No, not 5.
I am
4, 6
5,
and
9, 10, 11.
4, 5,
5, 9, 10, 11. My affidavit is ready.
Lord, I tell you.
File the affidavit.
Lord,
5, 9, 10, 11 you are appearing. And Mr. You are appearing for the state.
state has perhaps, Lord, 5.
1 and 2. 1 and 2. So you are appearing. You are appearing 1.
Lord, 5 is the.
So all are appearing.
No, my lord is at the cost title. 5 is the institute, which is represented by Mr. Basu. 5, 10, 11, he is being represented. 6 and 7 were the erstwhile director of 5. My lord, may I say this, my lord? Perhaps none of us are judging. Neither I am judging, neither he is judging. Your lordship would be judging. He was served with a copy earlier. He did not appear. That was his choice. Now at the hearing stage, he cannot get an opportunity. If there is nothing, now order will be passed against him. Lord, the affidavits are on record. My lord, I will beseech your lordship, give us a time on a particular day when we will finish our submissions.
Section 31 liability.
No, my lord. No, my lord, I strongly oppose that. No.
Why you not appeared earlier?
Yes.
Filed a the matter did not come up, did not
Oh, so
taken up in the meantime.
there was an order passed.
When you appeared?
Yes, order
When
gulo
you
bar
appeared?
korna. Sompa order gulo dao na.
When you appeared?
Yes. কবে ভোকালতনামা ফাইল করেছে দেখো
After the last order was passed, they know he appeared.
So you could have been gone through the earlier orders. There is a direction.
Yes. It was for all the respondents. এরকম হলে তো যখন তো
We need to read certain facts before
And state will not file, you will also not file any affidavit. You will file affidavit. Okay, you give the copy to the state.
That I'll give to Mr. Mukherjee.
You do one thing, I am allowing them to file affidavit. How soon you will file? You are filing today, you will file reply.
Reply file হয়ে গেছে তো?
File.
We are filing a reply to this.
So you will not file any affidavit.
ওটা কি? ওটা কি?
And state will also not file any affidavit. So, to 2 weeks, and how soon you will file?
1 week.
Hey, consent.
Milord, as a last chance, Milord.
That's why I am fixing a special fix.
Yes, Milord, I'm so grateful. Specially fix করছে তো। আবার কি হবে? কি হলো ওখানে? ছিল
3:30 कर देंगे कब है 10 February 10th February I am fixing at 3:30 at 3:30
হয়ে যায় ডেট আবার
Counsel for the respondent number 5, 10, 9, 11.
5, 9, 10, 11, my
5, 9, 10, 11 filed affidavit in opposition after serving the copy to the London Counsel for the petitioner.
And we have also filed a reply.
Petitioner has filed the reply. Let the same be kept with the record. Learned Counsel appearing for the respondent number 4, 6, and 7. Praise for extension of time to file affidavit. For the interest of justice, time to file affidavit in opposition extended for a period of 2 weeks from date. Reply, if any, there to be filed within a week thereafter. Full stop. It is made clear that no further opportunity shall be granted for filing affidavit by the respondent number 4, 5, 4, 6, 7.
পাগলামি করছিস কেন?
আমার দুটো কপি আমি এখনই হাতে হাতে দিয়ে দেবো।
The counsel for the respondent number 1 and 2 submit that they will not use any affidavit.
রিসিভ করলাম না সচিবরা।
In view of the above, let the matter appear on 10th of February 2026 at 3:30 p.m. as a specially fixed matter.
রিসিভ করলাম না কিন্তু।
But although this is not connected, I came across 2-3 more couples not related to the institute, not related to this institute. They are also facing the same problem. This
That's
is the
why
norm now.
In the writ petition, in
Yes.
the appellate side, every day 1 or the 2 application is coming. So
Hmm.
I am also worrying about this.
My lord, I will
Today
pray for an
only-
inquiry, overall inquiry.
After 45 or 2 months, 1 order only I passed. I am worrying about this only.
Yes, this is now a business. Unsuccessful couples, they are coming. Now they, in order to give them a gift, they are bringing some outsiders, getting the sperm and the eggs, give them a baby. Now, after some time, if this
There
problem
are rules,
comes,
but they are not following. What can be done?
then your lordship will not take some steps. That is only we are praying.
Grateful.
একটা কপি দিয়ে দেন না তপনদাকে দিয়ে দেন।
একটা কপি দিয়েছিলাম আর 3টে দিয়ে দিলাম। ঠিক আছে?
नहीं है कोई.
My lord, I appear for the petitioner. We had completed our submissions, my lord. This is relating to that, the shares and stocks, my lord, that were put in by the banks, my lord.
Yes.
My lord, yes, Mr. Banerjee.
আমার তো শেষ হয়নি. Who will start?
Miss, today you are looking very happy.
Mr. Jishnu Chaudhary. Where is Mr. Chaudhary? Or Mr. Bachao, you will start. Who will start?
And if there is no one else, I'll tell your lordship. Mine is probably the shortest submission in this case because I am possibly the only defendant against whom he has no cause of action really. I'll show that. If there is no, I'll tell your lordship the difficulty in me making so. I'll make my submissions, but then your lordship will have to give me a chance 5 or 10 minutes, not after they make their submissions, because some of the defendants may make allegations against me.
That's
That's
why who is main is the
Main is Mr. Chaudhary.
Main is Mr.
Chaudhary.
Chaudhary.
Where is he?
If he's not there, my lord, I'll take up your lordship's time.
Mr. Chaudhary is not available today. Subject to what falls from your lordship, if Mr. Bachawat wants to argue, he can argue. Lordship, I will also indicate.
Because again, allegation and all these things. That
Yes, your lordship, that is the precise thing. In fact, if your lordship kindly appreciates this, all allegations in the end are directed towards
Correct,
me.
that's why.
So if your lordship allows me to address at the last, I'll be able to deal with all the allegations all at once. So subject to what falls from your
Very
lordship.
skillfully
It
put.
is better you accept all these things, that the matter can be discussed. Shortcut method. Yes. Mr. Shah, you are appearing for?
I am for the NSDL, but I have very little to say.
But he's got a lot of useful things to say, which can be done in 1 minute. So he can, but he can earn his fees and go away after that.
One of the tests of whether the plaintiff has a strong prima facie case is when the defendants can't decide who is done.
But when the plaintiff says that he has a case only because defendants are
Defendants, yeah. So,
but I can start off if it comes to that. Not I can, because it seems no one else is willing. So your lordship will not forgive me if I take a little longer than I might otherwise, but it's better that not I do it. And please bear it in mind, if required, give me 10 minutes, although I have no right of reply, but not till the others finish their submissions, give me that. So the long and short of it is this. There's
you
a
are
company.
appearing for?
I appear for the respondent number 5.
Yes.
Now, it's in the petition.
Yes.
Now, just to remind your lordship of the case in a few sentences, the plaintiff's case is that he is someone who has been investing in stocks and shares to the respondent number 1. The respondent number 1 is a broker. Now, the broker pledged not the shares of the customer, which with HDFC Bank, HDFC Bank took these pledged shares, sold them, and recovered the money due from the respondent number 1. So my learned friend's contention is that is wrongful, illegal. HDFC Bank and respondent number 1 are liable. This could not have been done. This is one part of the argument. The second part of the argument is, look, the respondent numbers 2 to 8 or whatever are all people who are in charge and control of the respondent number 1. And therefore, they as individual shareholders, directors, are also individually liable. These are really the two limbs of his submission that I could see. Now, but as far as I am concerned, my learned friend, or before that, not before what he has specifically said against me, the more important thing is what was his case. So he says there is a SEBI order, or there is a series of SEBI orders. Under those SEBI orders, respondent numbers 2 to 4 have been found to be the people in charge of respondent number 1, and they've been found guilty of wrongdoing. Therefore, admittedly, he has suffered loss damage. Admittedly, there has been some wrongdoing. Because there is wrongdoing, therefore, not the suit. Now, the frame of his suit is this. He says that 9 crores worth of his securities have been sold, or his pledged shares have been sold. Out of 9 crores, SEBI has given him compensation, or the stock exchange has given him compensation to the extent of 25 lakhs. So, his claim really is 8 crores 75, but he has inflated it and claimed 29 crores total by way of damages. Then he has gone and got an ex parte injunction. That ex parte injunction is directed not against the people who've been found guilty of wrongdoing, but against the whole world. And that too, not for 29 crores, for which there is no basis. Now, as far as I'm concerned, admittedly, and this is the admitted position, he did not comply with the provisions of Order 39. No service was made within the permitted period or long thereafter. That's the admitted position. So, interim order, forgetting whether there is cause of action or not, on this technical point itself, it should go. Second thing, your lordship will also consider, while considering the grant of injunction against bank account, is most of his claim sounds in damages. Whether a claim in damages can be secured by way of such an order. And as far as I'm concerned, he has no case against me. That's what I will show your lordship. But this is it. So, firstly, what are the allegations against me? Now, as far as allegations against me are concerned,
please have a look at his petition once, my lord. I won't trouble your lordship too long with the petition, but if your lordship sees para 2 of the petition. Lord, if I may place just that.
Yes.
The respondent number 1 is a share and stockbroker registered with the respondent number 12. The respondent numbers 2, 3, 4 are the present directors.
Yes.
So, Lord, I am not a present director. This appears from his petition itself. The respondent numbers 5, 6, 7 are erstwhile directors of the respondent number 1. So, I am a erstwhile director. How a not erstwhile director can be made liable, Lord, is something he'll have to show. Then, Lord, more important, the respondent number 1 was at all material times and still appears to be controlled and managed by the family of the respondent number 5. So, my lord, on the basis of this appears to be, there is no positive statement saying that I am in control. Appears to be. Now, here I'll show your lordship, my lord, when I show your lordship, 1, my lord, I ceased to be a director long ago. Number 2, I ceased to be a shareholder also long ago. Now, if I am not a shareholder or not a director, but how can he then say that I am controlling and managing it at all? The respondent number 5 has been and still is in control of the said family. Lord, I don't know what that means. Respondent number 5 was and still is in control of the said family. And though having resigned from directorship in the circumstances mentioned below, continues to hold substantial shares in the respondent number 1 is not patently incorrect. I'll show your lordship the records of the MC. And to control and manage the BMA group of companies, including the respondent number 1 through his associates and other entities, etc. So there's another group of companies I have it, that's mine. Now, my lord, this connection with the respondent number 1 and respondent numbers 2 to 4 and myself is absurd. Please come to the cause title, my lord. Lord, please see who the respondent, that first set of respondents is, my lord. Really speaking, this is a company where, my lord, the shareholding is owned by the Bhattars.
Yes.
And I am, my lord, Agarwal. Now, there is no relationship between us. So this family, my lord, they belong to the same family or controlled through family, my lord, doesn't make any sense. Now, the fact of the matter is, and this is what I'll show your lordship from my affidavit, but I came in, Lord, as an investor into the company. In order to, Lord, protect this investor, this investment that I made, Lord, I put in some, Lord, directors in the company. Lord, in 2018, and this is before, Lord, this wrongdoing of pledge shares happened. It's one thing if I was there when it had happened. In 2018, Lord, we resigned as directors and we sold our entire shareholding, and went away. Now, given this, Lord, to drag in erstwhile directors, Lord, let us not take this to an absurdity. Lord, if I was a director in 2000, could he have caught me? If I was a director in 2010, could he have caught me? Now, I have resigned and gone in 2018. Admittedly, Lord, all of this wrongdoing happened after that. Now, can I be made liable for that is the question. My learned friend has not cited any authority at all. At all. Now,
yes.
How an erstwhile director can be made liable, Lord, no authority has been shown.
Yes.
So, Lord, I take it that his case must be premised on the basis that I'm a shareholder.
Yes.
That is the only basis. Now, I'll show your lordship from the records that all my shares were transferred. So, I'm also a erstwhile shareholder. So, Lord, will every erstwhile shareholder and every erstwhile director be made liable? Lord, it sounds a little absurd to me.
My companies are in negative.
One second. Now, one second. Don't divert from here. So, Lord, number 1, I am not a shareholder. Number 2, I am not a director.
Yes.
Number 3, I was not so at the time of the wrongdoing. Now, Lord, please remember another major factor. According to his case in the petition, he started dealings with the defendant number 1 in 2017, not in 2015 or 14 or 12. So at the time when he comes in, Lord, it is just about before the time when I go out. Now, therefore, my Lord, to say this, and now another thing which I have said in the affidavit, which is not disputed, is I have never had any personal dealing with him. I've never met him. It's not disputed. So, my Lord, now please remember, therefore, his case rests on this small little footing that I was in the past a director of the company and a shareholder. Now, directorship, like I've said, he showed nothing. Now, coming to shareholding, he says, I am a shareholder. And that is an incorrect statement that I'll show you, Lordship.
Yes.
So, Lord, this is the small compass around which it has been not framed. Now, in my opposition, I put in all these documents showing that, look, I've ceased to be a director, I've ceased to be a shareholder, and all of that. So, in answer in the reply, he then comes up with one document. One document, and I'll show you, Lordship, those are the contract notes issued by the company on pre-printed letterheads on which my name is printed, Lord, in 2020. So, Lord, the company continued with not using the old not printed formats, and it's there. That does not make me part of the company. Why? Now, in relation to all these complaints that he has filed, he's filed not complaints in different places. SEBI actually directed a forensic audit.
Correct.
SEBI filed an affidavit before the Gujarat High Court in a writ proceeding filed, saying that I am not culpable. It is respondent numbers 1, 2, 3 who are culpable. Not just that, in the SEBI orders, your Lordship will find, after the forensic audit which was directed against me, we were asked to appear and we gave them documents and everything, and they are satisfied that I had nothing. So, Lord, SEBI has found no wrongdoing against me. Now, given that, not the other principal leg of his argument, which was the legal argument, not that also falls to the ground. He relied on the SEBI Act. He relied on not section 27 of the SEBI Act. If I may just hand it up to your Lordship. But this is how he's pulling his cause of action. Very well. Yes. But if I may hand up, your Lordship has a copy. But if your Lordship takes 27, where a contravention of any of the provisions of this Act or any rule, regulation, direction, or order made thereunder has been committed by a company. Every person who at the time the contravention was in charge of and was responsible to the company for the conduct of the business, as well as the company shall be deemed to be guilty, etc.
Correct.
In other words, not vicarious liability of the officers of the company.
Yes.
Now, Lord, I give a very simple answer to this. Lord, I'll deal with it in more detail. But simple thing is, first, Lord, if there is found to be an offence of under the Act by me, here, my Lord, I've been found to be not guilty at all by SEBI. That's number one. Number two, my Lord, he has to then show that I was in charge of and responsible to the company for the conduct of the business. And that, my Lord, he cannot do once I show that I'm not a shareholder or a director.
Now, that's why he is telling that it is 2017. You have been came out on 2018. About
Yes,
one year.
2018. But 2019 is when the pledge shares, his cause of action is arising out of sale of pledge shares by HDFC Bank. That's happened in 2019, 20, and so on. I was not there that time at all.
Okay.
And Lord, your Lordship will find, when I show the orders, Lord, SEBI has found that I'm not responsible for any of these unauthorized acts.
Yes.
The jump in pledge, they noted the final audit was in December 2018.
Not as far as my client was concerned, my learned friend has made submissions without showing anything or showing my opposition. The only thing I believe which was shown is at page 447 of the petition. My opposition was not shown. My opposition was not shown. My documents were not shown. His pleadings in the petition were not shown either.
Yes.
But please give me a moment. Yes. Now, my lord, please look at this. Lord, this is the only document which was shown. And, my lord, on top of that form, on the left side, your lordship will find authorized signatories. 3 names given: Anubhav Bhattar,
Yes.
Avinash Agarwal, and Shiv Kumar Damani.
Correct.
Now, this is the name which was printed, my lord, right from the beginning. It's a pre-printed form on the contract note. It has always been there. Now, it's clear. Lord, please come to the bottom of that page. If your lordship finds the date 27th of November 2020, when admittedly I was not, my lord, either shareholder or director. How could I remain a, my lord, authorized signatory? And please see, my lord, who signed this document. Madhav Prakash Mohta.
Yes.
So, my lord, to go back to it, my lord, please see on top. Lord, what is this? It's a contract note form AA. So it's a, my lord, format. Contract note issued by members acting for constituents as brokers and agents, owner, member, Bombay Stock Exchange, contract cum bill. And then below that, annexure form 10DB under Rule 20AB. So, my lord, it's a format. When I was there, this is what was there, and it has continued.
Yes.
I can't be, my lord, faulted because the others have not bothered to have new, my lord, contract notes printed. So, my lord, this is the only document which was shown.
Yes.
I'll deal with this. Now, my lord, please take my opposition, my lord. My lord, of defendant number 5.
Performed by Avinash Agarwal.
That's your question, bro.
Yes.
Yeah, I think so. Give me the hard copy, it'll be easier. But please take para 11A at page 14 first, my lord. Lord, before that, Lord, the maintainability points, I'll not deal with that, Lord. I'll argue the technical points later. First, Lord, the factual position. Lord, if I may read from here, I am not a director, shareholder, nor promoter of the Respond Number 1 company as on date, and have no relationship whatsoever with the company. Even previously, I was never involved in the day-to-day management of the Respond Number 1 and was never in charge of the conduct and business or operation of the Respond Number 1. I have been and continue to be engaged in the business of manufacture of steel. I have no experience in securities market or in the business of security broking carried on by Respond Number 1 and was therefore have never been actively involved in the stock broking business. My role in the Respond Number 1 company was extremely limited and was principally that of an investor who had invested money capital in the Respond Number 1. I resigned as a director of the Respond Number 1 in 2018. In 2018, Respond Numbers 5 and 6 and all their affiliates also sold their shareholding in the Respond company and completely exited from the company and ceased to have any link in it. Then, my lord, B. From the inception of the Respond Number 1 and all throughout, the entire transaction, business and operation of the Respond Number 1 were handled by the Respond Number 3 and were under the sole and direct supervision, management and control of the Respond Number 3. And Lord, this is, Lord, your lordship can make a note. This is what SEBI has also found. I'll show those. Lord. Respond Number 1's management team, including Respond Number 2 and Respond Number 7, were accustomed to acting on the instructions of the Respond Number 3 and reported to him alone. As per the records of the Respond Number 13 NSE, the Respond Numbers 2 and 3 were the designated director of the Respond Number 1 and responsible for the management and affairs. So, my lord, I was not a designated director. Respond Number 3 always interacted with clients, associates, banks, statutory authorities, etc. on behalf of the Respond Number 1. So, my lord, I am not in any day-to-day activity either. Then let's see. My role was strictly limited and restricted to that as a financial investor who invested money in the Respond number 1. I was never designated director of the Respond number 1. I resigned as a director on 17 December 2018, as would be evident from the records of the Respond number 13. Copy of Form DIR 12 filed with the Register of Companies recording my resignation with effect from 17th September, and the board resolution of the Respond number 1 recording that I had resigned as a director annexed here too and marked A. I'll take your lordship into the annexures later. The designated directors were Respond number 3 and Respond number 2. And hence, it is those persons who would be responsible for the operation and management of the Respond number 1, including maintaining records of the Respond number 1's clients' documents, transaction records, pledging or transfer of client securities. A copy of the letter issued by the Respond number 13 showing that the designated directors of the Respond number 1 were Respond number 3 and 2, and the Respond number 5 was only a non-designated director, is annexed here to and marked B.
So you are the non-designated director?
Yes. And my lord, having this is mandatory. Having designated and non-designated directors are mandatory. Now, my lord, please come to page 55 in this connection.
Yes.
Not every time there's a change of directors or anything, there has to be, the stock exchange has to be informed also. Now, Lord, please see this. Lord, it's written to kind attention Anubhav Bhattar. Subject change in directors. This is with reference to the intimation regarding change in directors of the corporate trading member. Please note for clearance of change in non-designated directors in accordance with SEBI circular has been granted by exchange to BMA Wealth Creators for the changes in directors as mentioned below, and your lordship will find there's an asterisk against the name of Shiv Kumar Damani and Anubhav Bhattar. Now, what is that, my lord? Asterisk just below the box, kindly find. Asterisk says designated director. Now, why was this necessary? That your lordship will find. Lord, item number 2 in that box, Avinash Agarwal, Lord, post facto resignation of NDD and Lord, non-designated director, and Lord, item 4 is Mrigesh Devashri,
NDD.
So, Lord, these were non-designated directors who retired.
Yes.
Or rather, who resigned.
Yes.
And Lord, please see the date of resignation is also, Lord, the effect, third column, 17 September 2018. So, Lord, this is the record of the stock exchange. Now, my learned friend was fully aware of this, but with knowledge that I have ceased to be a director, I was not a designated director, and I am not a shareholder. With full knowledge, my lord, he has dragged me into the proceedings.
Yes.
Now, my lord, this can't be anything other than a pressure tactic. Throw your net wide, you might catch something. Lord, this is it's a pressure tactic, but it's an unfair tactic. And since we are on it, Lord, please also see, Lord, the page before that, Lord, the forms filed with the MCA, Lord, starts at page 50. And your lordship will find at page 51. Lord, under item 17.
17 September.
17 September 2018, Lord, I've gone. So, Lord, all these records show this. Now, why show useless things? Now, Lord, please come back to page 16, Lord.
Yes.
Lord, I read till Lord halfway down that paragraph where Annexure B is. I never directly interacted or dealt with banks, statutory authorities, including respondent numbers 12 to 13, or clients or associates on behalf of the respondent number 1. So I have not had dealings with not this client and had no knowledge of transactions conducted between the respondent number 1 and its bankers, clients, or associates. I do not personally know of any of the petitioners. And to the best of my knowledge, I have never met or interacted with or had any business dealings with them. Now, this has not been denied. That I have never met, interacted, or had any business dealings with them. It's not denied in the reply. I never indulged or started or otherwise approved of any practice of unauthorized pledging of client securities. I was never an active director of the respondent number one, nor was I actively involved in the business. Then, Milord, this is more important, Milord. Milord, disputes arose between us. And Milord, ultimately, your Lordship will see when I leave, Milord, I make sure that they can't use the name of my company either. Milord, that I'll place. Various disputes have arisen between respondent number 5, 6, and the other affiliates on one hand, and respondent number 3 and his affiliates, including 15, 16, 17 on the other. My affiliates and I were completely exited from respondent number 1 as shareholders with effect from 17 September 2018, despite suffering financial loss in the process. And I'll show that also, Milord. But there's a huge debit balance, Milord, against me. I am also a loser. Such fact was also made known to the respondent number 13, the fact that the shareholding of my affiliates and me in respondent number 1 had been reduced to nil with effect from September 17 was also taken on record by the respondent number 13 NSE, as would be evident from a copy of the letter of 4th April 2009 addressed by the respondent number 13 to respondent number 1. That's page 56, Milord. Please see the letter at page 56, Milord. Change in shareholding pattern is the heading of the letter NSE is writing. In accordance with the SEBI circular dated so and so, the exchange has granted free clearance to BMA wealth creators for below given changes in shareholding pattern in Annexure 1. Accordingly, exchange has taken note of the same. You are requested to ensure that there will be no further change in shareholding, etc. Then the next para, dominant promoter Anubhav Bhattar along with relatives support will hold 51% and continue to hold at least 51%, etc. So, Milord, he's always had 51%. Milord, he's always had that. Now, Milord, please turn the page and see, Milord.
Who has written this? Abhinav?
Milord, NSE.
NS.
National Stock Exchange is recording this.
Yes.
Now, Milord, please see what was my shareholding. Milord, dominant promoter group as on 31st March 2018 and Milord thereafter. There are two columns, before 18 and thereafter.
Yes.
Now, please see item 1, Avinash Agarwal. Milord, 5.54% shareholding.
Correct.
And that becomes 0, Milord, next column.
2018 0.
Yes. Now, Milord, defendant number
No, domain
3,
promoter group.
Bhattar, he had 23%.
Yes. And it was increased 25. So this 5% has come here. Because Avinash Agrawal was 5.54.
Milord, there may be various other people, Milord, that I'll do the calculation, tell you. Milord, please see, Milord, Milord, item number 10, Parton Commercial, their shareholding goes up substantial.
Parton, acha, 8 to 48.
So, Milord, this Parton Commercial is another company of his, which has also been found guilty by SEBI or not found to be involved rather. So, then, Milord, please come back to page 17.
Yes.
I'm full-time in the business of manufacturing steel.
Page?
Not page 17, 17 subpara F.
Yes.
I'm engaged full-time in the business of manufacturing steel. The company is managed by me and or other descendants of my late grandfather, Bhuralal Agarwal, are known collectively as BMA Group. Even within the BMA group of companies, different branches of the family of late Bhuramal Agarwal, but Bhuramal Agarwal is the BMA. Different branches of the late Bhuramal Agarwal manage their respective businesses independently. Hence, I am not involved in the management of several companies within the BMA group itself. Respondent numbers 1, 3, and 8 are not members or part of the BMA group. So, Milord, respondent number 1 is not part of my group. At the time when the respondent numbers 5 and 6 and the affiliates were associated shareholders, investors in the respondent number 1, respondent number 3 had been permitted to use BMA in the name of respondent numbers 1 and 8 for limited purposes only. However, after the exit of the respondent 5 and 6 and their affiliates, use of the BMA name by the respondent number 1 and 8 was no longer permitted. Respondent number 5 had issued a notice dated 14th August to the respondent numbers 1 and 8 in this regard, a copy of which is annexed here to and marked D. And that's at page 58. So, Milord, we told them, look, you can't use this. And we gave them a cease and desist notice saying, please stop using BMA as part of your name. That's page 58. That's on page 58, 14th August 2019.
Yes.
And we say very clearly, look, this is ours, and para 8, you are called upon to immediately carry out the following, failing which will take appropriate steps to protect our rights. C is making reference to the BMA group, the founder of BMA group, late Bhuralal Agarwal, various firms, companies were part of the. And C is using my registered trademark. C is making any statements or suggestion that BMA group has ventured into realty sector, etc., etc. That's okay. So what had happened was, not after I left, this BMA was taken out by him, but he was not using it on his website and for various projects and things like that.
Notice to them.
So, that's there in the notice. Then, but please come back to page 18. Then, please come straight away to para I. Now, this is very important because SEBI has also given a finding on this. In July 2019, I learned that my signatures had been forced on personal guarantees and other documents submitted to the respondent number 11 by the respondent number 1 to obtain loans. So, I was also taken for a ride. In fact, some of the documents which had been purported signed on dates when I was not even present in the country, as evident from my passport. Thus, this was immediately brought to the attention of authorities, including the respondent number 11. I crave leave to refer to and produce copies of relevant documents. This, I'll show from the SEBI order itself. Then, subpara J.
No, they have argued that the no document is shown.
My lord?
They have argued no document is shown.
Very well, there's a finding. I already have a finding in my favor. Okay. I have a finding. Then, my lord, please comes to. My lord, I'll deal with the SEBI orders. Then, my lord, I won't read subpara J. This is not SEBI. Gave us notice. After notice, hearing is held. And there was an order first, directing a forensic audit, including against me. That forensic audit was conducted. And then, if your lordship comes to subpara K at page 21.
Yes.
In compliance with SEBI's order of 2nd January, respondent number 13 investigated the role of respondent numbers 5 and 6 and sought certain explanations from 5 and 6. He gave explanations which were sought of me by the respondent number 13. On being satisfied with the explanation and information provided by me, respondent numbers 12 and 13 decided not to take any steps against me in connection with the affairs of the respondent number 1. Please remember, my lord, notice was given to everyone. So, my lord, SEBI decides, my lord, now that nothing comes out against me. I'll show that from the order.
Yes.
So, my lord, 12 and 13 are SEBI and NSE. They've decided, look, I am not involved.
No, that is the only allegation because you have been scot-free by the SEBI.
Right. Now, my lord, that SEBI order can't be set aside by this court in this proceeding.
Correct. No, that's why they have made allegation that you are the director. There was some connection with them, but the SEBI has
there was.
intentionally scot-free you.
Well,
that is the allegation made by them.
Yes. Well, let me not handle this issue. But unfortunately, I don't have that kind of problem where I have spare money and I start investing in companies in the hope that more money will come in. But the rich always hope for more money, so they put their money in here, there, and everywhere. Now, when you do that and you're not involved, obviously you're going to suffer losses in at least one out of them. I may put my money in 10 different baskets. One of those baskets is bound to contain a few rotten eggs. Now, I've suffered huge losses. I'll show.
Mr. Banerjee, we caught hold of this and made a case.
But now, Milord, look at how Milord bad it can get. So, Milord, so there was some rotten egg, not my rotten eggs. I didn't lay them, not it my client. It was the person It was the person who brought him, not, not some friends of his not pulled him to invest in that company also. Not just like I've suffered a loss, he's also suffered a loss. But not look at the sad part of it. But I suffer a loss, it's I think fine for businessmen. Not there will be some losses somewhere down the line. There has to be. I don't believe any not businessman has only had success and success and success in every venture. But what's not more unfortunate is I have been cheated by, let's say, respondent numbers 1, 2, 3. Now, Milord, please look at the spin-off of it. The spin-off it is that, look, I have suffered a loss once. Now he wants me to suffer another loss. What has he done? He's gone and got an injunction against my bank accounts. Now, Milord, this is something which is completely unheard of.
Okay.
Unheard of. And that too, Milord, on a claim for damages. Now, Milord, so Milord, going back to K, in compliance with SEBI order, dated 2nd January, respondent number 13 investigated the roles of 5 and 6 and sought explanations. And then, Milord, on being satisfied, they didn't, Milord, proceed against me. Then, Milord, L. It is pertinent that the forensic audit itself noted the following facts even before explanations were sought for me. That the signatures on certain bank documents purporting to have been my signatures do not match the sample of my signatures, confirming my fear and belief that my signatures had been forged. And B, that during the period financial year 16-17 to 18-19, 3 companies affiliated with the respondent number 5 and 6 had paid a net amount of approximately 54.6 crores to the respondent number 1 and 8. I crave leave to produce and refer to a copy of the relevant documents. Then, Lord M, around this time, one second, just relax. So, Lord, please remember this 54 crores that I've paid is gone. I have suffered that loss, but not now, Lord M. Around this time, a writ petition being SCA number 493 was filed by some client of the respondent number 1 before the Honorable High Court at Gujarat. In the said writ petition, petitioners therein had purported to challenge the alleged inaction on the part of respondent number 12, SEBI, QA, the respondent numbers 5 and 6 herein, and sought for directions to be issued to SEBI in this regard. So, my lord, people had wanted action to be taken against me also because SEBI had kept me out. Respondent numbers 5 and 6 herein were arrayed as respondent numbers 5 and 8 in the writ petition. The following reliefs were sought. So, my lord, your lordship will see from the prayers, I am not reading them all, but action to be taken against me. But one is a direction to the respondent number 2, SEBI, to take similar action and pass similar orders as contained in SEBI interim order against respondent numbers 5 to 8, being respondent numbers 5 and 6 herein also. This is what is sought. Now, my lord, please turn the page. Not subpara N. In the said writ petition, respondent number 12, herein SEBI filed an affidavit, and this is very important. SEBI filed an affidavit dated 10th of August, wherein respondent number 12 is inter alia stated as follows. Sure. We'll show it from there. In this regard, the forensic audit was conducted by the respondent number 3, which is the respondent number 13 here, yes. NSC. This respondent is informed that from the documents made available to the respondent number 3, respondent number 13 here in the course of forensic audit and submissions made by erstwhile directors of respondent number 4, respondent number 1 herein, respondent number 3 did not find any evidence of involvement of the respondent number 5 and the respondent number 8, i.e. the respondent numbers 5 and 6 herein. In unauthorized pledging or misappropriation of client security of the respondent number 4. So, my lord, clear finding by SEBI and stated on affidavit in a court. Then, my lord, as the respondent number 3 did not find any evidence of involvement of the respondent number 5 and 8 in the unauthorized pledging or misappropriation of clients security of the respondent number 4, it has been decided that no further enforcement action from this answering respondent, etc., is necessary. So, there is nothing to show that I was in any way involved. That's the stand that they take. So, my lord, there were no orders against this respondent after this writ petition. Then, my lord, comes subpara P. On 11 January 2023, respondent number 12 issued the final order in the investigation relating to the conduct of the respondent number 1 under section so and so, so and so, so and so. The said order inter alia notes that allegations were purported to have been made against the respondent numbers 5 and 6 herein, but that based on examination of materials available on record, it was decided not to proceed against the respondent numbers 5 and 6, and accordingly, I was not made a notice in the proceeding before the respondent number 12. So I was no longer noticee. Direction was thereafter passed against notices therein, but not against the respondent number 5 and 6. In the said order of 11 January, it has been held that it has specifically also been noted inter alia that the actions of the notices as mentioned therein fall within the definition of fraud as mentioned in not all these sections. Accordingly, appropriate penalties were levied against the notices. Notably, no such finding was arrived at against 5 and 6 since they were not found to be involved in the impugned acts after full completion of the investigative process. Now, again, a question which I throw up here is, there is a specialist body which is being given certain statutory functions to safeguard the interest of customers or people dealing in the stock market. It has a statutory job of investigation and punishment. Now, in this case, a thorough investigation has happened. The authority has decided to punish certain people, and it says there is nothing on the basis of which any further investigation against me or a audit or any punishment is necessary, and it does not proceed against me. Now, my learned friend was then required to show that this finding, which is there, can be overturned by this honorable court. My learned friend has showed no authority for that purpose. But if this cannot be overturned, if these findings remain, and these are findings of fact, if these findings of fact remain today without challenge, and there isn't any, can this suit ever hope to succeed?
Against you?
Yes. As against me. I am concerned only against me. I would be happy if not 1, 2, 3 who have been punished are further punished. But my learned friend has now got the rotten eggs. He can fry it and make a fried egg. It doesn't matter to me.
Now, by drafting the suit, he has kept in mind the bar member of the bar.
Of course, not a member of the bar, not many members of the bar, including Mr. Shah, who has nicely nodded and left. And not everyone has left the baby to me. So, of course, my learned friend has also enjoyed many a day when, well, someone else was holding cudgels over here. There, of course, he may have had no option.
Correct.
So, going back to this, therefore, the fact is, I'm not saying that the suit may not be maintainable, but the fact is, there's a statutory role. A statutory investigation is carried out. Now, that is admittedly not under challenge. Now, if that is not under challenge and that finding of fact doesn't go away, he cannot at all hope to get any relief against me in this suit at least.
Yes.
Now, if he cannot hope to get that relief, can he get interim relief? That interim relief must be in aid of the final relief.
Okay.
Now, please also bear two factors in mind as far as I'm concerned. These factors may not apply to the other defendants. But, number one, if these documents had been showed, or these portions of the SEBI order showed to your lordship, that look, he has been found not to be involved and has gone scot-free after a statutory investigation, would such an order have been passed? It's an ex parte order. It's an order of the greatest good faith. If this had been shown, I'm pretty sure that your lordship would have been inclined to say, let them come. This is factor number one. Factor number two, he chose not to comply with the order of with the requirements of Order 39. Did not serve me admittedly. And I'll show your lordship what the judgments say. But the interim order has to go on that ground alone without not even getting into merits.
Merit of the matter.
Lord, if Lord, my learned friend says after 10 extensions, Lord, the fact that there have been 10 extensions, your Lordship will bear in mind and Lord, direct Lord, costs to be given appropriately. It may have been good for the bar, for whole of the bar, but Lord, please consider, Lord, a litigant has also been forced to come
In the court.
to the court and the counsel fees not involved, heavy counsel fees. So if my learned friend says 10 extensions, but please keep that in mind in deciding whether to not grant costs to my my client or not, because under the Commercial Courts Act, your lordships actually have to now take it into account. Now, look, we'll go to the legal part later. Let's finish with the facts. So, not the juniors are nowadays much more prepared than us, actually, very frankly. They go deep into
That
it.
required.
They're very not this was, your lordship will be surprised, they were ready. They tried to get me ready at perhaps 12:30 or 1 at night, saying that in case others are not there, let's take the chance and argue it. And it requires a lot of perseverance in that winter to try and get me ready at that time of the night and then go home in a scooter.
That is main.
I also benefited from my junior because I had the occasion of being assisted by her at various times of the day. So no problem.
That's why this SEBI matter is with you.
बुझिए
My junior happens to be my wife. So that's why I say that there were more occasions than his juniors had to assist him that my junior had to assist me.
But that mutual collaboration also is extended at home.
Yes.
So therefore, now to go back to this. Right, he is taking objection. She doesn't have to take a scooter back home.
Her scooter
She is there only.
she's
Online.
She doesn't have to take a scooter. She can take the internet.
No, today you'll have to walk home. Today you'll have to walk home. The car is.
With the kind of weight I put it, I have to walk home many days.
Yes.
So, therefore, summarize the facts. I'll just place the SEBI orders thereafter, but I think the SEBI orders are accurately summarized in those paras. Now, therefore, to summarize, number one, I was an investor in the company. Number two, I was never involved in day-to-day affairs. Number three, I was not involved in interactions with clients, bankers, or anyone else. The fact that I have not interacted with him is not disputed.
Yes.
I am someone who has also not suffered loss. That again I will show your lordship. Companies owned by me had not also not dealt with him as a customer for dealing in shares. They have similarly suffered and perhaps for an amount more than he has. That also I'll show your lordship. So, I was not in day-to-day management. Whatever involvement I had with the company ceased in September 2018, completely snapped and went out. Now, my learned friend has to then show how and in what manner I should be held liable for in respect of the unauthorized, so-called unauthorized sale of the pledged shares in 2019.
Yes.
Now, please bear that I would not probably divide this, the time period into three parts. But what happened prior to 2017 can be of no relevance because he came in 2017. He became a customer in 2017, October 2017. Then is the phase between October 2017 and September 2018. My learned friend has to show that I did something in that period, which
you've taken the benefit of.
Either I have taken the benefit or more importantly, that the pledging of shares took place then and the unauthorized sale of shares took place then.
Correct.
If it took not place post 2000, not post September 2018, after my resignation, there can't be any personal involvement. That's for sure. There's no personal involvement. The only thing which would then come in is vicarious liability, which is why, not as a probably a argument of desperation, as a last resort, not Section 27 of the SEBI Act.
Yes.
So, not if my learned friend can at all come in, it must be qua the SEBI Act, Section 27, otherwise out. Now, for that, both under the SEBI Act and otherwise, my learned friend has to show my involvement. And here I say, not SEBI has said that I was not. The statute, because he relies on the SEBI Act, Section 27.
Yes.
So if the statutory investigator under the Act comes to a finding,
So one authority has come to the finding how this court.
not one authority, he relies on Section 27 of the Act.
Correct.
That Act itself says this is the manner in which it is to be decided. That authority has decided. There is no challenge to that finding. Now, can 27 then be relied upon by him?
Okay.
Now, my lord, as far as the orders are concerned, can I take your lordship into the orders? Give me volume, page 220. Again, 220 ka debe na, my lord. Oh, it's 4:30. But I won't be able to finish with the SEBI orders in this short time. I'll do that on the next day, not when.
Come on, Alex.
But is it?
It's fixed tomorrow also.
But it's there tomorrow. But is it possible to take it up half an hour earlier? I believe there's some 3:30 resolution tomorrow. So tomorrow. I leave it to your lordship. Not otherwise, believe it's also there day after. Right? It's there tomorrow and day after. I leave it to your lordship. Not your lordship wants to take it up, fix it a little earlier tomorrow. Not I'm.
Come at 3. Counsel for the respondent has argued at length. Respondent number 5 has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at 3 p.m. Huh? Come tomorrow because my appellate side staff is. But day after tomorrow, under the heading application for withdrawal.